Bismillah, alhamdulillah, salatu wassalamu ala rasulillah wa ala alihi wa sahbihi wa man wala, thumma amma ba'd, to proceed. Inshallah, today we will have the task of going over Mawareeth in about 4.5 hours. So now, what are we going to be able to accomplish here? If you did not have any formal knowledge of Mawareeth, this would be an introduction to the basically science of Mawareeth. There is no way, the science of Mawareeth requires a lot more than 5 hours. I do have about 20 hours online on the science of Mawareeth in English for those of you who may want to refer to it. It's in my YouTube sort of page.
Channel.
It's Sharh al-Umda, the Mawareeth, according to al-Umda, according to the Hanbali Madhab. But usually when you discuss the Mawareeth, there are not that many differences between the Madhab in the science of Mawareeth. There are few differences, and the differences have been pointed out as well. So, you know, my page is not commercial. I don't have any qualms with basically advertising my page because it is not, there is no monetary benefit whatsoever in you visiting it and listening to the Sharh al-Umda on it. So that's one thing. If you have not had any basically exposure before, this is going to be just an introduction. If you have exposure to the science of Mawareeth before, this will be a refresher. How often do we need a refresher for the science of Mawareeth? Every 6 months, I think that if you master Mawareeth, you will need a refresher every 6 months. It is a science that can be easily forgotten. You do not need a refresher on al-Ahwal al-Shakhsiyya or family laws every 6 months. You do not need a refresher on ibadat every 6 months. Mawareeth in particular, it's a science that can be easily forgotten, very easily forgotten. So this will be a refresher for the people who had the chance to master the science before. Inshallah, we will try to make this as interesting as possible. My delivery, everybody knows I'm monotonous. My delivery, you do need to work hard a little bit with me because my monotonous delivery will not stimulate you enough to stay awake unless you are interested in the subject and you work a little bit harder to stay awake with me. So that's one thing that I just needed to tell you at the very outset so that you know what you're up to and what you need to do in the next few hours. Certainly, Yaser Ali, he is an imam from, where is it? Phoenix, and he's also a practicing lawyer, would provide us with the necessary knowledge of application. How do we take this and apply it in our particular circumstances here in America? Because it is important that we are aware of the local laws or the laws of the land so that we are able to basically exercise our deen to our best possible capacity without violating the local laws of the land. And this particular segment of the Dawah or this seminar will be inshallah between 11 and 12:30. And then we will go back to finishing Mawareeth, basically the fiqh of Mawareeth. And afterwards we will have a panel discussion at the end to entertain questions. But inshallah, during the Dawah or during the seminar, we will take your questions and we'll try to make it interactive because it is a dry science and it does need a lot more for people to stay awake listening to Mawareeth, particularly after you have 3 days of 2.5 days, yeah, of listening to lectures of sort of dense subjects. All right, so whenever they talk about Mawareeth, and I'm just going to try to throw something at the beginning to make it a little bit more interesting. So whenever they talk about Mawareeth, they say, he died and he was survived by. he died, and he was survived by, and then they list, the survivors. And then you start to basically work, to solve the problem. So let us basically just let us construct a mas'ala. Mas'ala is like a problem. It's like a scenario. Different scenarios. I'm just going to use mas'ala because it's the word that's usually used in Mawareeth. But just remember that mas'ala means the scenario that we were working with. So let us construct a mas'ala to give us basically, to figure out how we will proceed from here with our discussion. Okay, he died and he was survived by
3 wives.
You don't have to create problems at the very outset. Let's say he was survived by 1 wife. All right. He died and he was survived by 1 wife, okay?
Children? 3 children.
2 daughters.
1 daughter.
Okay. What do you guys want? 1 daughter, 2 daughters?
1 daughter.
1 daughter.
1 sister.
1
1 son.
sister.
And 1 mother. Let's say 1 brother.
1 brother.
2 brothers.
2 brothers. That is a half paternal, right? 2 half paternal brothers. Okay, who else? 1 maternal. 1 maternal what? Brother or sister. Okay. Brother, 1 maternal brother. Okay. What else? You want the mother also?
Grandfather.
1 mother. I mean, you can't have 2 mothers, right?
Grandfather.
What?
Grandfather.
You want to put a grandfather? Let's put a 1 grandfather here. What kind of grandfather?
Father's son.
Maternal, paternal?
Paternal, because the one mother is there. Yeah, mother is there.
You want a paternal grandfather, a father's father. And then we will have to basically be spelling these things out. So we have to say a son's son, a son's daughter, because these things make a difference. Okay. And what else do you need, or do you want to have here?
He did not leave anything.
1 son.
Son. And 1 daughter.
Well, huh?
Grandson.
That's enough. Okay. So we can have the 1 son, and then we can come back to the issue of the because if we talk now about the grandfather, the inheritance of the grandfather, it will not be a good start. It could complicate things for everyone. We will come to it in session 3. So if you put 1 son, okay, so let us say, can we put 1 maternal aunt as well? Let us add 1 maternal aunt. 1 maternal aunt, that is Hatem. Okay, can we put, can we put a non-Muslim father?
Yes.
Okay, let's put a non-Muslim father here.
Is the grandfather still in?
No?
Is the
What?
grandfather still in?
The grandfather? We're just saying that he was survived by. We're not giving him anything yet. We're just saying that he was survived by. He was survived by a grandfather and a non-Muslim father. That's fine. Okay. So This will give us an example. Basically, if we try to figure this out, we will figure out so much already at the outset. Okay, so Muslim, one wife, one non-Muslim father, one daughter, one son, one sister, two brothers, half paternal, one maternal brother, one maternal aunt, one mother, one grandfather. When you look at a mas'ala like this, what are you going to do at the very outset? Huh? Yeah, so أصحاب الفروض will be heirs with designated shares. And al-Dasabat will be residuary heirs. Residuary heirs means what? Residuary, the rest, heirs. So they take everything else after the heirs with designated shares have taken their shares, correct? Yes. But there is something that you look at prior to this. Someone comes to you and tells you he was survived by all those people survived him. Yes? Exactly. Who are the heirs here? Who would be entitled in this mas'ala? Who would be entitled to inheriting in the beginning? So who are the heirs? We will have, and I will put them here because we will need to come back to them very often. Who are the heirs? 15 men and 10 women. 15 men and 10 women. That is including the heirs with designated shares, أصحاب الفروض, and the heirs and the residuary heirs, that is al-Dasabat, who will take the rest. So can someone help me figure out the 15 heirs, 15 males, ten females. Okay, so someone said al-ab. Is this a good start? Yes, it is a good start because you want to start with al-usul, the ancestors. Okay. Al-ab, the father. Okay, and the grandfather. We say the grandfather, وَإِنْ عَلَى, no matter how many generations up. The grandfather, وَإِنْ عَلَى, no matter how many generations up. So this is the grandfather, the great-grandfather, the great-great-great-grandfather, and so on. They're not going to inherit all of them in the presence of each other, but they may inherit if they don't have anybody separating them from the deceased. Okay, so that is 1, 2. Who's this third?
The requirement has to be that they are Muslim, correct?
Well, we will come to this. We're coming to this. We're just trying to figure out who are the heirs now. So son and grandson. Five. Okay. Grandson وإن نزل. Grandson, هذا الابن وإن نزل. Grandson, no matter how many generations down. Grandson, no matter how many generations down. Which grandson? The sons are the grandsons that we're talking about here. Daughters' sons are not. If the grandson is separated from the deceased by a female, he is not an inheriting grandson. Exactly. But if the grandson is separated from the deceased by a female, he's not an inheriting grandson. Okay, so the son and grandson, no matter how many generations down, as long as he's not separated from the deceased by a female. Okay, what else? Number 5. No, you don't go to the Ram now. Yes. Okay, brothers. How many brothers do we have? In the inheriting brothers, we have 3 brothers. We have the full brother, الأخ الشقيق, الأخ لأب, the half paternal brother, the الأخ لأم, the half maternal brother, half maternal. Okay. We're going to come to this, of course, but we need to come to it. Yeah, those are the brothers. Okay, now let's move on. What else do we have? Ibn al-Akh al-Shaqiq, Ibn al-Akh al-Ab. Okay, that is the brothers, the full brother's son, and the full brother, the half paternal brother's son, no matter how many generations down. No matter how many, okay. So that is number 8. I don't want to say nephew. That is why I told you things will be spelled out. We're not going to be saying nephew. Why? It's going to confuse us. So just say the full brother's sons, no matter how many generations down. And then number 9, the half paternal brothers, sons, no matter how many generations down. Okay, number 9. Okay, al-Am al-Shaqiq, yet half paternal, paternal, P. Al-Am al-Shaqiq, the full uncle. Uncle? No. Yes, no, it's not it's not this. The father's father, because uncle is also the khal. Uncle is also the mother's brother. The khal is not with us here. So al-Am is the father's brother, the full brother of the father. Father's full brother. No, you don't say and his son now, because if the father's half paternal brother is here, he blocks Yahjub, the son of the Shaqiq. Yes, but list them بترتيب, in order. List them in order. Okay, so the father's full brother. The father's full brother, and that is, no matter how many generations up. Because it could be also, if we don't have this, we will move to the grandfather's brother. We will move to the great-grandfather's brother. If we don't have the first one, we will move like this. We will go up and move like this, okay? But anyway, now, number 9, the half paternal brothers' sons, Ibn al-Akh al-Ab. Okay, so number 10, the father's full brother. Number 11, I'm just going to have to put number 11 here. This will be the father's half paternal brother. Okay? Wait a second. The father's full brother. Wait a second. Yes, it is. Yes, it's correct. Why not? Al-Am al-Ab. Wait a second. We're coming. We will start with the husband whenever we address a mas'ala. We start with the husband or with the wife. But here, we're just trying to list them. And we're coming to the husband now. So that is number 11. What is number 12?
We don't put
No. No, because الجهة مقدمة على القرب. الجهة الأول. So we will come to this. It's direction, proximity, strength. جهة, قرب, قوة. Direction, we are moving in this direction. We don't move, beyond this direction until we're done with this direction. You don't basically, okay, so what he's saying is, now you have a that's the father's brother, full shaqiq, full brother of the father. He had a son, and there is a half-paternal brother of the father, that is Amma also, half-paternal brother of the father of the deceased, who has or does not have a son. It's not a problem. So you have those three. You have the full paternal, you have the full brother of the deceased, and his son, and you have not the full brother, the full brother of the father of the deceased, the full brother of the father of the deceased. It is important. Uncle would have solved the problem, but uncle will confuse us because, so the full brother of the father of the deceased, his son, and his brother, but not from the same mother, like the deceased and himself, which is the half-paternal brother of the father of the deceased. It's easy, brothers. This is a woman. This is the symbol for the man, the woman. Okay. And they had this man here. Okay. And this man had a son. Okay. This woman, after this man died, went on to marry another man, and had, no, not this way. This man, after this woman died, although usually it would be the opposite, but this man, after this woman died, went and married another woman, right? And he had a son with her. Okay? Who's this? The full brother of this. Who's this? The half-paternal brother of this. This is now the deceased. This is the deceased. Okay? How is this one related to the deceased? His uncle, in other words, his father's full brother. How is this man related to the deceased? His father's half-paternal brother. Now, this father's full paternal brother had a son. This deceased, this man was survived, of course not by his father, because his father would have blocked everybody. He was not survived by his father. He was not survived by his grandfather or any grandfather. He was not survived by brothers of his own, of course not sons, no brothers of his own, no children, sons of his brothers, and so on. So we went to the al-umuma. We went to the paternal uncles. And here he was survived by this man, and this man. Who will inherit the rest? If there is anything extra after people with designated shares, أصحاب الفروض, took their shares, who's going to now inherit the rest? One, the full brother of the father will inherit all the rest. He will block his son, of course, and he will block the half-paternal brother. His half-paternal brother. He will block that as well. Okay. Why are we here? Because we've imagined a scenario where this one is not with us. This one is with us. This one is with us. Who inherits? 2, not 3. Why? He is the son of the full brother of the father of the deceased. Yeah, but we don't look at this. We don't look at this until we're done with the direction. These are abna al-umuma. We don't look at the children of the uncles, paternal uncles, until we're done with the uncles. And then we look at the children of the paternal uncles. And then if you have the children of the paternal uncles, and one of them is first generation, and one of them is second generation, down from the uncle, which one will you take? The first generation, because he's closer to the deceased, and he will block the farther away child of the uncle, or son of the uncle. And that is called what? Proximity, closeness, qurb. Jiha is the first thing, direction. Qurb, closeness to the deceased, is the second thing. So, and then is strength, which is quwwah. Because if you have 2 in the same direction, as close to the deceased as each other, one of them is full and one of them is half. Full brother, half paternal brother. Who blocks who? The full brother blocks the half paternal. This is called quwwah, which is strength. We have to remember this. This is going to be extremely important when we discuss al-asabat, residuary heirs. Jiha, direction. Qurb, proximity. Quwwah, strength. How close you are to the deceased. And I don't want, and I just, we're branching off a little bit. But anyway, father's half paternal brother is going to be with us among the heirs that we will look at. Now, okay, where are we going after this? The sons of the full brothers of the father. This is abna al-umuma, the sons of the full brothers of the father, of the deceased. Huh? 11 in Arabic. Fathers half paternal brother. Al-am li-ab. So it would have been what? If we're talking about the deceased and we wanted to simplify this, we would have said what? The paternal uncle. The paternal uncle. However, the word uncle in English includes who? Includes the paternal and maternal uncles. So in order for us to be precise, we're trying to complicate it and say the father's half paternal brother. Yeah. No, if we were to say it in English, we would say the paternal half uncle or something. No, it needs to be spelled out like this, because this is al-am li-ab. So it needs to be spelled out like this. It is the paternal, half paternal brother of the father of the deceased. The half paternal brother of the father of the deceased is called al-am li-ab. Because he's not full brother, he's half paternal. You have half paternal, half maternal. It is, he's not the full brother. So half is basically غير الشقيق, not شقيق, not full brother. Half maternal. الأخ الأب half paternal. Yes, yes, Sheikh Muhammad. No, I'm going to come to the next one. Number 13 is sons of the half paternal brothers of the father. Half paternal brothers of the father. Number 14. Oh, we're close. Husband. And 15. Emancipator. Okay, al-mu'taq. Emancipator. The person who let us say the deceased was a slave. Someone emancipated him. The deceased was not survived by family members. Then al-mirath bil-wala comes after that, which is inheritance because of allegiance through emancipation. Allegiance, al-wala, through emancipation, by emancipation. Okay, but that is if the deceased was freed and then did not have family to inherit him. Then the person who emancipated him, because he has done him a favor, would inherit him. Okay, these are the 15 men.
What's number 14?
Number 14 is the husband. You know, he's important. He's right there. Husband is number 14. Okay, now the 10 women.
What do you say about the uncle, the paternal uncle? The brother of the father, that's it. Or why do you have to say half?
But, okay, why do I have to say the half?
If we say
Paternal uncle.
means what?
Paternal uncle. Does that separate between the full and the half? No, it doesn't. Yeah, so paternal uncle means what? My father's brother.
Yes.
Which brother? The full brother or the half brother?
Full.
It doesn't tell you.
Paternal uncle would include the full and the half. How do you separate them? You will have to spell it out. Al-am al-shaqiq. How do you say al-am al-shaqiq in English?
Full.
Okay, so this will be the full paternal uncle.
That's okay.
Okay, how do you say al-am al-ab in English?
Yes. Half paternal.
Which half now could be the half maternal?
Half paternal.
No, paternal uncle. This is because he is the am, not the khal.
Yes.
But now I want to say he's not only a paternal uncle. He is half paternal brother of the father, not the full brother of the father. So when I say half paternal uncle, that doesn't do it.
ماشي دكتور ممكن تترجمها بالعربي جنبها.
Okay, so this will be al-ab, al-jad, al-ibn, ibn al-ibn wa in nazal, al-akh al-shaqiq, al-akh li-ab, al-akh li-um, ibn al-akh al-shaqiq, ibn al-akh li-ab, al-am al-shaqiq, al-am li-ab, ibn al-am al-shaqiq, ibn al-am li-ab, al-zawj al-mu'tiq. Okay, the women, 10 females. Okay, mother. Okay. Mother. Grandmother. Which one of them? Maternal. Okay, 3. Grandmother. Which one of them? Paternal. Because she's weaker, and we will see in different madhahib. You know, I'm Hanbali. I'm not trying to be Hanbali on you today, but we'll see in the different madhahib, inshallah. 4. Daughter. Thank you. Daughters of sons. Okay, now, next. Full sister. Thank you. Half paternal. Well, it's easier for women. Half paternal sister. Thank you. Half maternal sister. خالة. ما فيش خالة. Wife. Emancipator. Emancipator. Wallahi, the women didn't give us any trouble here. Okay. Now, why did I write this on this board? Because I'm just going to keep this board for the rest of the seminar. Okay. Why did we go there in the first place? Because we had to spot, at the beginning of the mas'ala, we had to spot who's going to inherit and who's not going to inherit. Out of this list, does the wife inherit? Okay. Does the non-Muslim father inherit? Why? Because now the wife inherits because she is entitled to a designated share, من أصحاب الفروض. This is an important chapter that we will talk about. The non-Muslim father will not inherit. Why? Because unbelief is called mana, hindrance, min mawani' al-irth, one of the hindrances. So there are three hindrances that we may talk about later. That is what? What are the hindrances? اختلاف الدين, different religion, being of different religion, slavery, and murder. Huh? Murder. Yeah. Slavery and murder. Murder of whom? Murder of the deceased. If he murdered someone else, he still inherits. Murder, he still. But murder of the deceased. If you murder someone, you don't inherit from them. This is a deterring punishment, because otherwise people will be, yes, for inheritance. Okay. And now, why is it that slaves will not inherit? Because they are owned. If they inherit, this money goes to the master. It would have better gotten to a relative of the deceased versus going to the master. Okay, but if someone wanted to do a favor, what they should do first is to emancipate, not to pass on money to them, to emancipate them. And there is something called the tadbir, that's emancipation after life, for those who don't have the ability or the will to emancipate during life. But anyway, so this is an important chapter called the mawani' al-irth. The daughter is entitled to a designated share, an important chapter. The son is a asaba, residuary heir, an important chapter that we will go over. All of those are with us. This is not with us. This is with us. This is not with us because of the mawana. Because of the mawana. This is with us because of being entitled to a designated share, an important chapter. Son, asabat, residuary heir, an important chapter. One sister, entitled to a designated share, من أصحاب الفروض, and you will find her here. You will be able to spot her here. Okay, we didn't say full or half, but you're able to spot her here. One brother, or what is it? Two brothers, half paternal. Those are ashab furood, residuary heirs. They are with us. One maternal brother. One maternal brother is with us. You will have to consider him because he is an heir or not. Yes. Has a designated share or not? Yes. Will he inherit in this particular mas'ala? Of course, no. There are too many people that can block him. And that is the chapter of al-Hajb, Bab al-Hajb, the chapter of blockage. Who blocks who? Keep in mind, there is a huge difference between mani', hindrance, and blockage. What is the difference between mani'? What is the difference between this and this? Both of them will not inherit. Both of them will not inherit anything in this particular mas'ala. What is the difference between them?
One will not inherit anyways, yes, and the other one will inherit because of this particular case. Someone is blocking his way.
Okay. No, but what is the more practical difference that we need to be cognizant of? Huh? Elimination? Hajb yani blockage? Okay. Okay. Huh?
The hindrance is present in the person himself, whereas blockage is through an external cause.
All of these are valid differences, but the most important difference that I want you to remember is
the reason for himself, the hajj for other reasons.
okay, yes. But the one difference that I want you to remember very, very well is what? The person who is hindered, not blocked, hindered by a mana, an internal mana.
It will not affect the
Exactly. He will not be with us to begin with. He is not being considered. He's not there. He's just not there. This person, everything else, this person will be present. Will be present. This person can block his mother, a couple of these, two or more of these, can block their mother's hajb nuqsan, partially. Why? يوصيكم الله في أولادكم للذكر مثل حظ الأنثيين فإن كن نساء فوق اثنتين فلهن ثلث ما ترك وإن كانت واحدة. Okay, you got to it quickly. فإن كان له إخوة فلأمه السدس. But before this, فلكل واحد منهما السدس. فإن كان له ولد فلأمه السدس. No, yes, I wanted to bring it from the beginning because the whole verse is important. There are three verses that are extremely important, 11, 12, and 176 of Surah An-Nisa. So 11 is يوصيكم الله في أولادكم للذكر مثل حظ الأنثيين فإن كن نساء فوق اثنتين فلهن ثلث ما ترك وإن كانت واحدة فلها النصف لأبويه لكل واحد منهما سدسه مما ترك إن كان له ولد فإن لم يكن له ولد وورثه أبواه فلأمه الثلث فإن كان له إخوة فلأمه السدس من بعد وصية يوصي بها أو دين آباؤكم وأبناؤكم لا تدرون أيهم أقرب لكم نفعا فريضة من الله إن الله كان عليما حكيما. Okay, so in this particular verse, it says that if there are two brothers, it didn't say which kind of brothers. Any two brothers, ikhwa, plural, but it meant two or more. Then the mother will not inherit 1/3; she will inherit 1/6. What is that called when you are partially blocked? It's called the hajb nuqsan. That is partial blockage, not total blockage. Hajb hirman is total blockage. Okay, but this person is with us. This person is going to be crossed. He's not with us, and that is one of the things that you will have to look at. Okay, so I'm just going to come to it. What about the maternal aunt? What about the maternal aunt? Huh? Okay, the maternal aunt is not with us to begin with. She is not one of the 10 women. Is she one of the 10 women? She's not one. If you are Hanbali or Hanafi, you will not completely forget about her. You will remove her temporarily, but you will keep her on the side until you may come back to her because she is min dhawi al-arham or not. Okay, that's extended kin or special kin that is not a asaba, is not a residuary heir, but she is a relative. You will come back to those relatives, dhawi al-arham, connected through the womb. You'll come back to those relatives that are not here if I don't have anyone here. Okay? But before al-mu'tiq, before the emancipator, before al-mu'tiq. Al-mu'tiq would be the last one. But you will come back to Dhawi al-Arham, according to whom Hanafis and Hanbalis. Malikis and Shafi'is will cross the maternal aunt like this and forget about her, because it will go to the treasury before it goes to her. So that's that. One mother is certainly with us. One grandfather is certainly with us, and he's going to give us the greatest trouble. If he left money and he did not say which madhab, well, it will be basically the official one of the state in a Muslim country. In a place like here, if he does not tell us who should, like some people in their wasiyah, they say AMJA should be the arbiter, for instance, or something of that nature. If he does not spell out who gets what, he can say so and so, whatever organization will be the arbiter. If he did not, then the madhab of his community, his imam, whoever is going to do the division. Yes, al-Musa ilayhi, the executor. If he left an executor, then it would be the executors. But if he did not leave the executor, it will be whoever is going to do the division. Now, mother and grandfather. We're done with this. Why did we start by this? It gives us structure, although we don't have that much time anyway. But it does give us structure. We're looking at this. The first thing that we will look at is who are the heirs to begin with? Who are the heirs to begin with? The second thing that we will look at is any one of them is hindered from inheritance because of being the murderer of the deceased, being of a different belief than the deceased or religion, or being a slave. So these are the three hindrances, and then we will remove this. And then we will look at the rest of the people, Who are the people who have designated shares? That is a chapter called أصحاب al-Furood, people with designated shares. And who are the people who are Dasabat, residuary heirs? We will have to identify those. Those are two big chapters. Now, among al-Dasabat, the residuary heirs, who's blocking who? That is an important chapter called al-Haj, or the blockage, partial or complete blockage. Yes, sir.
Just before you go, I just had a question. In the case of rada'ah, breastfeeding, are they considered heirs, or?
Okay, no, and then I will come to it right now. Okay, good, thank you for asking this. I will come to it right now. So that's the chapter of blockage. Do I have more shares than I have estate? Do I have more shares, meaning that ultimately we want the division to come up to 100% of the estate? What if the division comes up to 120%? I mean, it's not usually like this, fractions, not percentage, but what if the division comes to 120%? This is a chapter called al-Awl, which, yes, that is proportionate reduction. Everybody will be reduced because it's crowded, so we will have to accommodate each other. Everybody will be reduced a little bit. What if the Ashab al-Furood, the people with designated shares, we don't have Dasabat, because once we have Dasaba, if we have a Dasaba that will inherit, means there is no Awl. If we have Dasaba, there will never be Dasaba and basically extra money with us, or because the Dasaba takes the rest. So okay, but if we don't have Dasaba and we have people with designated shares and they took up to 80% of the inheritance, there is no 80%, it's fractions. But anyway, just imagine 80% of the inheritance. what is this going to be called? Rad. Al-awl is the opposite of this. They took 80%. يعني okay. الرد is we call الرد what? Redistribution, basically. Redistribution. Redistribute the rest that you have among the heirs. That is an important chapter, which is the chapter of Rad, the redistribution. Now, the question that was asked is an important question also, because at the beginning of the lecture, the second lecture, we will start, we'll start the seminar, inshallah, after we come back from the break. At the beginning, we will talk about what? We will talk about أركان وأسباب وشروط وموانع الإرث. That is what? The pillars, the conditions, the hindrances, and the causes of inheritance. Well, let me just finish this quickly so that when we come back, we go right into the... So, what are the arkan of al-irth? Whenever you talk about any subject, you talk about the pillars of the salah. What are the pillars of the earth? What are the main topics? There is warith, Mawareeth, and mirath. So there is the testator. Is that the right word for the Mawareeth?
Decedent.
Huh?
Decedent.
Decedent? Yeah. Is the right word? Huh?
Al-mayyit, right?
Al-mayyit, yeah. Decedent? Yes. Okay. So please correct me every time I make a mistake in translation. Decedent is the mayyit. And then there is the heir. Is that a good word? Heir is good?
Heir is good.
Oh, heir is good. And so there is this decedent, there is the heir, and there is the property. Property, okay.
Estate, actually.
The estate, okay. And then, so these are the three pillars. These are the arkan, the three pillars. And thank you so much. It is very helpful. We all want to know the right terms that are being used here. It's not superfluous at all. Okay, so al-mawâreeth, he said decedent. Al-mawâreeth. Al-warith is the heir. Huh?
Instead of saying deceased, its technical term is decedent.
Okay.
Decedent.
Yes, deceased, decedent.
Decedent.
Decedent, okay. D-E-C-E-D-E-N-T, decedent. Okay, so al-mawâreeth, al-warith, and al-irth. These are the pillars. You have to have the three to have any merit. You have to, for any inheritance, you will have to have the one who's passing on the estate, and the one who's receiving the estates. It was very, very simple. Okay, these are the pillars. What are the asbab? What are the causes of inheritance? Asbab al-irth. An-nasab al-nikah al-wala. An-nasab is what? Kinship. Kinship. An-nikah is what? Marriage. Al-wala is what? Allegiance. Allegiance, why? Through emancipation. And now, alhamdulillah, there is no religion that put together a better system to get rid of slavery than Islam. So now, alhamdulillah, we don't have to discuss these issues, but they are part of the fiqh. And whenever we study fiqh, we will have to study fiqh according to the tradition, and then we do the adaptation to our circumstances at a later stage. But fiqh has to always be studied according to the tradition, and then we do the adaptations at a later phase. Okay, so now what are the conditions? The conditions, shurut, the conditions of irth, to verify that the person actually died, to verify that the other person survived them, and to verify that there are no hindrances. These are the conditions. Verify that the person died, verify that the other one survived him, did not die before him, did not die with him, verify that the other person survived him, verify there are no hindrances. And then we have the last thing is the mawâni', the hindrances. What are the three hindrances? اختلاف الدين القتل اختلاف الدين والقتل والرق. So being of different religion, being the murderer of the deceased, and being a slave or not free. These are the hindrances. I guess this is a good introduction, inshallah. Okay. Should we say intentional murder? When we come to it, we will study the different madhahib, because if you're Shafi'i, you will not say intentional murder. If you're Maliki, you will say intentional murder. So when we come to it, or you will say al-udwan, the Malikis. It's basically unjustifiable killing. So we will come to it, but for now, let's say al-qatl, and then when we come to the details and see who gives which one of those among the madhahib, inshallah. We will have 5 or 10 minutes. It's 9:30. When should we come back? 9:35 or 9:40? 35? Oh, that's very energetic of you. Great. You could pick up coffee or go to the bathroom in 5 minutes. Okay, we're ready?
We're ready.
Yalla, bismillah, alhamdulillah, salatu salamu ala rasulillah wa alihi wa sahbihi wa man wala. Okay, so we will start inshallah. This is going to be Umdat al-Fiqh. This is a book, this is the matn. I based my talk today, or I based today's seminar on Umdat al-Fiqh. It is a Hanbali manual of fiqh written by Imam ibn Qudama, rahimahullah ta'ala, who died in the year 620 after the Hijrah. Mawareeth, there are not that many differences between the madhahib and Mawareeth. When there are, we will point them out. When there are, we will point them out. So whichever madhab you're coming from, don't put your guards up, you'll be fine. If there is a difference, we will point it out. Okay. The order of okay, so as I told you before, every time we have a mas'ala, and we said that we are going to use the word mas'ala, every time we have a mas'ala that is presented to us, what do they say? Mata wa tarak, he died and he was survived by, and then they give you a list. Are we going to go right into inheritance? No, we're not going right into inheritance. There are things that will be done to the estate of the deceased before we get into inheritance. The first thing in this order is Hanbali, and we're not going to be, we'll point out the differences in inheritance, but we're not going to point out each and every difference. This order is a Hanbali order. First, the funeral expenses will go out. Second, specific debts that can be found in the estate. What does that mean? So I lent you something, and then now it's time to divide the estate. I find the very exact thing that I gave you, the very exact piece of furniture that I gave you. I get to take this before all the debts are distributed. It is my exact thing that I have given you. So that debt will go out first, and then all the general debts, all the debts, everything the deceased owned to people will be given to them. In the Hanbali madhab, these include debts to Allah as well, such as, the delayed, no Hajj, delayed zakat, things like that. And then wills, whatever, the 1/3 that you have the right to dispose of.
Let's call that bequests.
Bequests, okay. So we will put number 4, it will be bequests. Instead of wills, it will be bequests. And then inheritance. So in Arabic, what would that be? تجهيز الميت, ديون الميت, الديون المعينة, الديون المتعلقة بذمة الميت, الوصية, الميراث. Okay, so the first thing that will go out is what? Remember? Funeral expenses. Everything that is related to death and the preparation of the body and burial and everything, it will come out from the estate. And then if someone finds their own thing, their very own thing, they will take it. Then all the debts will be taken out, subtracted from the estate, and people will be paid back, and then bequests, and then,
What does it mean if someone found his own things? What does that mean?
Okay. You borrowed my iPhone.
The hiba, and I'm talking about the hiba is
Not the hiba. The hiba is not non-refundable, right? You borrowed my iPhone, and okay, let's say I borrowed your iPhone, and then I died. Okay, I borrowed your iPhone, and then I died, and I also I owe Sheikh Ashraf $20, and I owe Sheikh Hussam $16, and I owe Sheikh Raouf $5. Then everybody comes to take their stuff. You find your iPhone, you take it. Then they say, okay, he owes me 5, 16, 20. Let's say I left behind, and there is deferred zakat as well, or something. Then let's say I left behind only $20. Then everybody will take. Proportion. Yes, they will take a.
his share.
Yeah, a portion of a part of the estate that is proportionate to their entitlement.
Doctor, you said the Hanbali order. Do we have other orders?
Yeah, there are differences when it comes to the حقوق الله عز وجل. They are not included, for instance, according to the Hanafis. حقوق الله will not go out. حقوق العباد will go out. But the debt coming out before the wasiyah is consensus. The wasiyah coming out before the inheritance is consensus. Okay, the book of bequests. Imam al-Qudama rahimahullah started by this hadith from Sa'd, that is Sa'd ibn Abi Waqqas radiallahu anhu. So it was reported from Sa'd ibn Abi Waqqas that he said, O Messenger of Allah, my ailment reached the extent that you see, and I am a wealthy man, and I have one daughter only. Should I give away 2/3 of my wealth for charity? He said no. I asked half. He said no. I asked 1/3. He said 1/3 is fine, and 1/3 is still a lot. It would be better to leave your inheritors wealthy than to leave them poor, begging from others. So you should not give more than 1/3 of your inheritance. But what is preferred in terms of the wasiyah? What is preferred? According to the Hanbalis, وَيُسْتَحَبُّ لِمَنْ تَرَكَ خَيْرًا الْوَصِيَّةُ بِخُمُسِ مَالِهِ. It is preferred for one who leaves wealth behind to bequeath 1/5 of his estate. Why? Why is this? Because of reports that are not necessarily authentic, but because also of certain reports traceable to the Sahaba Ridwanullahi alayhim in not only their statements but also their actual bequeathing. They bequeathed 1/5 of their inheritance. Imam ibn Qudama cited those. Okay. Now, if you're poor, you should not bequeath anything to anybody. You should leave all your money to your inheritors. You should not bequeath. It's makruh for you to bequeath anything to anybody because the Prophet ﷺ said it is better to leave your inheritors well off than to leave them poor, begging the people. So if you're poor, don't bequeath to people. Let your own survivors get all of your money. Now the legatee, yes.
Bequeath, when they said it's recommended 1/5, is that
harm, or what is that for?
Oh, thank you. That's a good question also. So the 1/5 that you will bequeath up to 1/3. You do have the right to bequeath up to 1/3. Or more if your inheritors will approve of it. Or more if your inheritors will approve of it. Let us say you had, who gets that? Let us say you have a non-Muslim father, a non-Muslim aunt, for instance. And Safiya bequeathed money to her Jewish cousin, right? And that is why it is the agreement of Muslim scholars that you could bequeath money to your non-Muslim relatives. Non-Muslim relatives. This is part of the kindness that is basically expected of all people, regardless of their religions. So bequeathing money to your non-Muslim relatives, bequeathing money to your non-inheriting relatives. You have a maternal aunt, for instance. I said aunt in Canada one time, and they said to me, here we say aunt, don't say aunt. So, but anyway, so you have a maternal aunt, and if there is any Canadian here, you have a maternal aunt, for instance. She's not going to get anything from your inheritance. And keep in mind, Dhawoo al-Arham does not mean that they are less important or less significant. The Prophet ﷺ said, al-Khala بمنزلة الأم, or al-Khala walida. Al-Khala, the maternal aunt, is a mother. The maternal aunt is like the mother. So it doesn't get any closer, أمك ثم أمك ثم أمك. So your mother and then your mother, your mother. So if she is a mother, she is like your mother, she is extremely close to you. If she is not going to get from the inheritance, give her from your bequest. Okay? And also anybody. In fact, the way for the future here in these Muslim minorities, in a country like this, in wherever we are, our institutions will not stand on their feet unless people remember also the different organizations, different institutions, their masajid, and so on. You know how much awqaf the Catholics have in this country. You know how much Catholic hospitals around the world. This is something that we have to pay attention to. We will not survive as a community. The money is basically necessary for all of those activities and functions and building our institutions. Anyway, so you will do whatever you want with the 1/3, but you cannot give more than 1/3 unless إلا أن يشاء باقي الورثة. The Prophet ﷺ said, لا وصية لوارث إلا أن يشاء باقي الورثة. That addition, إلا أن يشاء باقي الورثة, was reported by Daraqutni, and Ibn Hajar, rahimahullah, considered it reliable. So, لا وصية لوارث, there should be no bequest for an heir, except if the rest of the heirs approve of it. Now, the Hanbalis would say, they have two different reports. They will say it's still forbidden, but it will be valid. And some reports says it's mubah, and so on. But in general, it is okay. It is okay as long as the rest of the heirs will approve of it. You want to give half of your money to your masjid, take permission from your kids. And then they can retract it. Yes. They can retract it after you die. It will be their right. They can take it back. They can give you permission, say, okay, give your half of your money to the masjid, and then you die. They have the right to say no, because their permission is required at the time of the division. At the time of the division. So you get, yes. هذه زيادة عند الدارقطني, yes. عند الدارقطني وابن حجر قواها. So now, okay. Now, who can receive? ولكل من تصح الهبة له وللحمل إذا علم أنه كان موجودا حين الوصية. And bequests are valid for the benefit of anyone who is eligible to receive gifts and for the fetus in the womb if it becomes known that he or she was present in the womb at the time the bequest was made in his or her name. Okay, anyone can get a bequest, including your method. Okay, if I want it to be interactive, but if I also want to make sure, because I have like 4 or 5 people who wanting to ask questions, I wanted to make sure that we finish. So it will be up to you. I will not say no, but it will be up to you if we will finish or not. Yes, Akhi.
Sakaratul maut, can a person figure things out just when he's about to die? The humbly mother, do they allow that?
Well, this is coming at the end, and it's coming at the end. This yes. No, it's coming at the end. Any disambiguation, any need for disambiguation. So any question that is not pertinent to the very topic that we are talking about now, please defer it. But any need for disambiguation, please ask it. Yes?
Can a parent give wasiyah to an heir child to add more to their share than the rest of the kids?
Can a parent give one of the children more than the rest of the kids? Okay, from the wasiyah. Okay. First of all, اعدلوا بين أولادكم. The Prophet ﷺ said, you know, be fair among your children, or be fair with your children. So by default, no, absolutely not, except if there is a particular indication, and such as one is disabled or one has some issue, and the rest of the kids طابت نفوسهم بذلك. The rest of the kids are accepting, you know, without any pressure of that, then that would be okay.
They still can retract that.
At the time of distribution, yes, they can say, no, we take it back.
So my question is related to this. Can they retract from Sharia perspective or legally as well?
Legally, yes. Okay, next is the chapter on the executor of the bequest, Bab al-Musa ilayhi. So I wanted to say that it is important for us that we appoint someone, designate someone to take care of this business. Like if you, and most of the time, it would be helpful, and I'm not doing this because Sheikh Yaser is here, but it would be helpful to have a Muslim lawyer taking care of your affairs. Like you take your wife to a Muslim lawyer as soon as you can. Encourage your congregation also to do this, to figure out what will happen after you die. There are a lot of things that need to be figured out, because you could die at any time. You know, ما حق امرئ مسلم له شيء يريد أن يوصي فيه يبيت ليلتين إلا وصيته مكتوبة عنده. So it is not befitting of a Muslim person that has anything concerning which he wants to, you know, to write a will, to spend 2 nights without his will, or being there, you know, without writing his will. So it is important that we be proactive about this thing, and Sheikh Yaser will have his time, inshallah, to talk to you more about these things. So the executor of the bequest, certainly in Islam it doesn't have to be a lawyer. It could be anyone. It could be anyone, male or female. This is, it is valid to appoint any sane, trustworthy Muslim man or woman as an executor of the bequest, to perform acts that are within the scope of legal capacity of the testator, such as paying his debts, distributing his bequest, and looking after his children's interests. Looking after his children's interests. Okay. Now, this is subsection on guardianship. Subsection, the guardian may permit the discerning children to conduct the business. Now, you are the executor, you are the guardian, Musa ilayhi. The guardian may permit the discerning children to conduct business, to test their prudence. Rushd here means competence in money management. For those whom he feels to be competent, he should pass their money to them once they reach puberty. He should have this transfer of wealth witnessed. This applies to males and females alike. Okay, so if you are the executor and you take care of the children, you are the guardian of the children, now when do you give them their money? That is what they're saying. Of course, nowadays, kids reach puberty and they're completely just not there. During their times, Benjamin Franklin started to work when he was 9 years old, right? He had a job when he was 9 years old. A 9-year-old here is just a 9-year-old. So anyway, so nowadays, certainly it may be later than this. This rushd, this prudence may be reached at a later age. And it is in the capacity of the legislatures to determine what age. Bulugh in Islam is, 15 according to the majority, 18 or 17 based on the gender according to the Hanafis, and that is just bulugh. Certainly, bulugh in Islam is about the biological markers, but if you don't have the biological markers, then what is the ceiling, the age for bulugh if you don't reach the biological markers? 15 according to the majority, 17 and 18 according to the Hanafis. But nowadays, most people will say that rushd competence is 21. Okay, so the Book of Inheritance, or Kitab al-farâ'id, this section pertains to the division of the division of the estate, not residuary estate. Maybe residuary estate after the will or the bequests. Whatever is left after the preparation, funeral expenses, and paying off the debts, and the will or the bequest, is going to be now the mirath or residuary estate. Okay, so chapter on the hindrances to inheritance. And we did talk about this. We talked about the asbab, we talked about the shurut, talked about the mawâni', and we talked about the arkan. We talked about the pillars, we talked about the conditions, we talked about the causes, and the hindrances. So, the file that you guys got, just to not get busy like taking pictures of the screen, we will send you the PDF if it was not sent to you. Has it been sent? It was sent to you? Okay, the whole PDF. Everything should be there. Which PDF was sent to you? Huh? Okay, so everything is here. Everything is in that PDF that was sent to you. If you want to take pictures, it's up to you. It doesn't bother me. I'm just letting you know. So these are the mawâni', these are the hindrances, and we've talked about everything related to this.
Can you,
yes?
for a moment, talk about the convert from their non-Muslim parents?
Okay. Oh, thank you. And remind me if I forget something that's important. Difference in religious affiliation, meaning that the people of one religion shall not inherit from the people of another, because the Messenger of Allah ﷺ said the Muslim shall not inherit from the non-Muslim, nor shall the non-Muslim inherit from the Muslim. And people of two different religious affiliations may not inherit from one another, as for the apostate, he does not inherit from anyone. Okay. And if he dies, his estate becomes a fay'd, spoils. It goes to the treasury. Okay, I know, politically incorrect, but this is Ibn Qudama's Matn anyway. But the issue here that we wanted to say is that inheritance here is not basically court-enforced distribution of the estate. Inheritance here is predominantly a willful distribution by the decedent. Therefore, can a Muslim child inherit from their non-Muslim parents? Of course, because that is not court-enforced division of the estate. That is the non-Muslim parent passing on willfully, bequeathing to their children money. And it is a wasiyah, not an inheritance. Now, here is the issue. What if they bequeathed more than 1/3? Can they do this? It would be like what we used to say is, you tell the rest of the heirs, are you okay with that? And if they're okay with it, then they are okay with it. Tell the rest of the heirs, are you okay with me getting more than 1/3? Then if they're okay with it, then that's fine. Yes?
But often they're not okay with it. You've offered them an exit.
Well, then take the 1/3.
Well, if the son is not a child, that's it. The father is kafir, and the son is the only heir, and he is adult, mature person.
Okay, so the father bequeathed to him. This is all bequests. It's not inheritance. It's not court enforced. The farq بين الوصية والميراث is that the mirath in Islam is court enforced distribution of the estate versus the wasiyah, which is your willful bequeathing to people that you want to bequeath to. But let us try to go through we're going to be behind no matter what. So if we branch off, go on tangents, it's going to be, we're not going to end anything. You're just going to go home with 1/4 of the, yeah.
It's the point. اختلاف الدين, the father is a non-Muslim, and he is only one iron son, 25 years old, and there is no bequest, no wasiyah. What are you going to do with this money? Big property. Son is Muslim. Father is very rich, wealthy, but non-Muslim.
You presume that he passed like 1/3 to him. If the state gives him the money, he will just take it. If the state gives him the money, because the father did not make any distribution, he will take it if there are no other heirs. Because لا أحد له حق ينازع فيه. فإذا كان هناك أصحاب حقوق ينازعون ساعتها تخبرهم بأنه لهم حق. If there are people who are entitled to the inheritance, then you tell them, I can take 1/3 of this inheritance based on my religion, and if you approve of more, then I'll take whatever it is that I got. But if not, if there is no one to basically claim the estate, it's either you or what is it? The treasury. So in this case, you take it. Now, okay, so killing. The killer shall not inherit from one whom he or she killed unjustifiably. However, if he or she killed the deceased justifiably, such as for a capital crime or retribution, or when the legitimate authorities killed the rebels, then that will not be a hindrance against the inheritance. A hindrance against the inheritance. The Hanafis and Hanbalis come in the middle of this. The Malikis are on one side, the Shafi'is on the other side. The Shafi'is will not give you inheritance if you killed the deceased, even if you killed the deceased justifiably. Even if you were the in qisas, justifiably. Doesn't matter to the Shafi'is. Doesn't matter. If you kill the deceased, you're not going to inherit. What are the Shafi'is trying to do? Yes.
Even if it's accidental?
Anything. Yes. So anyway, for the Hanbalis, it is whether it's accidental or intentional, it doesn't matter. The only exception is when you kill the deceased justifiably, like the deceased deserved the sort of capital punishment, and you executed it. Categories of heirs. والوارث ثلاثة أقسام ذو فرض وعصبة وذو رحم. The heirs belong to one of three categories. ذو فرض, heirs of designated shares. عصبة, residuary heirs. ذو رحم, other kin. This is Hanbali and Hanafi. This is not Maliki or Shafi'i. What is it for the Malikis and Shafi'is? 1 and 2 only. Malikis and Shafi'is don't have ذو رحم, other kin, they don't inherit. Hanafis and Hanbalis, they give ذو رحم, they make them heirs if you don't have one or two. If you don't have one or two. But they also put them before the emancipator in two. Okay, anyway.
So,
Yes?
3 is not Maliki or Shafi'i?
3 is not Maliki or Shafi'i. So, فذو الفرض 10 الزوجان والأبوان والجد والجدة والبنات وبنات الابن والأخوات والإخوة من الأم. Heirs with designated shares are 10. The spouses, the parents, the grandfather. Which grandfather? Okay, the grandfather in this case is the paternal grandfather. Any grandfather between whom and the deceased there is a woman is not going to inherit. It is a grandfather that is connected to the deceased through men only, because he inherits as a asaba, residuary heir, paternal kin. The grandmother, which grandmother? It is any grandmother. It is paternal or maternal grandmother. And the Hanbalis do not make a distinction like the Shafi'is between the paternal and the maternal grandmother. We will come to the inheritance of the grandmother and talk about it a little bit more. But any paternal or maternal grandmother. Okay. But certainly, so it is the mother and the mother's mother and the mother's 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 mother and so on, as long as it's going through females. And then it is the father's mother and the grandfather's mother, the father's mother and the grandfather's mother. It does not go up all the way like on the other side. On the maternal side, mother, her mother, her mother, her mother, her mother. 20 generations up. Well, still, huh?
There's no cap.
There is no cap, yes.
But one of them will cut the way to the others.
Of course, any one of them, anyone closer, because as we will come to say, we have the jiha, the direction, and then you have the qurb, the proximity. This applies in any direction. You have a son and a son's son. Son's son will not get anything. The son will block him. You have a brother's son and a brother's son's son. The brother's son's son will not inherit anything because the brother's son will block him because closer. So qurb. And then the last thing is al-quwwa. You have two uncles, two paternal uncles. One of them is full, one of them is half paternal. The full will inherit, not the half paternal. Quwwa, strength. So jiha, qurb, quwwa. Direction, proximity, strength. Okay. And then you have the grandfather, the grandmother, you have the daughters. Who are the daughters? Sulbiyya, which is your direct one. Who are the daughters of the sons? Any daughter. Okay. Daughters of the sons means that she is separated from the deceased by males only. So it is your son's daughter or your grandson's through your son's son's daughter, son's daughter, and so on. من أصحاب الفروض. أصحاب الفروض, she has designated share. She has a designated share. She has scenarios where she has designated. This one can take half of the estate. But as of course, but this is the chapter of blockage. Right, so we'll come to this. All right, and then the daughters of the sons, the sisters, the maternal half siblings. Okay, this actually is 3 in 1. This is 3 in 1 because this is the full sisters, the half paternal sisters, and the half maternal sisters. All of them inherit. That is why here, under the sisters, full sister, half paternal sister, half maternal sister, 6, 7, and 8 are just the sisters. Because these are spelled out completely, the 15 and the 10. Okay, and that's it. These are called what? أصحاب الفروض, the heirs with designated shares. Only these, and you must start by them. We said that we have 3 verses that we need to remember and 1 hadith. Yeah, it's not like this way, but like when the Prophet ﷺ says al-Haj Arafah. Hajj is about Arafah. Also, Mawareeth is about 3 ayat and 1 hadith. The 3 ayat are Surah An-Nisa, 11, 12, and 176. That's the last one. That's al-Kalala. And the surah and the hadith is al-Hiq al-farâ'id bi-ahliha fama baqiya fali-awla rajulin dhakar. Al-Hiq al-farâ'id bi-ahliha. Give heirs with designated shares their shares, and whatever remains, give it to the closest male relative. Closest male relative. I can't think of anything other than تأكيد, because it's رجل ذكر. Every رجل is ذكر. Yes. Okay, inheritance of the husband and wife. Okay, we will get now to the designated shares. Let us begin. Before we do this, we will have like a couple of drawings here, because there are 2 ways to go about this. There is the way of trying to get every heir and figure out what they get. The other way is to
هل الفقهاء أخذوا من الحديث التفرقة بين العصبات وذوي الأرحام؟ الحديث فلأولى رجل ذكر، فهل الفقهاء يعني فرقوا بين العصبات وذوي الأرحام بناء على هذا الحديث؟
Yes. أولى رجل ذكر عصبات فقط ليس من ذوي الأرحام. لكن الحنابلة والحنفية they used other آيات and hadith أولو الأرحام بعضهم أولى ببعض. They use other آيات and hadith to prove their point that Dhawoo al-Arham will inherit before the treasury. No one is arguing that Dhawoo al-Arham will not inherit in the presence of Asabat. They will inherit only if there are no people with designated shares and no Asabat. Okay, so let us make a drawing here and let us figure out the estate of the deceased, the decedent. Is this or this? Okay, what are the shares that we have? Because one of the things that you want to remember, let's say I tell you that Sheikh Abdullah, someone died, and Sheikh Abdullah gave his maternal aunt 3/4 of the inheritance. 3/4 of the inheritance. You will come to say, you will not need to listen to anything else, and you say, Sheikh Abdullah is really different because maternal aunts don't inherit, and there is nothing called 3/4. So you will need to know what are the designated shares. So how do you divide this circle? Like this, half. And this circle will be divided into 3 parts. Okay, that's it. Then you will do this. Okay, and you will do this. Okay, so what are the designated shares? Half. Quarter. And 1/8. What are the designated shares? No. 2/3. That is 2/3. And then 1/3. And then 1/6. That's it. There are no other designated shares. You know, sometimes we say thuluth al-baqi and stuff, but we'll come to these things. You know, the 1/3 of the rest and stuff, but we'll come to these things. But anyway, just remember, it is half and divided and divided. 2/3 and divided and divided. Divided by 2 and divided by 2. So half divided by 2, 1/4. Divided by 2, 1/8. 2/3 divided by 2, 1/3. Divided by 2, 1/6. That's it. Okay. So now let's start. Let us say, so who inherits 1/2? We will need to remind ourselves now of these things. Who inherits 1/2? The husband. Who else inherits 1/2? Daughter.
And the daughter of the son.
Thank you. Daughter of the son.
And the sister.
Thank you. Full sister, right? Full sister. Who else? Half paternal sister. Half paternal sister. They inherit 1/2. They will have different scenarios, but in some scenarios, they will inherit 1/2. That's what we're saying. We're not saying that they will all the time inherit 1/2. We are saying in certain scenarios, they would inherit 1/2. Okay. So who inherits 1/4? Oh, it's only for spouses. That category is only for spouses. It is the husband and wife, depending on the different scenarios. Okay? So the husband will inherit. Okay. The husband will inherit the 1/4 if there are children. Okay. The deceased was survived by children. Inheriting children. Let us say the deceased was survived by his daughter's daughter. That doesn't affect anything. Inheriting children. Who are the inheriting children? Sons and daughters of sons. Sons and daughters of sons. Okay. Yes. That is al-farâ'id. Any farâ'id. We just call it farâ'id in this case. Mudhakkar or mu'annath. So the husband and wife in different scenarios. The wife would inherit the 1/4 if there were no children. The husband would inherit the 1/4 if there were children. In the presence of children, the husband inherits 1/4. In the absence of children, the wife inherits 1/4. What about the 1/8? One person only inherits the 1/8. Wife/wives. And I have to be, forget about political correctness here. It's wife/wives. Yes. What? Oh, okay. Well, yeah, this is the asaba will get. It does not get 100%. No one gets 100%. It is called. Okay, asabat. What is the share of the asabat? You never mention a share for the asabat. If he gets half, you don't say half. You say al-baqi, the rest. Asaba does not get anything, even if you have a mas'ala. Okay. Someone was survived. Do not confuse things. Someone was survived by
a husband and a father. Husband and a father. How do you حل هذه المسألة? How do you solve this مسألة? The husband gets what the father gets? The rest. Don't ever say the father gets half. The rest. We don't. The father gets the rest. The rest happen to be half. Okay, that's fine. But that is not the lingo. That is not how this problem is solved. Yep. Well, you have to stick to the technical lingo, of this science, so that you avoid.
The rest I'm talking about the last ayah. It's talking about al-kalala. 100%.
Okay. Okay. يرثها here أخي is بالتعصيب. يرثها here as a عصبة, not صاحب فرد. So he will get the remaining, the rest. In this case, the rest is 100%. We still call it the rest. The rest. There is no share called 100%.
What do you mean by sons, daughters, and daughters of sons? When you said sons and daughters, daughters of sons, that was
الابن والبنت وبنت الابن. بنت البنت لا ترث. الابن the sons. البنت the daughters. The sons' daughters بنات الابن. بنات البنات لا يرثن. The daughters of the daughters do not inherit. They inherit when do the daughters of the daughters inherit? When do the daughters and daughters of the daughters inherit? Dhawi arham. So they inherit if we don't have the heirs with designated shares, and we don't have asabat, residuary heirs. They will inherit only then according to Hanbalis and Hanafis. What do the Malikis and Shafi'is do in this case? The money will go to the treasury, the state. Okay. Now we have the 1/8 is the wife.
the 1/8 wife, even if the children from another wife. Even if she has no children from him, but he has children.
Of course. No, of course. The wife will get 1/8 if the husband had children from any wife. He was survived by children. Now,
the children were not to inherit because they were non-Muslims. Do they still give her the 8 or no?
if the children are non-Muslim,
Not with us.
huh?
Not with us from the beginning.
They are not present.
Forget about them.
If they are killers, they are not present. Slaves, they are not present in the mas'ala.
And the non-Muslim
Uh-huh.
still gets an 8th, right? The non-Muslim wife.
The non-Muslim wife still gets an 8th? No, she doesn't. He will have to give her, and in general, brothers, people say, like, if the wife gets only 1/8, that's very little. What are we going to do with the house? Maybe Sheikh Yaser also will talk about this a little bit more, but whether she's going to be kicked out of the house and stuff like this. You guys are miserly. Why don't you give her the money in your life? Why do you wait until you need to bequeath the money to her? Just give her the money in your life. Make the house joint ownership, you and your wife. She automatically has 1/2. You want to be miserly and controlling in your life, and then you want to say, well, I can only give my wife 1/8. How fair is that? Well, it's unfair in the beginning that you did not give her anything in your life. Okay, so make the house joint ownership. That's what I advise anyway. You don't have to. In Islam, you're not required to, but that's my advice. To be kind and to avoid the problem of she inheriting less than what she's being kicked out from her home. After she spent 30 years there, they will tell her, okay, it's time now for you to go find the studio. Okay, yes, but as we said, we're going to be way behind. Yes. Disambiguation.
Yeah, why do we give the wife in the life whatever?
I told you don't give her if you're not. This is my.
If the heirs are children.
I told you Islam does not require this of you. I'm just telling you that if you want to be kind and you are concerned about your wife's future and the fact that she will get 1/8 of the house and the fact that she will be kicked out of the house, after you die, if you're so kind, give her half of the house in your life. Write the house and joint ownership anyway, whether you do it or not. Sheikh Yaser will talk about this. So, anyway. But joint ownership is basically what the law of the land. Yes.
الحدث أن مر عليك مسألة أصحاب استغرقوا بالإنهيرنس.
أصحاب الفروض, of course. زوج وأخت. See, زوج وأخت. Done. زوج half, أخت half. Done.
لا يعني لم يبقى العصبة شيء.
Like husband and sister. Husband and sister. No, الولد is.
أصحاب الفروض مع وجود العصبة. مرة مسألة أصحاب الفروض استغرقوا التركة عدم وجود
زوج وأخت. زوج وأخت. الأخت متى ترث النصف? When does the sister get 1/2 if you don't have فرع وارث أو أصل مذكر؟
سؤالي مع وجود العصبة.
مع وجود العصبة.
يعني الابن مثلا.
قدم العصب للرب يرد فقط عليه.
Listen. زوج وأخت survived by a husband and a daughter, and I have to be fair to the brothers who speak only English. So no matter what, but I have to be fair because the people. This is the announcement. This is the agreement. This was going to be done in English. He was survived by a husband and a sister. Okay, when does the sister get the half? Verse 176 of Surah An-Nisa. يستفتون قل الله يفتيكم في الكلالة إن امرؤ هلك ليس له ولد وله أخت فلها نصف ما ترك. What is the kalala here? What is the kalala here? That is the man that was not survived by inheriting descendants. Inheriting descendants, male or female, does not matter, male or female. That is al-abna, al-banat, banat al-abna. That is the sons, the daughters, and the sons' daughters. Okay? These are the inheriting offspring, descendants. Or an inheriting male ancestor. Male ancestor. So that means what? Means the mother does not change that. Inheriting male ancestors. Now the inheriting male ancestor, if it is a father, she's out. She's out. If it is a grandfather, he will cause us all the trouble afterwards that we will come to. And if you're Hanafi, you can actually go out and have coffee and, for Hanafis in the crowd, you will have 1 hour break. Because the grandfather, according to the Hanafis, and actually one position in the Hanbali madhab, it is the sort of the weaker report in the Hanbali madhab is in agreement with the Hanafis. So we have 2 reports in the Hanbali madhab. One is the grandfather blocks all the siblings. The grandfather blocks all the siblings. The other one is the grandfather does not block all the siblings, and we will come to the details, but we're behind. Okay, 2/3. Who inherits 2/3? Yes.
ممكن نعمل no interruption policy until when we ask later.
I told you, you guys are responsible. Yeah.
Can you read our questions?
Unless it is for disambiguation, meaning clarification, meaning I said something that is undecipherable and you want it deciphered. Otherwise, interruptions will cause us to go home without finishing that refresher. It's a refresher or introduction, depending on where you're coming from. Okay, so 2/3. Who inherits 2/3? Okay. 2 daughters. or more.
Two sisters.
Two daughters of the sons. Two full sisters. Two half paternal sisters. No. Two half maternal will take 1/3, man. Okay. Not the other side, it is this side, but 1/3. And these are أصحاب فروض also. These, yeah, but okay. So it's all designated shares. Okay, all designated shares. 2/3. Okay, 1/3. Hmm?
The mother.
2/3. 2/3 would be daughters, daughters of sons, full sisters, half paternal sisters. أخت الشقيقة, الأخت لأب. Okay. 1/3.
The mother.
The mother. In which case?
In the case of when no brothers.
No children or multiplicity or of siblings. So yeah, no children or more, two siblings or more. In this case, she gets 1/3. Who else gets 1/3?
No, one daughter half.
Hmm? Okay, that's great. We just said it. That's maternal siblings. Will get 1/3. So al-Umm will get 1/3. Maternal siblings will get 1/3. Thuluth al-Baqi is a different story that we will come to. The 1/3 of the remaining is a different story that we will come to. So who gets 1/6? So a lot of people will get 1/6. The father will get 1/6. The grandfather will get 1/6. If the father is not present, the grandfather will take the same rulings as the father, except that he will be blocked by the father, and he will not, according to the Hanbalis and the Malikis and Shafi'is, he will not block the siblings, and he will not compete with the mother in the Umariyatain. Okay, but in general, the grandfather takes the same rulings as the father, except in certain limited cases. So the grandfather takes 1/6, the mother and the grandmother.
One brother.
Hmm?
One brother in Kalala.
Okay, one maternal brother or sister.
Or sister.
Okay. One maternal sibling. Will get 1/6. So the father, the grandfather, the mother, the grandmother, one maternal sibling, that is brother or sister.
Daughter of the son.
Ahsant. Daughter of the son. When does she get 1/6, the daughter of the son? If you have one daughter who will get 1/2, she will get the rest of the 2/3, which is 1/6. الأخت لأب مع الأخت الشقيقة is the other scenario here. الأخت الأب مع الأخت الشقيقة. That is the half paternal sister. الأخت الأب مع الأخت الشقيقة. Okay, we said that in the kalala is what? The man who was not survived by inheriting children or male ancestors. Inheriting male ancestors. That is kalala. No father, no paternal grandfather, and no children inheriting children. Who are the inheriting children? The sons, the daughters of the sons. No matter how many generations down.
Not the son of
Huh?
The sons.
So we say sons for the sons no matter how many generations down. And the daughters of the sons, no matter how many those sons, no matter how many generations those sons down. Okay. So now we're done with this. Let us go over the scenarios of each and every one. Okay. It's going to be difficult. 10:42 already. Okay. What time is your segment, Sheikh Yasir? 11? 11 to 12:30? Is that your segment? Okay. So, but we will come back after this segment, which is extremely important, and we will do our thing, inshallah, after lunch.
Take lunch just half an hour. We don't need more.
We'll try to squeeze lunch because there is much material to cover here. Okay, so the husband. Whenever you start any case, Sheikh Muhammad, can you do your Ma'rad thing? Or where do you go? Can we remove these and put them up there? So whenever... Okay, so whenever you have any mas'ala, start with the spouses. Please start with the spouses. Okay, and then the rest of the people with designated shares, and then the residuary heirs. So give me a mas'ala that has a husband. So here, Imam ibn Qudama rahimahullah ta'ala says, for the husband, 1/2 of the estate if the deceased has no inheriting offspring. If she has inheriting offspring, he gets 1/4. She, the wife, is entitled to 1/4, whether there was one wife or 4. If he has no inheriting offspring, if he has inheriting offspring, the wives are entitled to 1/8. All of them are entitled to 1/8. So you have a husband. So anyway, let's do this. Well, let's use the genome. Do you guys know how to use this? Do you guys know that square is for male and circle is for female? And this means they are married. And this means they have children. Okay? So this means, so if we say that this is the original case, that this is the index case. If we say this is the index case, okay. Wait a second. Okay. Whenever I write this, whenever I draw this, I will do 2 circles here to point, or 2 squares to point to the index case. This is the index case. If she was survived by all of those, this index case was survived by all of those. Who's this? Her husband. No, guys, like his sibling is here. Like, this is her father, this is her mother. She's coming from her father and mother. Her sibling is here. She went and got married to this man. They had these kids. Okay, this is, who's this? Her paternal grandfather. Who's this? Her paternal grandmother. Okay, so she was survived by a husband, 2 boys, 2 sons, a daughter, a brother, a father, a mother, a grandfather, a grandmother, paternal, both. Okay, man sayuwarith, who is going to solve this mas'ala? Yes? Huh?
You're talking about this mas'ala or give a mas'ala?
This one. How are you going, okay, Who's going to get what now?
Can we start with a more simple one? If there is only husband, what do you do?
Well, okay.
She's only survived by husband and no one else.
Okay, he will get 1/2.
What about the rest?
Huh?
What about the rest?
The rest, you want to ask about nawazil and stuff like this. Anyway, okay, so he's talking about the redistribution. According to the four madhahib, there is no redistribution back to the husband. You guys, the ABCs are first. You're getting us into like
Let's take that
okay.
first.
Redistribution. What he's talking about here is when she's survived only by a husband or he is survived only by a wife. According to the four madhahib, the husband and the wife are not included in any redistribution, in any rad. They are not included. The money will go to the asabat. There are no asabat. Will go to Dhawoo al-arham. There are no Dhawoo al-arham. Will go to the state. Okay. Now, Uthman radda ala al-zawjayn. Uthman radiallahu anhu redistributed to the husband and the wife. Majma' Fuqaha al-Sharia took the position of Uthman, even though it's counter to the four madhahib, because in our conditions here, let's be honest, like what do you want to do? Like you want the money to go to the state or you want the money to go to the wife? Okay, good. Money is going to the wife. That's it. But this is, okay, let's.
Can we go without a question so that we can cover?
Yes, brothers. This lady died. Allah yarhamha. Okay, what is this poor guy getting now?
He's getting
Fourth, 1/4, 1/4. Why?
They are children. They are children.
No. Say the right word. لوجود الفرع الوارث. Because of the presence of inheriting descendants. Because of the presence of inheriting descendants. Yeah. Now, because the daughter's daughter is actually your child. She's actually your grandchild. But she's not inheriting. Yes. Okay. Now, okay, so he's getting 1/4. If we take these out of the mas'ala, if we cross the children, how much does he get? Half. In the presence of everybody else, yes, he gets half. Because what blocks him from the 1/2 to the 1/4 is only inheriting descendants. We're done with this one. Let us say, okay, just to flip it, let us assume that. Okay, this is difficult to be the index case. If this index case was the man, if this was a man, make it a man, and this is his wife. Okay, what does she get? 1/8. If we remove this, the inheriting descendants, she gets 1/4. We're good. We're done with the husband and wife. That's great. Okay, 6 people will never walk away without part of the estate. Who are the 6 people that will never walk away without getting part of this estate?
الزوجين الوالدين
children.
الزوجين والوالدين
The inheriting children, that is of the first generation. Your son and your daughter. Let's say your son and your daughter of the first generation, just immediately, because the rest can be blocked by them. Your son and your daughter, your wife or your husband, because you can't have the two, and your mother and your father. Your mother and your father. These 6 people will always get something. Never will they walk away without anything. So, because, So now, the inheritance of the father. The father has three possible situations. If there are male descendants of the deceased, he gets 1/6. He inherits as a residuary heir. If there are no inheriting offspring, he gets 1/6 and inherits as a residuary heir if there are female descendants of the deceased. Okay, so when it comes to the father, the verse of Surah An-Nisa, verse 11 of Surah An-Nisa that we quoted earlier, when it comes to the father, we're not looking at anyone except the descendants. We're not paying attention to anyone except the descendants. So we will have three scenarios. That the man was survived by sons or sons' sons. The man was survived by daughters or sons' daughters. The man was not survived by any children. Three scenarios. If the man was survived by sons or sons' sons, the grandfather will get what? The father will get what? Only 1/6. Because he cannot be an asabi and take the rest. Because as we will come to it in the chapter of al-Dasabat, we will know that the first thing that we look at is the direction. The direction of al-bunuwa, which is filiality, takes precedence over the direction of al-ubuwa, which is ancestry. Takes precedence because one is still have the responsibilities of life ahead of them and stuff.
One is exiting life,
Yeah.
basically.
So okay. So the direction of the bunuwa takes precedence first. And in this case, the father will not be a residuary heir in the presence of the son or the son's sons. In the presence of the daughters, 1/6. In the absence of everyone, what does the father? Where is the father in the absence of the children? Yeah. In the absence of everyone, he will be a residuary heir. Okay, if there are daughters, why is he getting the 6th and the rest? Why can't we just say the rest? What does it mean to say the 6th and the rest? If he's getting the rest, he's getting the rest. But why are we doing this?
Based on the ayah.
But the rationale behind it.
لو قلنا الباقي فقط ربما لا يأخذ شيء.
Exactly, because in the presence of daughters, the daughters are so strong, they can really, because they take what? 1/2 or 2/3. If there are two daughters, they take 2/3. The man, if we say the rest, he may walk away without anything, and he's a father. He can't walk away without anything as a father. So if that is the case, we will not say the rest. We will have to say he will get 1/6. Okay? All right. So okay, let me give you an example. A man was survived by a husband, 2 daughters.
A man was a husband or a wife.
Oh, no, I'm sorry. A woman was survived by a husband. A woman was survived by a husband, 2 daughters, a mother, and a father.
One more time. A man?
No, a woman was survived by a husband, 2 daughters, mother, and father. What does the husband get? 1/4. We are done with this because there are inheriting children. The husband will get 1/4. What does the mother get 1/6?
The father the same.
Okay, 1/6. One second. The two daughters, what do they get? 2/3. If we say that the father gets the baqi, the rest, he's not going to get anything. Two daughters will get 2/3. The mother will get 1/6, and the husband will get 1/4. Is there anything left? No. Without anything, this is a'ila, this is alat, this is already, we don't have enough. So it's crowded. So nobody of the residuary heirs will get anything. Therefore, we made it look like this. And in fact, can you help me read the statement of the professor of, at the beginning of this PDF, under the chapter of Asabat, it's just a beautiful statement I want. At the beginning of the book of inheritance, and the PDF of Sharh al-Umda that I gave you. And I will end by this before Sharh al-Umda that I gave you. This is the book of inheritance, huh? Oh, yeah. Huh? No, the book of inheritance. At the very beginning of the book of inheritance. Loading amount of bequest. Okay, can you come here? Read it here.
It's here.
Okay, so this Professor Al-Malik Ramsey, he was a professor at the King's College in London between 1825 and 1899. He's the author of many works on the subject of the Muslim law of inheritance. That's what he said. The Muhammadan law of inheritance comprises, beyond question, the most refined and elaborate system of rules for the devolution of property that is known to the civilized world, and its beauty and symmetry are such that it is worthy to be studied not only by lawyers with a view of its practical application, but for its own sake, and by those who have no other object in view than their intellectual culture and gratification. So it's sallallahu ala Muhammadin wa ala alihi wa sahbihi. Okay, so now that we, because it is, the next segment is going to be very important, I wanted to say, we're clear why the father is getting 1/6 and the rest now, right? In the presence of daughters or sons' daughters, we are concerned for him that he may walk away without nothing. So we give him 1/6 and the rest. If there is rest, okay. We survived by 2 daughters and a father. Survived by 2 daughters and a father. The daughters will get 2/3. The father will get 1/6 and the rest. He will not get 1/3. He will get 1/6 and the rest. They happen to be 1/3, but he's getting 1/6, and the remaining 6, he will get it as a residuary heir. So, yes, no, we don't say 1/3 because 1/3 is not, Yeah. We'll stop here. We will have a 10-minute break, and we will come back, and then we will push Sheikh Yaser's 10-minute, we'll give him his 10 minutes, inshallah. Okay, we'll stop here and come back in 10 minutes for Sheikh Yaser's segment.
بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على أشرف الأنبياء والمرسلين سيدنا ونبينا محمد وعلى آله وصحبه أجمعين اللهم علمنا ما ينفعنا وانفعنا بما علمتنا وزدنا من فضلك علما يا كريم. So first off, thank you all for joining today, and it really is an honor to be in front of the Mashayikh at AMJA and Sheikh Hatem Hafidhullah to refresh our understanding of ilm al-mirath and the farâ'id. And this is, subhanAllah, such a virtuous and noble science, and one that is impacting every single person in our society. And yet, subhanAllah, and this is the prophecy of the Prophet ﷺ, that it's something that is not discussed. Right? So for the average Muslim, perhaps they have attended thousands of halaqat and khutbahs in their life, and maybe they've never had a discussion about the obligation of mirath, despite the fact that it comes as the most explicit injunction in the Quran. Shaykh Hatem alluded to the 3 ayat from Surah An-Nisa are the most explicit, detailed injunction that is an obligation to fulfill. Now, everything that the Shaykh is covering has to do with how to distribute the estate after death. How to distribute the estate after death. Now, what we are talking about in this session is the reality that would not be possible but for some work you have to do before death. Okay? So I'll say that again. This notion of estate planning in most Muslim lands doesn't require you to affirmatively do something before you die. Is that true or no? Right? So if you grew up in a Muslim country or a Muslim majority country, or even in countries with sizable Muslim populations. In India, for instance, it's not a Muslim country, but they will apply Muslim law to Muslims. You don't actually have to make a will. So the hadith that the Shaykh mentioned about writing the will in most Muslim societies doesn't have to be implemented. But here, that's not the case. That it's not going to happen that your estate will be distributed per the Sharia, per the science and the ulum that we are studying, but for you taking some action. So then the point I'm trying to make is that the objective of studying this science is to implement it, and to implement it requires some work. Now, I would say we have potentially a few evidences or dalil for this notion of estate planning as well. So the Shaykh mentioned 2 of them. He mentioned 2 hadith. The first was the hadith about not allowing 2 nights to pass without making a will. The second one he mentioned was the hadith of Sa'ad bin Abi Waqqas radiallahu anhu. So this is a very interesting hadith. Anybody know where Sa'ad bin Abi Waqqas is buried? No, where he's buried. In China. Is it?
That's what they say. They have a grave for him in China, but that's...
So maybe not then.
That's not correct.
Okay, it's not correct. So they have a grave, but it's not correct then. The point here is he passed away, correct me if I'm wrong, Sheikh, much later. Much later. Meaning, when this hadith is narrated, he didn't die shortly thereafter, but he died well after the death of the Prophet ﷺ. Well after. In other words, he's thinking affirmatively about how to distribute his wealth prior to his death. It's not something that just happens after his death, but he's making a discussion with the Prophet ﷺ about such. In other words, he's planning his estate. Right? We have in Surah Al-Kahf that Musa alayhi salam and al-Khidr are traveling, and they come to the city, and they find obviously the story with the orphan, and he explains it. وَأَمَّا الْجِدَارُ فَكَانَ لِغُلَامَيْنِ يَتِيمَيْنِ فِي الْمَدِينَةِ وَكَانَ تَحْتَهُ كَنْزٌ لَهُمَا وَكَانَ أَبُوهُمَا صَالِحًا. That kanz that was under the jidar, that wasn't something that just happened, but it was again somebody taking some sort of step to protect the wealth for the orphans that were there. So what I mean to say is that this is something that in America actually has to be done. And so what we're going to talk about today is how do we do it? And where are the conflicts that arise? So the thing about our legal system is that there are default rules about who gets what. So just like the farâ'id that the Shaykh is explaining, in whatever state you can live in, it has some default rules. So if you don't do anything, the state rules will apply. meaning the state has some sort of plan for you. Now, the beauty is that you have the ability to override those rules if you choose to do so correctly. The state will allow you to do whatever you want. So now what's really interesting is that when we talk about Sharia in this context, there's potentially two groups that will oppose this conversation. So the first you would expect are people that say, oh, this is Sharia creeping, this, that, and external people who are not wanting to see or are afraid or causing hysteria about Sharia in America. So when I do this work as an attorney, that's one of the people that say, oh, you're implementing Sharia, imposing Sharia, this and that. The other one, very interestingly, is actually from within the Muslim community. And I think this takes a point back to the theme of the lecture, the conference rather, which is that for many, many Muslims, these rules are extremely uncomfortable. People are very uncomfortable with these rules and not willing to submit. So I would say that one of the things that's very important in educating our community is educating our community about the importance, educating as imams, educating the community about the importance of these rules, educating the community about some of the wisdoms of these rules, right, as well, and ultimately that it is part of the submission. And so for instance, the Shaykh mentioned the quote of this professor. And subhanAllah, Allah subhanahu wa ta'ala says at the end of that first ayah of number 11, آباؤكم وأبناؤكم لا تدرون أيهم أقرب لكم نفعا. So in other words, if it was up to us and I have $100, should I give it to my dad or should I give it to my son? You could make good arguments for both of them. You could make an argument, my dad, I owe everything to him. You could make an argument, my son has the rest of my life in front of me. And so Allah subhanahu wa ta'ala says, إِنَّ اللَّهَ كَانَ عَلِيمًا حَكِيمًا. And Allah subhanahu wa ta'ala sets these rules, and so we want to create a system in which we can implement them. So what are we going to talk about? We're going to talk about what is estate planning. I want to use some terms. The Shaykh mentioned that terminology is so critical. And this was another theme of the conference, is that we want to be able to be conversant as imams, as community leaders, in a language that people understand. So it's important to know the Arabic terms, it's important to know the English terms as well. I often tell people I'm an estate planning attorney. They say, oh, mashallah, I'll tell my friend. Meaning what? I don't have an estate. That's the assumption, is that is for somebody else, right? And so we'll talk about, I want to pause, just as the Shaykh did as well, I want to allow questions to get through, the presentation to get through, and then I'm going to give you time, inshallah, to ask questions. Because this will lead to all kinds of questions, is this conversation. And then we're going to talk about what are the tools and practices. So in America, what framework can we use to achieve this? What are the tools that exist? So we want to understand what they are, what do they mean, how do they work? And then that way, again, we can advise our communities correctly with what we're supposed to be doing. Now, this question the Shaykh mentioned about, how do I ensure my wife has enough? How do I ensure this? What about the fact that my daughter gets half? All of the questions about the application of the farâ'id in the context of American society, we're going to talk about these, right? How do we actually apply them within this question? And then where are the challenges, where are the conflicts, where are the places that we're going to see and this last point is very important, I think, for AMJA, and I think for the organization, for the ulama, that there's a lot of unanswered questions still in this space. There's a lot of potential conflicts. There's a lot of areas that will require, inshallah, bodies like AMJA to do more research collectively and to come up with some fatwa that people will be able to apply and benefit from, inshallah. So, okay, now, estate planning generally, when somebody comes to me for estate planning, what are their objectives? And I think these apply across the board for Muslims, okay? So generally protect family, right? So everybody says, as a parent, anybody who's a parent, obviously you want to protect your children, your family, those who care for you, those who are dependent upon you, right? This has nothing to do with Islam. This is just inherently human. Obviously it has to do with Islam. I don't mean to say that, but it's driven whether you're Muslim or not, right? Another thing here in America is that with the advent of modern medicine is that most people don't actually die suddenly, statistically. There's a period perhaps of sickness, illness, incapacity. You see this within your communities. And so part of this work, obviously, ilm al-mirath and farâ'id have to do with taqsim after death. But even prior to that, what happens, right? And so we want to think about that a little bit. Now this third one is very, 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 very important. I will not, cannot overemphasize this point, which is to say there is a system in the US, in every state, that after you pass away, the court will administer the distribution of the estate. Okay? And this is known as what? Probate. Has anybody dealt with probate? Almost nobody, right? So very few. Okay, so this is really critical because this idea is that the court, a secular judge who knows nothing about Islam, is going to manage and oversee the distribution of the wealth. Now this occurs, and I will repeat this throughout the presentation, this occurs even in the presence of a will. This occurs even in the presence of a will. Okay? So just bear that in mind as we go through this. Most people, Muslim or non-Muslim, do not have any interest in being involved in a probate court. Whether you're Muslim or you're not Muslim, you generally have no benefit of going to court. Some people describe this almost as a lawsuit against yourself. You have to pay a lot of fees, lawyers make a lot of money, the court has a bunch of things. Now imagine if you have a 2-year-old, a 4-year-old, the court will administer and see this distribution for the next 16 years. Annual reports, filings, just totally inefficient process. So we want to generally try to avoid the court system. Okay? Now, this is not talking about disputes. If there's disputes, again, we're before a secular judge. So we're going to talk about the need to develop some dispute resolution mechanisms outside of the court system. Now, of course, right, the Sharia rules need to be implemented. فَرِيضَةً مِّنَ اللَّهِ. This is not like something for most Muslims, they think this is something optional. I mean this really. If you interact with people, they're not hearing enough about how this is obligatory. They think it's something, if I can do it, great, otherwise I'll just do whatever I want, right? I'm in America, we follow American rules. It's a very common response, right? American rules do not prevent you from doing what you want. You're totally allowed to follow the rules of the Sharia with some caveats that will come or some challenges that will come. But it's important to understand this point. Then family disputes and conflicts. I mean, this is universal. This is not something American. This is something in every society. The disputes about mirath exist and they're bitter. And so how do we, again, preempt them? The other thing to know is that there are certain taxes that are really important to consider. So there are so many different kinds of tax. There's income tax, there's capital gains, there's regular income, there's sales tax, there's property tax. There's one more tax after death. It's called estate tax. Okay. Estate tax is something that generally can be avoided. Okay? I have no problem saying this, right? People come to lawyers to avoid paying that tax. There are structures you can create to mitigate those tax obligations. People who don't do that kind of planning will be subject to that tax. Okay? And that tax is very dramatic in certain cases. Now, this doesn't impact the average person, but it impacts wealthy people, and it impacts wealthy people within your communities. The current estate tax is 40% of the estate above a threshold. Now, that threshold right now is very high, right? But nonetheless, some states, New Jersey, I think, for instance, has an estate tax. Certain states have, mostly in the Northeast, have state estate taxes on top of federal estate taxes. So I would argue almost that, this is a squandering of wealth. The Prophet ﷺ tells us to avoid ida'atul mal, just wasting your wealth. This is something that can be really avoided with some front-end planning, and it can benefit your family, it can benefit the community, rather than having it pass to the government. And then this notion of sadaqah jariyah and this wasiyah, as well as the concept of the hiba and the lifetime gifting. These are things to do. Now, Sheikh Hatem mentioned, let's use correct terminology. So I just dropped a few words that I want you to try and understand. So we said decedent. This was the first term on the slide. Decedent is the person who passes away, the mayyit, right? This is known as a decedent. The estate, and this is going to be an important one. We're going to come back to this again and again. We're talking about estate here, defined, if we were to define it back from the third rukn of mirath, this would be كل ما يخلفه الميت, right? Everything that the mayyit leaves behind. Everything that the decedent leaves behind would be known as his or her estate. Okay? And this is critical, this is absolutely critical, that we cannot do any of this. We can't do any of the application of ilm al-mirath without first defining the estate. So when it comes to who owns what in a household, this question is generally not discussed, not resolved, and not clear. Okay? So we're going to come to that point. An heir. This is the person who inherits by law. An heir inherits by law. A beneficiary is somebody who inherits through a will, a trust, or a designation. You have a 401k, you have a beneficiary, right? And so this person is known as a beneficiary. So the warith in Islam would be known as an Islamic heir. That the Sharia gives this person a share. So he would be an Islamic heir. Now, for instance, take a parent. Somebody has a wife and survived by a wife and 2 children and a father. So under the Sharia, the father is a warith and he gets an Islamic share. Under every state law, every state in the United States, does the father get anything? No. Okay? So this is, again, the importance of planning. You don't plan, you will absolutely ensure that that father doesn't get anything. Okay? But you can plan such that whatever you wanted to do, to distribute the shares the way you want, and your father, your mother, whoever, who would not be an heir under state law, would be able to inherit vis-a-vis a will, a trust, or some mechanism that you create. Okay? Again, terminology. We said wasiyah, usually people say I need to make a wasiyah, and they mean a will. Okay? Now sometimes people use the word living will, sometimes people use the word last will. Okay? First of all, I don't think we should use the term wasiyah to will, because I'm going to explain this next point. But what's the difference between last will and living will?
Living will is the one that continues to be modified?
No. No. Healthcare directive. A living will has to do with pulling the plug. A living will has to do with what to do end of life. It's a medical directive. It is, I am, Sheikh Hatem probably sees this all the time, I am, in the hospital, Allah protect us and grant us afiyah. What do? Do you pull the plug? Do you do this? All of that stuff is found within a living will. So utilize the correct terminology when talking to the community. That if you say to somebody, you all need to make living wills, that's not a false statement. They can make living wills, but that's not going to solve the problem of mirath. That's a different document, okay? A living will. A last will is the common document that we hear. I want to make a will, usually that's referred to as a last will. Family trust. Anybody knows what a trust is? It's like a waqf, like a waqf. Actually, the commentators, American, Western historians and I guess law professors and such have written that the trust was actually something that is adopted from Islamic civilization. It's not the same, but it's something that is similar. Now, here, this I'm going to talk about as being the potential solution for most cases in the US. That the trust is going to be better than the will. I'll say that again, the trust will generally be better than the will. Why is that? It's because the trust is an entity you create, kind of like a waqf. You put all your assets inside of it. You can put your home inside, you can put bank accounts, you can put investment accounts, you can do all these things. This waqf, if you want to call it that, but it's not exactly that. This trust becomes the owner. Now, it's a very technical difference in fiqh, because it's not a waqf. The ahkam of mirath will still apply. You are still the manager. But as far as US law is concerned and state laws are concerned, you are now known as the trustee. And you manage the wealth. And the waqf, I keep saying the waqf, the trust will never die. So therefore, we never have to go to court. The trust, it's different. The trust will not die. And so therefore, we don't need to go to court. And because we don't need to go to court, we avoid probate, and we can do everything we want according to Sharia. We can define who owns what, who gets what, and who's in charge of doing that. All the things that the Sheikh covered and will cover can be applied within the framework of the trust. It's a private administration. Whether you're Muslim or not, this is generally a better solution. Because you're Muslim and your constituents, the people in your community are Muslim, this will generally be the better solution. Okay? We talked about taxes. I mean, there can always be disputes. We can't prevent disputes. Disputes can arise. But yes, you can build a mechanism for resolving the dispute, right? It's not, I mean, it's America. Anybody can sue anybody. Like, we can't stop that, but we can try. And we can try to preempt and prevent those disputes. And when they do arise, we can make sure that there is a mechanism for resolving them from within the trust. So for instance, you could name AMJA, you could name a scholarly body, you could name whatever to resolve those disputes, and that would be binding upon the people who are now disputing. This is beautiful, right? It's a solution that is absolutely necessary, I think, in society. Because the alternate is, this is what would happen, is a secular judge would be tasked with resolving a dispute of religious law. I mean, this is nonsense, right? Like there's no situation in which that should happen, or that they even want to resolve. The secular judge doesn't have any interest in doing so. And so we're going to talk about a lot of disputes that can arise that will be better suited for a arbitration type panel rather than a court. Okay, advanced directive is, we said living will, advanced directive. I think this one's important too. Who makes decisions? So you have you have community members who don't have Muslim family, or they have, they don't have any family in the country. They should have these documents in place to ensure that they have somebody to make decisions. Otherwise, the next of kin will generally make those decisions, right? Okay, so there's a slight difference. The living will has to do with, in some states it's the same, in some states you can have two documents. One is specifically for end of life, okay, specifically about instructions about end of life. And then this one can be who's going to make those decisions for me, right? So I name Sheikh Hatem to make those decisions for me, right? I name my brother, I name so whatever, right? And so that's fine. And the living will specifically might guide those instructions. Okay, this is a whole nother conversation about Islamic bioethics and end-of-life care decisions and stuff. I'm not going to touch on those. I just want to flag for you that they're important to consider and to ensure that they are resolved. Oftentimes, you all have seen these probably, where there'll be a fight between a parent and a spouse about what to do about the sick, person who's in the hospital, and instead of dua and Quran and salawat and whatnot, they're fighting. Right? So these things can be in advance resolved, at least with some clarity. Executor is the person who is responsible for administrating the will, also known as a personal representative. Okay, just terminology I want you to familiarize yourself with. Personal representative. A trustee, slightly different, but functionally doing the same work in the context of a trust. The person who administers the trust is known as the trustee. Okay? Power of attorney is for incapacity. So in the event of incapacity, this person will be managing financial affairs. This is pre-death. So there's post-death and there's pre-death. Somebody's in the hospital from an accident or some sickness. They can't manage their affairs anymore. And this becomes more and more common and for extended periods of time. The more advanced the medicine becomes, people are lingering in neither here nor there. And so this becomes important that they have this. And then guardian is the person who is responsible for the children. This is different, potentially. Who is watching and has custody of your children is known as the guardian. Who is responsible for their financial matters? Sheikh talked about rushd. وَابْتَلُوا الْيَتَامَى حَتَّى إِذَا بَلَغُوا النِّكَاحَ وَابْتَلُوا الْيَتَامَى. Test that orphan, right? فَإِنْ آنَسْتُم مِّنْهُمْ رُشْدًا فَادْفَعُوا إِلَيْهِمْ أَمْوَالَهُم. That person doesn't, in American society, can be two different people. It can be somebody who, let's say you want your children, one person is well suited to take care of the children, but they don't know anything about finances. So maybe the person managing the money is somebody else, right? This can happen. Agent is just general term. Okay. So now, we said estate cannot be divided according to Sharia unless and until we clarify who owns what. We can't do it. It's logically impossible for me to give a fourth, a quarter, an eighth, a third, a half to anybody unless I know what it is I'm cutting up, right? So, couple things to know about property ownership in America, or a few things. Now, states differ. This presentation is general. Every state has some nuance. Most of them are kind of the same, but every state has a little bit of different things. This is why you have to build relationships with your local lawyers, right? You need to teach them, you need to benefit from them and have a good relationship so that we can, work on these things jointly. So joint tenancy with the right of survivorship is perhaps the most common form of property ownership in the United States. What does that mean? What does that mean? Spouses co-own, but what happens when one dies? The other one gets 100%. Okay. Spouses co-own is fine. The other one gets 100%. Okay. The right of survivorship is going to be the problematic part with regards to the application of mirath, right? Because the spouse is going to get 100%. Now, let's say I've got that house with the joint tenancy with right of survivorship. Now, point number 2 is essentially the same. In some states, this is called tenancy by the entirety. I'm just giving you terms so that you familiarize yourself with them. In some states, this number 2 and number 1 are the same for a married couple. I make a will. I go to a lawyer, I make a will. I get it witnessed. I get it notarized. I have everything proper. It says, according to Sharia, my wealth will be distributed as such in the following shares, and if not, everything is legal, everything is proper, everything is clear. Who gets the house? Still the spouse. This is a very important point, which is that certain things are going to trump the will. So even if you make a will, you have to understand that this right of survivorship will supersede what is written in your will. At that point, what happens? It's just an amana. When I say just an amana, it's a very heavy amana. It's not like some light thing. But there's no legally binding obligation on anybody to do anything. So if that person, if we flip it, because this is more common, that the wife passes away, the husband gets the house, the husband goes and gets remarried, the husband then goes and purchases a new house with joint tenancy with right of survivorship, the husband now passes away, who gets what? New wife gets 100%. What about his kids? What about his mom? Okay, very, very important. Even if he has this Islamic will.
What should we do now?
We're coming. I'm just making you worried a little bit, and then we're going to get to it, inshallah. So, very, very critical. Community property, who knows what that is? Who's from California, Western US? Huh? Okay. So community property is not an Islamic concept. It's a different concept. It's an interesting concept, and it's rooted in this notion that, this is the same in Arizona, where I am, which is, the idea is that whatever is earned inside of a marriage is considered 50-50. Doesn't matter who earned it. So the notion here is that your wife, we're going to start with this example and then I'm going to flip it. But you work, the husband works, and the wife does not work. She's home taking care of the children, and the husband makes $100. Community property law would say that the wife owns 50 and the husband owns 50. Community property law would say husband owns 50 and wife owns 50. Okay? Islamic law would treat is a separate property regime with financial obligations upon the husband. So people say this is fair. Look, she gave up the opportunity to work, and so therefore she should be compensated in some manner. And so for that reason, the law would give her half in the case of divorce or in the case of death. So she dies, the law would say that he makes a will or he makes a trust or whatever, and it follows Sharia. The community property law would say that his starting point is $50. Okay? So the 50 gets distributed. All he has the ability to do is 50. The 50 is already hers. Okay? Now, if the couple, if the couple agrees to this understanding, then fine, okay? But most of the time, again, this conversation hasn't necessarily happened. Now, invert it, and let's say the husband doesn't work and the wife makes $100. This happens too, right? Wife makes $100, husband doesn't do anything. I've had these cases. The husband is literally doing absolutely nothing, and he says, divorce me because I'll take half your wealth. So this woman, she's hostage to this guy. He's completely not fulfilling any religious obligation, any secular obligation, but so in that scenario, and this is really important. Why? Because people will lodge objections about the fairness of the Islamic inheritance system and say that, Western civil systems are more fair or this or that. And it's important for you to understand these points, which is not necessarily even to a liberal in Western society would the community property presumption seem fair if it is the wife who is earning. Because in Islamic law, what would that wealth be? Hers. So in this scenario, she would keep 100%. Under community property law, the law would give half of it to the husband who's useless, who doesn't do anything, right? And so even from that scenario, it's important to push back a little bit on these notions of, fairness and such. Okay, beneficiary designations. So I said retirement accounts, life insurance, these types of things. We're not going to debate life insurance and whatnot. It's just as a notion here. That is, if you have these kinds of assets, they tend to have what's known as a beneficiary option. So somebody comes to you and says, Sheikh, I've got a 401k at work. Who do I name as my beneficiary? It's important to understand what is a 401k, what is a beneficiary, how do I do it? Again, the beneficiary designation will trump the will. I'll say it again, the beneficiary designation will trump the will. You put your wife as 100%, you make your Islamic will according to the al-farâ'id shares, it doesn't matter. In fact, you make a will and you leave a wasiyah of 1/3, and you have debts, and you have funeral expenses. What happens to the 401k? 100% to spouse. None of that stuff has any legally binding impact. Okay? None of that stuff has any legally binding impact. Again, this is why I keep saying the trust will be better. Because yes, she has an amana, and she might do it, and inshallah she does, and that's fine then. Right? So Sheikh, where would you say the fariḍah lies upon the person? Is it in creating a legal instrument, or is it like a verbal wasiyah, you had a conversation, that's good enough? Like what would we say? Like how do we ensure that this is, my right was fulfilled?
You need to go all the way to ensuring that your estate will be divided according to the Sharia within the laws of the land. Whatever room the laws of the land give you, you must use all that room to ensure that you fulfill your obligation in having your estate divided according to the Sharia.
So, Jazakallah khairan. So I'll repeat that, which is to say, some people are just like, hey, I told my kids, I sat them down, I told everybody after death, do this, and they think that's good enough. Now, if they do that, then inshallah, it's fine. But there's a good chance that's not going to happen. It's a good chance somebody gets remarried. It's a good chance somebody objects, etc. So it's very important then to make sure that these things are done accordingly. Now, pension benefits. This is like a different category of asset. Okay, why? Because a pension is something that the company would give you in which you can pick a beneficiary. So there's like different options. There's I take a lump sum, or I take an amount and my spouse will get an amount for the rest of her life. Okay, so this is something I'm flagging that potentially would be treated from a Mawareeth perspective as something slightly different. Social security, pension, things like that. Yes? Yes.
Is that considered inheritance?
Okay.
We have to divide Islamically.
I'll let the Sheikh answer. The question was, so these assets that we talked about here, and this would go for this point and this point then essentially, and I think they're different. Do they have to be distributed according to the ahkam of mirath, or can you just give them to someone is the question, right? microphone.
Except for ownership that has been transferred during your life. Ownership that has been transferred during their life, or beneficiaries that have been designated during your life by the law, not by yourself. Such as if the law, for instance, gives the wife the pension. Like in certain countries, for instance, the pension is not something that you necessarily contribute to. It's just given to. So in Egypt, for instance, you die, your wife gets a pension. That is determined by the state. That has nothing to do with the mirath, the ma'ash that the wife gets or the pension that the wife gets. But the retirement plan here is actually money that is your money. So any ownership that has not been transferred in your life, that should be part of the mirath.
Jazakallah khairan. So this would fall under the definition then of, right, part of the estate of the decedent. This is what he leaves behind. Life insurance is complicated. Life insurance gets...
But it is determined by the state.
Yes, but you participate. Okay. You participate from your money, your monthly salary. Every month they deduct from the Egypt and they put on top of it. Exactly like here, you put the part of the money and the rest from the insurance company from the. So what's the difference between?
It's not voluntary, and you have no control over it, and you have no say how it gets distributed. You have no say in Egypt about the beneficiaries, who gets the ma'ash, no say. Whenever you have no say, it's out of the question. We're only talking about wherever you have control.
Okay. So, and this point is really, again, my emphasis here is to create an awareness of the complexity that exists. Okay? So we're not going to answer every question. The idea is that this is, from an Islamic perspective, an important obligation, a very sophisticated science and a rich science, and then overlay on top of that an entire another legal system. Okay? And this is what we need to be aware of when having these discussions. So yes, your question is life insurance is different. Yes, life insurance is a complicated sort of no precedent type of thing where it has $0 when you're alive, but on death you get, there's all kinds of different discussions. I'm going to table that so we finish the presentation. Partnerships. This is also really complicated. That somebody's in a partnership, there's no contract. Unfortunately, within our communities, far less people will write contracts, despite our tradition, despite debt contracts in the Quran. I mean, this ayah is giving us instructions, and yet at the same time, for Muslims, most people don't write anything. And so now we see all these conflicts. Somebody dies, and what happens to the business? Do we have to sell it? Do we have to liquidate it? What if there's no money to liquidate it? Can we just give income to the surviving spouse? How do we do all of these things? They have to be planned before. Otherwise, you're just setting up a fight. You're just purely setting up a fight. Okay, so the Sheikh covered these things, right? The funeral burial expenses, the obligations of debts, and the wasiyah, and then the farâ'id. Okay, I'm going to mention a few points that I think are worth noting in each of these categories, okay, as a practical matter. So, funeral burial issues, and this is not, again, purely mirath related, but just funeral and burial issues. So normally these are taken care of. If somebody doesn't fulfill them, doesn't have the money, alhamdulillah, almost every Muslim community at this point has some type of fund and will cover this for Muslims, right? I think that's generally the case in every community. Some communities have prepaid lots, so we're seeing more of these. I don't know if there's any positions on these things, but a lot of communities have these prepaid. Is this something you recommend? Is it just an optional thing, or like
a pool of money?
You can pre-purchase your slot in the Muslim cemetery.
Oh yeah, that's fine.
Yeah, so some people do this. I think I'll go back on this side. So we see that, and then that way at least they know they're buried in some cemetery. Wallahu alam, obviously, nobody knows where they're going to die. But this point is very important. People who have non-Muslim families and who are converts, I would highly emphasize that they create a will in which their instructions are clearly articulated. For Muslims, alhamdulillah, with Muslim families, it's maybe not that important. Like, alhamdulillah, this happens. People get buried and people generally want to follow. However far a person may be from the masjid, generally, alhamdulillah, this happens. But when people's families are not Muslim, this is absolutely critical. There can be fights. People want to cremate. I don't know if anybody is familiar with these statistics, but I was floored when I saw this. That currently, as of today, I just looked this research up, that currently about 60% of people in the US are getting cremated. And they estimate that by 2040, 20 years from now, 80% of people who die in the US will be cremated. I mean, subhanAllah, that's 80%. And the cost differential is very significant between the cremation and the burial, right? So the burial costs, I don't know what your community's range, could be anywhere from 3 to 10,000, 2,500 to 10,000 different Muslim communities I've seen.
In Canada, last year, it's 75%.
Of cremations? Yeah, so that's the thing. Actually, this is, I mean, the tracking that they're describing is incredibly, substantial percentage of people are being cremated. Now, when you leave it up to a family member with no decision, and that family member has to choose, do I spend $600 or $800, or should I spend $8,000 to bury this person? What are they going to pick? They're going to pick the cheap one, right? So this has to be written in advance as a protection for these community members who don't have anybody to decide this point. Yes.
As imams, we struggle with this a lot, especially the converted.
Mm-hmm.
Absolutely.
Absolutely. This is what I'm pointing this for. Alhamdulillah, for most Muslim families, it's not an issue. But for converts, people who have non-Muslim family members, this is very important. Yes?
Okay, I'm asking if it's like legally binding. Somebody comes to the center and then he writes papers that the center should take care of him and then
Yeah.
when he dies,
Yeah.
so somebody else from the family arrives and comes up and complains.
Yeah. Yeah, so if the will is done properly, the will govern. This is important. If legally binding, meaning you have a proper thing, you have 2 witnesses. Generally, every state requires 2 witnesses. And some states, I think one state might require 3. And most of the time, those witnesses should not be related to anybody in the document. So don't use like a Mawareeth or somebody. Use someone independent just to avoid any dispute. And that should be legally binding. You get it notarized on top of that, even better. I'm going to come to the will and all of these things, but I just want to point. One more point that's important here is the notion, or is the question of an autopsy. So the law generally, when someone dies as a suspicious death, they will do an autopsy. An autopsy is very invasive, and they will defer to religious tradition of the family and the loved ones if they say no, often. But if the person themselves wrote in advance, I don't want to have an autopsy, then that will be generally honored. When I see it suspicious, somebody dies in their sleep. Somebody healthy dies in their sleep at home. So the coroner might want to make an autopsy, and they may defer to the no if it's written in advance. So another thing that Muslim, non-Muslim, convert, non-convert, doesn't matter, should do this. Yes, quickly.
I work as a police chaplain, and I deal a lot with the court office and also the detectives. I think in certain states, if there is reasonable suspicion for a crime, the autopsy is not an option.
Absolutely.
However, my suggestion to the imams is to work with their funeral homes, to work closely, be a liaison between the funeral home and the autopsy, because at the coroner's office, to facilitate the way the autopsy is done.
Yeah.
Because sometimes they bring the cadaver to us, open in a very unpleasant condition.
Yeah.
So that's why I highly recommend for everyone to work closely with.
Agreed, 100%. I'm going to keep going, but this is a very important point. Build those relationships. And if there's a crime, you can't avoid the autopsy. It is what it is. Okay, now please, if I can just get through, I really want to, I'm going to run out of time with the same problem, and I have a lot more slides, inshallah. So, debts. Not much to say here, as the Sheikh already covered most of this stuff. Again, the Quran enjoins upon us the writing of these debts. This is, incredibly emphatic within the tradition, as we know, that somebody who has debts outstanding that are unpaid, the Prophet ﷺ is not, the idea of not praying janazah over this person until such things are resolved, that this is really important. This is another one that we see in conflict, is the mahr mu'akhar. Sheikh, is that treated generally as a debt? So this is important. Most of the time, there's a lot of mahr mu'akhars. Sometimes people come up with really ridiculous mahr mu'akhars, didn't think anything of it. Now, upon death, they realize that this was a very substantial amount that actually has to be paid. And if it's paid as a debt, it has to be paid first. And so this is important to consider. Now, debts to individuals versus institutions, I make this point to say that we live in a society, unfortunately, where people are just loaded with debt, all kinds of different debts. Right? It's like this massive weight. I don't remember what the statistics are, but the amount of debt that the average person has is unbelievable. And so it's important to note that some of these debts will be treated differently on a fiqh perspective. So for instance, some debts can be assumed by heirs. So frequently you have a house that has a mortgage on it, right, that the heirs can then potentially refinance and things like that and assume mortgages and all of that, right? Same thing can go for different large items that exist. And in some cases you can't, in which there might be some only equity portion that is distributed. Is it directly related? Yes.
That's that maybe for institutions that is riba or something. What's the Sheikh about it?
Go ahead, Sheikh.
Someone 10,000 ended up with 50,000 down there. Accumulated interest, accumulated.
But that's very quickly, that's the institutions. Every debt that will be dropped, like forgiven, you don't have to pay it off, and many of these debts are sort of,
student loans, things like that.
Yeah, things like that. So you don't have to go and figure out how to pay them off, because it's not possible. There's no mechanism actually to pay them back. Debts to individuals, the other debts, the heirs are responsible to pay the debts off from the estate, but the heirs are not. If the debts are larger than the estate, the heirs are not Islamically responsible to pay the debts off. Are they recommended? Like if your father died and he owed a lot of money, are they recommended to pay it off? Of course they are recommended, but they are not required. The debts to individuals versus the debts to Allah, if I'm Hanbali, so the debts to Allah actually compete with the debts to individuals in the madhab. They are all paid off. But most of the time, the fatwa that we give to people nowadays is that the debts to Allah, we go by the Hanafi madhab here, and we say that the debts to individuals have to be paid off. And if they want the debts to basically, Hajj that was not done and things of that nature, if they want to pay it off, then that would be recommended.
So, and if I can just maybe add to that point, in the Hanafi school, this comes from the max of the wasiyah amount, right? So that's all you can do. But this is interesting if we get to a question of zakat. And if we come to a question of zakat, and this is another separate, longer fiqh question, but if we come to a position of zakat being owed on retirement accounts, if that's a position that you arrive at, most people have very large retirement accounts that have never been paid zakat, and if they take that position, and then this would be important to consider.
What about the mortgage?
We said the mortgage can be assumed, refinanced, and things like that.
Yeah, if the husband died and there is a mortgage on the house, and there are some certain debts still he was late for $3,000, does the wife have to pay?
So a couple practical points here. One is that oftentimes, if you have a husband who is living, a breadwinner, and the wife is not, and there's a mortgage on the house, and there's not going to be enough assets to continue paying the mortgage, you're going to run just a practical problem, which is she's not going to be able to pay these things off, right? In which case, maybe you have to sell the house, and maybe you have to move into something smaller. Sometimes people are terrified by these things, but these are just practical things. If you chose to buy a house that you can't afford and you die in the interim, then this is just likely the result that would arise.
What's the muhammadan about the muhammadan if it wasn't money? For example, you promise your wife Hajj.
I don't know, Sheikh can answer, I don't know.
Are the expenses of Hajj will then need to be, yes.
Yeah, so this is a debt, and the debt has to be paid first. The mu'akhar is a debt that has to be paid first. That's the principle. And so now people play some sort of games with this question as well, which is, I guess if done properly on the outset, this question of, I want to make sure my wife has enough. Okay? So, I want to make sure my wife has enough. Before getting married, you can add a mu'akhar. It's totally fine, right? You can add a mu'akhar. That's going to come off the top. That's going to come prior to the thumun that she's going to get from the thing. That can be in a mahar agreement. That can be in a prenup, a premarital agreement, a prenuptial agreement. It can be there and it would follow and it wouldn't violate anything. Sometimes people come up with interesting things about like creating a mahar post just to give her something with some type of debt instrument. I'm going to skip that.
Please, I need to know the answer to that question.
The sheikh can answer that.
Yeah, it needs also legal advice. A husband died working $69,000.
Okay, specific one we're going to come later. 69, that's too specific, too specific.
I think the imams need to.
Yeah.
The wife and the sister who is with you now, she wants the community. We pay her the $69,000, which she's enrolled in. That's a mortgage for her. What's the legal advice? What should we do?
No, the house, this is a debt that is sort of guaranteed by the house itself. So that is not a debt that is basically a burden on her. If she does not, if she will have to pay off the rest of it, or she will have to sell the house to pay off the debt. This is not just a pure debt. You have the capital.
There's a security, which is the house.
No, you don't do that.
Yeah.
You don't do that. The community is not responsible. She has the house. She has equity on the house, and the rest is a debt. But she has equity on the house.
She can always sell. You can move. This is, I mean, so there's a few things sometimes people get really caught up with, this attachment to a house. I get it, but if you don't have the cash to buy the house in cash and you take this is a risk you take. And people should understand this, and it's common sense. So now we come to the wasiyah. This is practically, my intention is to give you the things I see as a practical matter. What this comes up in practice. So people that cannot inherit, adopted children, this is, not extremely common, but it's common, right? They're not going to inherit. Under state law, an adopted child, I don't know every state, but I'm assuming every state, an adopted child takes the place of a biological child. They're equal. It's not the case in Islamic law, right? It doesn't matter. So this wasiyah can be used here. Stepchildren, right? Somebody gets remarried, the father and stepfather wants to leave. Wasiyah, fine, great. Non-Muslim relatives, very important, right? If somebody wants to leave, this can come from the wasiyah. This point, Sheikh Hatem mentioned ability to establish endowments, awqaf, is so critical. There's a quick story. This doesn't clip. That's why I'm... فهمت. It's pro tip. Okay.
Let me help you.
If you can just turn the mic slightly lower, I'm pretty loud. I'll be good. It'll stop the interference. I know for the recording, inshallah. So John Harvard. Anybody heard of him? John Harvard. Religious immigrant to the United States. Young man dies at age 30. Leaves half of his wealth to build a university in Cambridge, Massachusetts. Making sense now?
Yeah.
Harvard University. Okay? 1638 is the year. The value of that endowment today is what? No, way more than that. Okay? Way more than that. Okay? It's above $40 billion. Okay? Meaning it started somewhere. So all of our institutions are masajid, right? The reality is, I'm going to be candid, the founders, the big donors, all of these people in the next 20 to 30 years, for the most part, are going to pass away. Okay, so build some legacy, some institutional capacity. Our institutions should be self-sustaining. I mean, the waqf is such an Islamic model, but we went ahead and built all of these institutions with no income generation, right? So this is one mechanism by which we can build awqaf, that are investments that will pay for the expenses and the imams and all of the facilities and all of these things. Really critical to do this. Okay, I'm going to skip this. I'm just going to run through the example. We have Sarah. She passes away. So she's got Ahmed, Umar, Sumayya, Khadija, and Aisha as her mother. So from the Sharia, based upon everything that we've covered, as a reminder, what does Aisha get? 1/6. What does Ahmed get? 1/4. And the bottom is لِلذَّكَرِ مِثْلُ حَظِّ الْأُنْثَيَيْنِ to the children, 2 to 1, boy to girl, and those are the shares. Now, under state law, what happens? Who gets what? Generally speaking, Ahmed will get everything. Under state law, generally speaking, Ahmed will get everything. In some cases, they'll give some portions to the children, depending upon your state. Okay? So Ahmed will take, depending, community property, this, that, all of that. Ahmed might likely get everything. So what happens in practice is that Ahmed, lonely guy, gets married, has kids. Now what? Ahmed dies. So now, not necessarily, the states are generally not that unfair. The Hajar would get a large portion, okay? Not everything, unless he puts her name on everything. If he puts her name on everything, then khalas, then it's gone, right? But, and this is not atypical. Like, I know people are laughing, but this is a very common scenario.
Children of the first wife, I don't think will take.
Very good, I'm coming to them. Okay, Hajar's death, do these kids inherit from her? No. Not at all. Umar, Sumayya, Khadija will get a portion. Who gets nothing? Aisha. Yeah, the Sheikh's listening, right? Aisha gets nothing. Her mother, she's gone from the picture. She's still alive, but she had nothing in this context, okay? So she was deprived of her rightful inheritance by virtue of not doing anything. Okay. Now, can we do? Okay. So Ahmed dies. He's married to her. Yes, Sheikh. Oh, Jazakallah khair. Barakallah feek. Perfect. Jazakallah khair. Allah barak feek. Okay, so now Ahmed dies. Hajar is his second wife. She is going to get a portion under state law. If she is named as the beneficiary, if she is a joint tenant on the house, if she is a joint owner of the bank account, she's going to get 100%. She's going to get 100%. Regardless, again, of if he went and made a will. I don't care if it's an online will. I don't care if he paid a lawyer. It's still going to end up in the same result. Okay? And I would argue that the only way to resolve that is for him to either have a trust, put everything in his name separately with nobody else, and then potentially point to the trust, or he has beneficiary designations that are according to Sharia. As a technical point, a reason I don't like naming the beneficiaries according to Sharia inside of your 401k directly is because you never know who's going to die when. Okay, so I put Thuman, Sudus, and Rubu' and whatever on my account directly, and then there's a car accident and 3 of the 4 people die. Now what? Now you're back in this unknown scenario. So most of the time things will work out, but it's possible that they will not, and so therefore, again, we would recommend the trust would supersede. Okay, Hajar dies. Of course, she's not going to give anything to her ex-husband's children from another wife. Nobody's going to do that. So her kids are going to get everything, and then these kids will get something under state law, and then Aisha will get nothing. Notice, interestingly, everybody looks the same in this scenario. All right, so what was our stop time, Sheikh? 12:40? 12:40. Okay, so 4 things, if you're advising your community, 4 documents. This is, and nobody should feel like they're immune, that this is only for the wealthy of my community. This is for everybody. Everybody should have a will. Now, I just said a will is kind of useless for a lot of people. There's still some function. It's better than nothing. It also is the place you name guardianship for children. We didn't really discuss this, but the worst scenario of all scenarios is that the state, two parents die, or a single parent dies and the other one's not alive, and who takes custody? Child Protective Services or whatever, right? Absolutely the worst scenario that you can envision. So therefore, at least in the will, you can stipulate who will be guardian of my children. Even if the mirath stuff doesn't work out, it's still, at least you have that taken care of. Now, if somebody's single and not married, the will, I think, is valuable. If somebody is single, I think the will is valuable. You can stipulate who gets what. But if somebody's married, it's not very great. Power of attorney, I said, for incapacity is important. Healthcare directive, living will / all of these things, I think is important to have. Now, a trust, I think, is more useful in most cases. I'm going to mention those cases. All of this is in the slide if you want, in the PowerPoint as well. Okay, so this is the core. You asked, how do we actually do this, right? This is the core 1 or 2 slides. Then I'm going to talk about some conflicts from a Sharia and American law perspective. Okay, guardians for children. Sheikh mentioned, pick somebody to administer. Otherwise, the court is going to appoint somebody. So, do you want some random lawyer who knows nothing about you to be the administrator? Or do you want to pick your friend, your brother, your whatever? Don't volunteer, as a piece of advice, don't volunteer to be the administrator of people's estates. So don't say, name me as the imam, I'll take care of it. Okay, you will have headaches for the rest of your life. Okay, so you can be a potential helper, but don't volunteer yourselves to be the administrators unless somebody has no relatives or something like that, in which case fine, right? But understand that they should name someone and they can consult with you and so on and so forth. And then who gets separate probate assets. So the only thing the will is going to cover is going to be something that is not have a beneficiary designation, does not have a joint tenancy with right of survivorship. Okay? So something that is not jointly owned and something that is not already have a beneficiary designation. For most married couples, that's almost nothing. Okay? For most married couples, that's almost nothing. So downside is it still goes to court. Most people think, I made my will, alhamdulillah, I'm done. No, you're still going to have to go to court. Doesn't control joint assets or assets with beneficiary designations, and tax is not really the point here, but that's important as well. So we talked about this trust. I want to emphasize why I think this is important. Okay? Because you can transfer and continue to own. So we didn't talk about hiba, but Sheikh in his answer said that if you give something away in your lifetime, then you don't have to do any of this. So if the third rukn of mirath is not present, meaning there's nothing left, we already gave everything away in your lifetime, then khalas, we don't have anything to worry about. But of course nobody does that. Nobody gives everything away. And so therefore there will always be something you still want. And you potentially want to use and benefit and control. So you can do that in a trust. You can do it in every state. Oftentimes people live in a state where there's a close border and maybe they have properties in different states. Realize that if that's the case, then you potentially have probates in 2 states, 3 states, 4 states, if you have things in different states. Even worse result. So the trust can help there as well. Avoid probate. Like I said, this is really useful. According to Sharia, obviously we said, yusikumullahu fi awladikum, the whole ayah can't be done unless that's the whole motivation. This last point is super, super important. Have a couple sit down. Look, I know this should be done with a lawyer. There's not that many lawyers that do this stuff. But even as a couple, as just counseling, as general advice, if you're giving a thing, a couple should have an understanding between them as to who owns what. Because even the amana side can't be done without this. Even as an amana, I don't know what my wife wanted or what my husband wanted because we never clarified who owned what. Now, I'm just saying, if someone's asking you questions, that one of the first things you should, I'm not telling you to go be a lawyer, I'm just saying that it's really important, somebody comes to you, let's say for premarital counseling, have some idea.
So inshallah, lunch will be served in the next room, Salon C at 12:30.
Can we go to 12:40 and I'll be done?
12:40 you'll be, it's up
Yeah.
to you.
Yeah.
But no guarantee the food will be. So you take responsibility. And then inshallah Salah will be at 1:15.
Okay.
The sisters' food will be in Sam Houston A, the same area.
counted 12. Yeah.
After this, we can check out, huh? Okay, can you give me 10 minutes so we don't? Okay, so, 20 minutes, sorry, 20 minutes. I meant 10 extra, I already took the 10. So, this question is, someone comes for premarital counseling, somebody comes inside of a marriage conversation, who owns what is something that I would advise that we have clarity over, again, so that people understand this point. Or if you're generally speaking about Mawareeth, that it's important to drill home this point again and again, that, who owns what. Make sure that that point is extremely clear. Okay, so now this 2 slides are areas of potential complication. How do we make this more complicated? How do we make this, practically speaking, what comes up as we see all the time, where I think some of these points are ones that we need further discussion of fiqh. Again, the answer or the objective that I'm trying to bring in this presentation is not to give you an answer for every one of them, but rather to get you thinking, and inshallah, that next time we'll have more development of this. Marital property, community property, spousal elective shares. What's a spousal elective share? Anybody know? Okay, so I said the state allows you to do whatever you want. The state allows you to do whatever you want so long as you make a will, you make a trust, or you put a beneficiary, so on and so forth, right? That's not 100% accurate, actually. There are certain rights that a surviving spouse is entitled to under many states' laws. So this is why it's so important, again, to do this planning together, and it's so important to decide who you marry in advance is something sound and logical, okay? Because people, again, as imams, people come in, they want to get married. No concept or consideration whether this person is going to adhere to any rules of Sharia or not, right? The person dies. They wanted to fulfill their farâ'id. They wrote a will. They met with the lawyer. They made a trust. They did everything. And it said that the wife got 1/8. And what happens? She says, I don't care, right? She says, huh? The man dies. He's survived by a wife who gets 1/8. In every state that has these rules, she's entitled to more than 1/8. Okay? By state law. And a spousal elective share means she can choose to override the will and take more than what is allocated to her by virtue of the man's will. Okay? Now, again, the only way you avoid this is both people being on the same page. If both people are not on the same page, just essentially forget about it. This is not something you can do without consent. So you made a mistake. You went down the wrong path. People come to me, oh, like my spouse is not in agreement. Well, you should have thought of that earlier, right? This is important. Spouse elective shares. If the spouse is not Muslim, she can get from, we can talk fiqh all day, but as a practical matter, she's not going to be bound by any of this stuff. She can completely throw it out and say, I don't care. Even then, I'll finish this point and I'll take the question. Even then, this trust that you make, it has to be with both spouses engaged in the marital conversation. You cannot unilaterally apply these rules. Now, for somebody's separate property in a community property jurisdiction, I can't cover every single notion. I just mean to say that a married couple has to do joint planning and that the married couple has to be on the same page, or otherwise this will not work. Okay?
Does it help if I make her sign the will also? Or?
It will not matter. The lawyer can draft some sort of waiver of like a spousal share and such, but she can sign your will and it doesn't mean anything. Correct, because it's a state law, right? So there's some caveats to this point. I just mean to say, you got to make sure this is a tarbiyah question. This is a question outside the scope of pure legal. Like you enter into a marriage contract, understand that there are implications of that marriage that will extend beyond the ramifications to your children and to your religious obligations. Yes, Sheikh. Yeah, yes, Sheikh. Prenups are, okay, this is a great question. Do I advise prenuptial agreements? Do I advise postnuptial agreements? Absolutely. Absolutely. Look, should people do prenups? It's a marriage, it's a contract before marriage. Look, it's not easy. It's not easy to do, okay? So it's not easy to convince a spouse that we're going to enter into a prenup. That might break off the whole marriage conversation. But is it sound? Is it religiously grounded? Does it memorialize the Islamic framework? Does it prevent disputes down the road? Yes. So generally the answer to that question is yes. Okay, number 2. This is very common. I own a house. It's for my sister in Egypt. Nobody has any papers. Nobody has anything. What happens when the guy dies? His sister doesn't get anything. The kids are going to take everything and khalas, and then you fight and this and that. You own something for somebody else. Make sure that you have some writing, some documentation, something. This is extremely common. You know, people are investing for their family members overseas with no understanding that their kids will not care about these things potentially. So make sure they're memorialized. In your will, in your trust, we would, as a specific distribution, say, first, my home should go to my sister. Number 1, right? It's not in this framework. It's not in duyun. It's not in anything. It's just outside. This is a specific distribution before we start, right? So very important. This is common. Okay, this question the Sheikh alluded to. Everybody asked this question. Everybody asked this question. I want to make sure that my spouse can continue to live in the home. Okay? Everybody asked this question. So this is really complicated because what happens is everybody wants the spouse to continue to live in the home and they don't want to, okay, option 1 is you give the spouse the home outright in your lifetime. It's an option. It's not a great option. Why? Because you can get divorced, now the guy's on the street. So not a great option, right? Huh? What the guy gives it to the girl, she divorces him and then he's out. Okay? So not a great option.
Even without divorcing, she can take it anytime.
Right. So not a great option. Okay. We can go 50-50. We can go 50-50. Fine. But in some states, a 50-50 is still not going to be enough. Those of you in California, where the prices are so expensive, right? So her 50% plus her 1/8 is still going to be less than the total value of the rest of the assets. The math is not possible such that she will be able to take the entire thing. Okay? Now, this gets more, maybe there's young children, maybe she's holding shares for other. This gets into a question of when does this taqsim have to happen? How long can we hold? What are the questions? More fiqh. I just mean to say this is a question that is extremely, extremely, extremely common. There are some different things here that are in this part of the analysis, but I would like to see a little bit more from the fuqaha bodies. Okay. Now.
Can we make it a waqf? Because that's the Islamic way of solving this problem.
Correct.
Is it doable? Can we make Islamically, we can make the house a waqf.
Yeah.
We can designate the wife as the first beneficiary.
Yes.
And then when she dies, we can designate the beneficiaries until the day of judgment. Basically, or we can.
But we restrict the ability to sell, do we not?
Yes, it does restrict the ability to sell, but you could designate the beneficiaries, and then after the 3rd generation or something, you could say that it would go to the community or make a waqf for.
So the only way we get outside of the mirath framework is through hiba or waqf, right? That's all. There's only options. Or it's gone. You donate it, or you gift it to somebody else, or it's in waqf. Now, if we're going to operate in waqf framework, we've got to make sure we fit under this waqf framework. How many people are comfortable with the idea of my house will eventually go to charity? I don't think too many. The other problem is, while I think that would solve part of the problem, this restriction on selling becomes problematic because now in the 2nd generation, you're going to have.
It doesn't have to go to charity. You could make it you could make your children and grandchildren the beneficiaries until the day of judgment. So you first say the first beneficiary will be the wife.
Yeah.
When the wife dies, then the beneficiaries will be the
so waqf ahli for the family for perpetuity.
It's a waqf for perpetuity until the day of judgment within your family.
So possible. My point here is I think this is something we can explore, we can talk about, we can discuss. I see benefit and I see some problems potentially with that scenario as well. I'm going to run through, they're going to not let me eat lunch. Everyone has to go. So dividing illiquid assets, okay? Again, this is so complicated, not complicated, but important that in an illiquid, I'll give you an example. There's two partners in a business. The business is worth, let's say, $2 million, okay? Partner 1 dies, okay? Partner 2 has to continue making his business, has to continue working, right? And doesn't have any liquidity to pay off the 50% ownership to the other family, right? Now, he says to her, his wife, I'll give you income for whatever, we keep running, you get income. And then in a year or two, because this partner was important in the business fails, you get zero, everybody ends up with nothing. Making sure that these things are thought out and decided. Tax considerations, okay? This is really actually important because there are structures by which the tax code advantages transfers to spouse. If I leave everything to my wife, I pay zero tax. That's the way the code works. I can have $100 million. I can leave $100 million to my wife, I pay $0 in tax. It's just the way the code works. If I apply the Islamic inheritance rules, I might end up paying $40 million in tax. Okay? Can we avoid some of that? Yes, through some, arbitrage of some sorts. Yes. Okay? There has to be some design, some intelligent thinking that goes into how do we mitigate that kind of thing. Some states, for instance, have an inheritance tax. If you leave money to your children, on top of an estate tax, they have an estate inheritance tax. If you leave money to your children, you pay a flat percentage. If you leave things to your spouse, they get zero. If the spouse then subsequently gifts to the children, there's no tax. Just got to go in a little bit, got to be a little smart, right? Okay. This one. Okay. So now the amount of people that are uncomfortable with the idea of لِلذَّكَرِ مِثْلُ حَظِّ الْأُنْثَيَيْنِ is incredibly significant. Okay? We talked about different things in the context of what people have, in the whole conference theme, right? This wasn't one of those that was addressed. But I will tell you that this is one that you can imagine many children will object to when time comes for them to inherit. And many parents, frankly, just don't want to apply. Okay? So again, this comes back to an education piece. My point here is not to give you some sort of magic solution, but rather just to bring this point here. Yes, how light people view this hukum and this obligation is incredible. Particularly if you look at the ayat that follow the ayat of Mirath in Surah An-Nisa, right? Tilka hududullah and such. So I think it's really important. Now notice I said this. I said biological sex rather than gender. Okay? Because I don't view it as that far-fetched that people will challenge on the basis of gender distributions as well. I don't see that as something that people will, it's not unforeseeable in our community, right? So I think this is really important. Let's just be real. Somebody can turn around and say, I'm a male, I want to get double. Now what do you do? Okay, you can laugh about it, but actually who's going to decide that question is what I come to at the bottom. Is he going to go, is he, she, whatever, going to go to some court and make this argument? And then who's going to decide it? Why? Again, make a mechanism so we can resolve these kinds of disputes as they may be. Okay, rushd. Okay, almost every parent says when they come in, I don't want to give things to my child, they're not mature, etc. So I think a deeper dive into the concept of rushd with some contemporary analysis is warranted here. And is rushd impacted by the amount of money that they are receiving? Is a $100,000 inheritance the same as a $1 million inheritance? Is 21, as the Sheikh alluded to, if a 21-year-old boy today, I say boy because I think generally young men mature slower in today's society by far than women. So a 21-year-old man inherits, 21-year-old boy inherits $1 million. Is that good or bad? Don't answer the question. It's just something to think about. And if not, then what are the legal restrictions by which we can limit or provide some discretion to the trustee, right? So I think this is important. Ibn Khaldun mentions that wealth lasts only for about 3 generations. It's a very fascinating analysis he has. And the Muqaddimah, he has a thing where he looks at desert Bedouin tribes and he says that the first generation works really hard. The second generation sees the previous generation working really hard, so they have instilled some sort of work ethic. The third generation has just luxury and comfort. Okay? The fourth generation squanders the wealth. And then this is a perpetual human cycle. So be cognizant of the fact of obviously we want to protect our family, we want to fulfill the ahkam, but at the same time we don't want to ruin this. This next point, another question. Who gets to define who's Muslim? Who gets to define who's Muslim? We just said Mawareeth is ikhtilaf ad-din, right? Who gets to decide? I'm talking about the murtad. We went through the conference and said some large percentage of people are not identifying as Muslim. Who gets to decide that question? That's going to be one of the messiest court cases. The court doesn't want to decide that. We have to have a body by which... Now, the other thing is, remember, everything that we're covering that Sheikh Hatem is covering is in post hoc analysis. It's an analysis after death. The problem is we have to do all of the planning pre-death. So somebody has to decide these things and identify these things prior to death. It's really complicated. Okay, hibah. Everybody comes and says, I want to make a hibah. I want to gift this to my child when I die. This is what people believe a hibah is. I will gift this to you when I die. In other words, this house, it's a hibah to my wife when I die. It's just understanding what a hibah is, understanding what needs to... Now, I want a hibah, let's say, okay, لِلذَّكَرِ مِثْلُ حَظِّ الْأُنْثَيَيْنِ, I want to make a hibah for my daughter because I'm worried about her and this and that, and the lifetime gift would be okay. The problem is she's a minor. So now what, right? Sheikh, don't want to discuss now? Or?
We can discuss later.
Okay.
You only have 3 minutes.
3 minutes.
2 minutes.
Okay. Zakat, irrevocable trust. This last point is the one I want to finish on, which is to say, in the Jewish community, there's something known as Beth Din. Anybody's heard of these things? Beth Dins, what are they? Religious courts, rabbinical religious courts. The rabbis will decide cases of Jewish law, and they're binding legal arbitration bodies that are recognized by US courts. Okay? Now, I think that we should develop these things. I think that the ulama and different lawyers can work together and that we can build these things, and there will be some pushback. I know this is being recorded, but whatever. There will be some people who will say this is, Sharia, this and that. It's totally fine. It's totally fine. Other traditions, faith groups do these things, and it's part of the development of our society to be able to have channels to resolve business disputes and inheritance disputes and family disputes without going before a secular court. Okay, I'll stop here. We're out of time. If you have questions, inshallah, we can address them in the afternoon session at the end of the day, or you can contact me, inshallah. I will do my best to answer. If I don't answer, please don't get offended. I will try, inshallah. Email is better than phone as well. Jazakumullahu khairan. Subhanakallahumma bihamdik nashhadu an la ilaha illa anta nastaghfiruka wa natubu ilaik. The PDF is on your, it's a handout. You have the full PDF already. Yes.
Honestly, the Hanbali madhab gives you flexibility because there are different reports within the Hanbali madhab. So the Hanbali madhab has more internal disagreements than the other madhab. Internal disagreements within the madhab. So without leaving the madhab, you will still be able to have some flexibility inside
the madhab. Additionally, the Hanbali madhab is the most flexible one in terms of transactions. It is the stricter in terms of ibadat, but usually the conflict with the reality is not in ibadat, it is with transactions. Particularly in the financial transactions, the Hanbali madhab is the most flexible for sure in terms of financial transactions. But having said that, I chose the Hanbali madhab without this consideration that it would work out better. No madhab, there will always be need for transfer and choosing and patching. These are three different things. Transfer is tanaqqul, choosing is ikhtiyar, patching is talfiq. Transfer, which is tanaqqul, is for the public to transfer from one madhab to one madhab, or to transfer to a position that's outside the four madhahib that has been mainstreamed by widespread acceptance. 3 divorces is 1, not 3. 3 divorces in one breath equals 1. That's, the position of the law in Egypt, in Syria, in Jordan, and so on. They took this from Imam Taymiyyah, rahimahullah. It's a position outside of the four madhahib, but it has been mainstreamed by widespread acceptance among the scholarly community. So the public will have the right to transfer. The public do not have to follow a particular madhab, and that's the correct position. Imam Ibn Abidin, rahimahullah, the greatest of the latter Hanafis, of the very late Hanafis, according to many people, said that that the stronger position among the scholars that the public do not have a particular madhab, because mixing zealotry with ignorance results in fire. The madhahib are followed by the students of knowledge and the scholar within the scholarly community, not for the ammi. So transfer, takhayyur, is for the scholar that chooses on the basis of tarjih between the different positions in the madhahib and the disagreements within the same madhab. Talfiq is when you patch two madhahib together without defying the intent of a shara or the legislator. When do you define the intent of the legislator? You do when you use the double standard, so you use the preemptive right against your neighbor, and then when the other neighbor comes in and says, I want to use it against you, you say no. You use one madhab one time and another madhab another time, this is double standard, unacceptable. Or when you say that the Malikis do not require the testimony of 2 witnesses in marriage, and the Jumhur does not require announcement, so you neither announce it nor you have 2 witnesses, that is secretive marriage, defying the intent of the legislator. That type of talfiq is unacceptable. But otherwise, whichever madhab you will choose, there will come times where you're not going to be following that madhab. Any Maliki here, for instance, who says I am Maliki, well, you shouldn't be Maliki if you're here, because according to the Maliki madhab, you should not, living outside of the Dar al-Islam is not acceptable. So everybody is using some form of flexibility, tanaqqul, or takhayyur, or this or that. So whichever madhab one chooses, the student of knowledge chooses, if they are flexible, here is the idea. We keep on jumping from, people who are not moderate, they basically dance like a pendulum from one extreme to one extreme. And societies that are not mature, that are not intellectually competent and not mature, they also dance because it is always emotional, not intellectual. But if the pendulum never stays in the middle. The middle is to avoid, to basically, for the students of knowledge to study according to one madhab without zealotry. تمذهب من غير تعصب. To take a madhab without being a zealot. So that's it. Anyway, so. Huh? سألت عن الإيش يا شيخ؟ to bring everybody in, but he went and did you give them? Okay, you shouted. Okay, so let's start. Bismillah. Alhamdulillah, salatu wassalamu ala rasulillah. Okay, so we finished the father, right? We finished the father. Just remember this, because when we come to the grandfather, it will be just like the father. So the father gets 1/6, gets 1/6 plus the rest, or the rest. Gets 1/6 if there are male offspring. Gets 1/6 plus the rest if there are inheriting female offspring. Gets the rest if there are no male or female offspring, inheriting offspring. That is the father. Now, here is the problem, our problem. Inheritance of the grandfather. Some of the, actually it's reported even from some of the predecessors. They say, لا حياه الله ولا بياه, which means whenever they talked about the Jad, the grandfather, may Allah not ennoble him or something like this. They make dua because he gave them a lot of trouble. And now if you're Hanafi, you can check out and you can say, I'll come back after 1 hour, because for Hanafis, and this is the one position in the Hanbali madhab also, but it is not the dominant position, the grandfather blocks the siblings. So you will treat him just like a father, except in 2 things. You'll treat him just like the father. If you're Hanafi, you'll treat the grandfather just like a father, except in 2 things. What are those 2 things? 1, the grandfather will be blocked by the father. Okay? Second, the grandfather will not compete with them. We will come to this particular one when we talk about a husband, a mother, and a father. A husband, a mother, and a father. What does the husband get? Half. Why? No inheriting offspring. Okay? So we're left with 1/2. What does the mother get? She is entitled to her designated share. 1/3. So 1/3 and 1/2, how much is left? 1/6. That is the rest. So that's what the father gets. So Umar radiallahu anhu said, well, the father usually gets twice the mother. How come he's going to get 1/2 of the mother here? He does not always get twice the mother. Sometimes gets the same like the mother. Sometimes gets twice the mother. Sometimes gets more or less, more than that. But anyway, here he's going to be left with 1/6 because he's a residuary heir in this example. There are no children. He's only a residuary heir, and he gets the rest. So the husband will get 1/2, the mother will get 1/3, he will be left with 1/6. So these are al-Umariyatain. Al-Umariyatain, al-Mas'alatan al-Umariyatan, is husband, mother, father. Wife, mother, father. In both cases, Umar radiallahu anhu said, no, we will give the spouse whatever it is that's theirs. The rest, we will give 1/3 of the rest. That's why I told you before, ثلث الباقي, 1/3 of the rest. We will give 1/3 of the rest, not 1/3 of the inheritance of the estate, 1/3 of the rest to the mother, and the rest will be for the father. Okay? So, but if you have the same scenario, so a husband or a wife, a mother, and a grandfather, will we say the grandfather takes the place of the father? No. We will give the grandfather the rest after the mother gets her entire third. So he will get 1/6, that's fine. He gets that 1/6. He's a grandfather anyway. He's not a father, he's a grandfather. So anyway, so these are the 2 differences according to the Hanafis between the grandfather and the father. 1, the father will block the grandfather, it's a difference. Second, the grandfather in these two Umariyatain, in these two scenarios, will not basically change the inheritance of the mother like the father did, will not reduce the inheritance of the mother. She will get her full designated share, and the grandfather just gets the rest. Now, if you're not Hanafi, there is a third difference between the grandfather and the father. According to the Jumhur, Maliki, Shafi'is, and Hanbalis, the third difference between the grandfather and the father is that the father blocks all the siblings. So the siblings, all the siblings of the deceased, the decedent, all the siblings of the decedent, the father will block them. You know, they're not going to inherit anything in the presence of a father. No brother or sister will inherit anything in the presence of a father, of the decedent. Huh? Yes. Okay? But for the grandfather, the Sahaba, the Prophet ﷺ did not leave them any instructions in this regard. And then the Sahaba Ridwanullahi alayhim, they disagreed over this issue. It's a big disagreement. Abu Bakr and Uthman and Aisha, they had one position which was later adopted by the Hanafis, that the grandfather will be treated like a father, will block all the siblings. Umar and Ali and Zayd said no. And Zayd is basically, for most of the masail, Zayd is the reference point, because the Prophet ﷺ said, وَأَفْرَادُهُمْ Zayd, or أَفْرَادُكُمْ Zayd, or the one who's basically most knowledgeable in farâ'id or in Mawareeth, in inheritance laws, is Zayd. So Zayd and Umar and Ali radiallahu anhum ajma'in, they said no. The grandfather, how is the grandfather is connected to the deceased? Through the father. He is one step from the father. The siblings are also one step from the father, connected through the deceased, through the father, with one step only between them. Therefore, the grandfather will not block the siblings. All of the trouble will come from this now. All of the difficulties that we will have in Mawareeth, the most difficult masail, will result from this. Okay, so here we will go according to the Jumhur, and if you're Hanafi and you want to basically learn this for your intellectual purposes, then that's great. And I actually would say that you should, in case you needed to solve a mas'ala according to the Jumhur for some of your constituents. Okay, the grandfather is like the father in all conditions, but there is a fourth condition that applies to him when he inherits with only the full or half paternal male and female siblings. Then he gets the greater of these two, sharing with them like one of them, or taking 1/3 of the entire estate, sharing with them like one of them, or taking the entire estate.
1/3 of the entire estate?
Huh?
Or taking 1/3?
Yes, we take 1/3. What did it say? Taking 1/3 of the entire estate. Okay, so now sharing with them like one of them, or taking 1/3 of the entire estate. These scenarios apply when, if you don't have heirs with designated shares, heirs with designated shares, these scenarios will apply. So you only have what? Grandfather and siblings. Grandfather and siblings. Now we will say grandfather, and well, let us say, this is the grandfather, okay? And who died? This one died. This one died. This one died and was not survived by a father. It doesn't matter here, with the mother, but let's say he was not survived by a mother for this particular scenario here. was not survived by a grandmother, was survived by this grandfather and these two siblings, a sister and a brother. Survived by a grandfather, a sister, and a brother. What happens here? The grandfather will be told, you're entitled to the better of two options. 1/3 of the entire estate, or you would be with them like one of them. Which one? The male, not the female, of course. He is a male. So you will be with them like another brother. You will act like another brother. Okay, the better of two options. In this case, what is better for him? No.
1/3 of the entire estate?
No. It's better for him to be like one of them. He to be a brother. Yeah. Why? Because if he will be a brother, then we will divide it by 5. He will take 2 out of 5, 2 out of 5 for the other brother, and 1 out of 5 for the sister. So 2, okay? So 2 out of 5 is better than 1/3. Okay? All right. If you add another sister, what happens? Add another sister. The third, both are the same. He will choose whichever one is. Both are the same. 1/3 is like being another brother. Okay. If you put one brother, an additional brother, then the third would be better for him. Then he will say, "Let me take the third. I'll get out of here." Okay. That's it. What if this lady is still alive? This lady is still alive. And let us also say that he was also survived by his wife. Survived by a wife and a mother. How much does the wife get? 4th, because they had no children. Okay? No children. The wife gets, these are his siblings. These are not his children. He got married to this woman. These are his siblings, his father, his mother, his grandfather, his grandmother. Okay, so he was survived by the wife, the mother, the grandfather, and these 2 siblings. This would be the next scenario here. Okay, فإن كان معهم ذو فرض أخذ فرضه ثم كان للجد الحظ من. Okay, if there are other heirs with designated shares, they will take their shares first, as usual, and then the grandfather will be entitled to the greater of sharing with the siblings, like one of them, taking 1/3 of the remaining estate after the subtraction of the designated shares, or taking 1/6 of the entire estate. Okay, so in this case, here is the entire estate, and in this case, the mother is still here. The wife is still here. She will get 1/4. That is the wife. The mother, we said we will keep her with us. How much is the mother getting now?
1/6.
Okay, why 1/6? عدد من الإخوة. لوجود العدد من الإخوة. Because multiplicity of siblings could be 1 brother and 1 sister, 2 sisters, 2 brothers. Doesn't matter their gender. Just 2 siblings. Okay, we have 2 siblings. The mother will get 1/6 for the mother. Okay, good. Now, okay, so the grandfather, we will tell him, you will get 1/6 of the entire estate before any division. The better of one of 3 options. The better of one of 3 options. 1/6 of the entire estate before the heirs with designated shares take their money. You'll compete with them. You will take with them. You will have a fard with them, designated share with them. Or you take 1/3 of the remaining, the rest after the heirs with designated shares get their shares. After the heirs with designated shares get their shares, you will get 1/3, okay? Or you will join these and take and be like one of them. Be basically a brother. Act like a brother. Okay, so what is better for him in this case? 1/4, 1/6. And when you see 6, just think 12. Okay, so this will be 2, and this will be 3 out of 12. So 3 out of 12 and 2 out of 12, right? 1/4 is 3 out of 12. 1/6, because you see 6 and 4, 12. 1/6 is, okay, 5 out of 12. We have 7 out of 12 remaining. So what is 1/6 of 12? 2. Okay. What is 1/3 of 7? 2 and a change, right? So it will be better for him to take 1/3 of the remaining. That's not always the case. But in this case, it's better for him to take 1/3 of the remaining than to take 1/6 of the entire estate. Okay, what if we say we will treat him like a brother? So we have 7 out of 12. We have 1 boy, 1 girl, one brother, 1 sister. If he joins them, how many shares of the 7 will he get?
Less than 2.5.
Okay, he will, okay, so we will have 7. He will get 2/5 of the 7. 2/5 of the 7. What is 2/5 of the 7? Just, try to remove the fractions. And if we,
We have 2.5.
Because it's not 12 anymore.
okay, that's why I'm saying try to remove the fractions. And if you try to remove the fractions here, what do? Multiply this by 5. Multiply the 7 by 5, so you will have 35. And of the 35, he will get 2 out of 5, he will get 14. And the other brother will get 14. And the sister will get 7. What is 14 and 14? 28. Plus 7, 35. Okay, you will multiply this as well. So this will be, you will multiply the original one by 5. Everything will be multiplied. Once you multiply this by 5, everything will be multiplied by 5. But we're just limiting ourselves here. Limiting ourselves here.
Is the wife still in this time? Is the wife still here?
No, this is 7 out of 12. Just take the 7 out of 12, and we're just trying to figure out if it will be better for him. It will be better for him to get 1/3 of. We said that it is not going to be better for him to get 1/6 of the entire estate, because 1/3 of the 7 shares is better than 1/6 of the entire estate. 1/6 of the entire estate is 2 out of 12. 1/3 of 7 is more than 2 out of 12. 1/3 of the 7th is what? You could even do it by percentage. But anyway,
It's better
so
for him
yeah.
to share and be one of these.
Okay, so here he will get. Okay, so let us say that.
2.63.
So 7 out of 12. Let us multiply. We said 7. We'll multiply this by 35. What is 1/3 of 35? We're still going to have a problem with fractions. But 2.3.
The other one 2.3.
Okay. Okay. Get me the one now with this being one of them. 2.6. No. 7 divided by 5. Divide 7 by 5. Multiply by 2. 2.8. Is it better then for him to be like one of them? Yes, it is better for him to be like one of them. And we can talk about tasheeh al-masail and removing the fractions, but this is not a very important chapter for us because we have calculators. And that is where we want to study fiqh traditionally, but at the same time, you also want to use the blessings that Allah had granted us. We have computers, so we don't have to basically lose our mind over the arithmetic problems. We have computers. So anyway, in this case, the grandfather will get better if he acts like one of them, if he acts like a brother. Of course, you add another brother, and then of course, it will not. He will be at a disadvantage if he shares with them. Then he will say, "Give me what?" No.
My third of
the third of the remaining. Third of the remaining, because it's more than 1/6. Third of the remaining. Okay. So he says here, okay, the full siblings in this regard are just like the paternal half siblings. If there is only one type of them, if there are more than one type, the full siblings will count. This is called the al-mu'adda. Okay, if there is more than one type, the full siblings will count the paternal half siblings against the grandfather, and then they will take their share. However, if the only full sibling is one sister, she takes half, and the paternal half siblings take the rest. And the paternal half siblings take the rest. Okay, what is he trying to say here? Al-mu'adda, what is this business of al-mu'adda? To count the siblings against the grandfather. Now, let us imagine that this man, the father of the deceased, had gotten married to another woman, and he had 2 sons with this other woman, who's not the mother of the deceased, or the decedent, who's not the mother of the decedent. So what happens here is that the grandfather here will say, okay, it is better for me to be one of you, to be like a brother. It will be better for me to be like a brother. They will tell him, keep in mind that these will not inherit in the presence of that. This guy, which is the full brother of the decedent, will block these guys who are the half-paternal brothers of the decedent. Yet, just, out of cleverness or whatever it is, they will say to the grandfather, they are entitled by the law, by Islamic law, to say to the grandfather, these are all our siblings. We counted them against you, to reduce his share. And instead of sharing with them, he goes back and says, okay, I get the 1/3 of the remaining, because they will count them against him to reduce his share. So if they count him against the grandfather, that is what's mu'adda. يَعُدُّونَهُ عَلَيْهِمْ. To count them against, or يَعُدُّونَهُمْ عَلَيْهِ. So to count them against him. So if they do, he will say, okay, I get 1/3 of the remaining. Then after they do this, they block them. They say, we just wanted to use you against our grandfather, but you don't inherit with us. You are blocked by us. So we will count them against the grandfather, and then we will block them because they are half paternal, and that's what it is. But okay, then we have al-Aqdariyya, and I don't know if it is wiser to go through 203. Okay, let's try to do this. So we have al-Aqdariyya. These are called the Dhawat al-Asma, Dhawat al-Alqab, Dhawat al-Asma. These are special problems. I don't know if it is wiser to go through the special problems or not, but let's try to go through them quickly. Okay, so this is al-Aqdariyya. It says here, if there is nothing remaining after the designated shares are distributed except 1/6, the grandfather will take it, and the siblings will be precluded. Yes, because he has a designated share. 1/6 is the least that he will walk away with. The least that he will walk away with is 1/3. Now we have other people with designated shares. Other people with designated shares. Okay? Those other people with designated shares, as well as when you add to them the 1/6, which is the grandfathers, that's it. The estate will be basically all taken. Then the siblings will not get anything. The siblings will not get anything because the least that he can get is 1/6. And the siblings will be precluded, blocked, except in al-Aqdariyya, which consists of husband, mother, sister, and grandfather. The husband gets 1/2, the mother gets 1/3, the grandfather gets 1/6, and the sister gets 1/2. Then the sister's 1/2 and the grandfather's 1/6 are divided between them over 3 shares, so the problem will be resolved without fractions by making 27 shares. None of the problems of the grandfather will be subject to awl or proportionate reduction due to shortage except this, and in no other circumstances will a sister get a designated share in the presence of a grandfather. Okay, so let me, visualization is actually, it's very hard for people, visualization, to visualize this. I have what? I have a grandfather, I have ukht zawj, okay? I have mother, I have sister, and I have husband, right? Right? Okay, so the index case, where is the index case? It has to be a woman. She has a husband. Okay, the woman, this is her father. He died before her. This is her, this is her mother. She didn't die before her. And this is her grandfather. And this is her grandmother if she didn't die. She's blocked by the mother anyway. And this is her husband. And she also has a sister. She also has a sister. What do we do now if this is the index case and she dies and she's survived by a husband, a mother, a grandfather, and a sister? Okay, so in this case, start with whom? The husband. What does the husband get? Why does he get 1/2? No children. Okay, the husband gets 1/2. Okay, and then what does the mother get? Think about it. Are there children? Is there a number of siblings? No, there's only one sibling, not 2 or more siblings. So what does the mother get? 1/3. Okay. How much do we have left? 1/6. The grandfather should be getting this 1/6 based on our principle. Our principle is if we only have 1/6, the grandfather gets it, and the children, the siblings get blocked. No. Here, actually he would benefit if the sister inherits. If the sister inherits with him. So he will say to the sister, no, I'm not going to block you. Please come on, inherit with me. And she gets, I'm not going to block you. You will get your share as if there is no inheriting children or ancestors. Okay, what is your share if there is no inheriting children or ancestors? What would be your share? 1/2. Okay, 1/2. Okay, now, so what do we have here? We have, huh? Okay, so no, but you have 6 here. Okay, let's say This would be 3 out of 6. This would be 2 out of 6. This would be 1 out of 6. This would be 3 out of 6. So what do you have? 3, 2, that is 5, 1, 6, and 3, 9. We have 9 out of 6. What do we do? Okay.
9 shares.
Okay, yeah.
9 shares.
Okay, so now we have 9. We have 9. What does the husband get? 3 out of 9. The husband will get 3 out of 9. What does the mother get? 2 out of 9. Proportionate reduction. So instead of the denominator being 6, you just made the denominator 9. But you kept all the numbers on top. Okay? So 3 out of 9. 2 out of 9. Now 5 out of 9. 5 out of 9. How many shares are left out of 9? 4. Okay. The grandfather will say to the sister, at least treat me like a brother. You know, because, you know, I'm a man. At least treat me like a brother. So now, out of the 4, he gets 2 shares, she gets 1. Right? Okay. So, in order for you to avoid fractions in this case, you will multiply by what? 3 divided by 4. Multiply by 3. 3 divided out of 4. Multiply by 3. So it will be 9 out of 12. 9 out of 12. To avoid fractions all over the place, go back and multiply everything by 3. So the husband was getting 3 out of 9, right? The husband will get 9 out of 27. The mother was getting 2 out of 9. The mother will get 6 out of 27. What is 9 and 6? 15. What do we have left? 12 out of 27. 12 out of 27. Divide 12 by 3. So the grandfather will get 8, and the sister will get 4. So the grandfather gets 8 out of 27. The sister will get 4 out of 27. What is 9 plus 6? Plus 8? 23. 9 plus 6 is 15. Plus 8 is 23. Plus 4 is 27. Okay, 27 out of 27. We are good. Now, is 8 out of 27 better for the grandfather than 1 out of 6? Well, obviously, guys. 8 out of 27 is huh? Yeah. Almost, yeah. So he benefited now from he benefited now from not blocking the sister. Otherwise, if he would not have benefited from blocking the sister, he would have blocked her and blocked even the brother and gotten his 6th. Okay? If there were no husband, the mother would have taken 1/3 and the rest would have been divided over 3 between the sister and the grandfather. This problem is called al-Kharqa. Akdariya. Why is the Akdariya called Akdariya? It's the muddying one because it muddied Zayd's principles. It muddied Zayd's principles in terms of the inheritance of the grandfather with the siblings. Disrupted, muddied, كدرت مذهب زيد. So, okay. Why is this called al-Kharqa? لكثرة اختلاف الصحابة فيها. This problem is called al-Kharqa due to the many different opinions of the companions. Now, he's telling you, in this one, we're not going to have a husband here. This person, okay. All right, so he's married. He had a father. but his mother was dead at the time of his death, and his mother, this is his mother's mother, this is his father's mother, his father's mother. Okay, so how do you, that's it. He survived by these. What do you do with this? What do you do? What does she get? She gets 1/4, fourth. Okay, no children. Okay, what does he get?
Which one?
The father. Don't make any mistakes. The rest. Why does he get the rest? Think about it. What are the scenarios for the father? You have male offspring, female offspring. So male or male and female. Female offspring only. No offspring. Male and male or male and female. You know, as long as there are male offspring, he gets only 1/6. Female offspring inheriting, he gets 1/6 plus the rest. No offspring, the rest. He's a asaba, residuary heir. Doesn't have any designated share, because anyway he will inherit a lot. Okay, so he will be the residuary heir. Okay, what about these ladies here? What about this lady and this lady? What about this lady and this lady? What do you do with them? Okay, good that we have non-Hanbalis here, traders. But okay, no. But yes, this lady here will not get anything according to the majority. Okay, and according to the majority, this lady here will not get anything. This lady will get 1/6. She is the mother's mother. The father's mother would have competed with her according to the other madhahib if this was not here. If this was not here, she would have, okay. Exactly. Therefore, this is an important thing. In all the madhahib, any time the connection between you and the deceased is alive, you are blocked. If the connection between you and the deceased is alive, you are blocked. If you are the son of the son, if you are, the son of the son, and there is a son, your father is alive, you're blocked. If you are the cousin, so Ibn al-Am, but your father, who is the uncle, the paternal uncle of the deceased, is alive, you're blocked. There is one exception. What is it? Because they have designated shares. The half-maternal siblings, they inherit with their mother. The half-maternal siblings inherit with their mother, in their mother's life. According to the Hanbalis, we have another one. The paternal grandmother will inherit in her son's life because she is a grandmother. So we will split the 1/6 between her and the maternal grandmother. But if you want to just remember the Jumhur, she's blocked by the father. Okay? All right. Hanbalis are very nice and fair. Okay. So she's getting the 6th. But let us say, I'm sorry, it just happened to be like this. Ran out of space here. Okay. This lady died before the decedent. This lady died before the decedent. This lady died before the decedent. We're going to go up one level. Okay. If you're here, if one of these ladies did not die, she will block the people on top. Okay. In the Hanbali madhab, okay, at least. Because the Shafi'is have an issue with the paternal grandmother. But let us say that in the Hanbali madhab, anyone in a generation closer will block the ones in a generation farther. But we don't have anybody in this generation anymore. How many grandmothers do we have? 1, 2, 3, 4. The generation that's higher, right? Is everybody's okay? Okay. The generation that's higher, you have 4 grandmothers. When it comes to grandmothers, how many grandmothers do you have? 2. How many great grandmothers do you have? 4. How many great great grandmothers do you have? 8. That's how it goes. Okay. So you have 1, 2, 3, 4 grandmothers. Which one of these will not inherit?
I believe.
Okay.
Second and fourth will inherit.
Huh?
Second and fourth. Number 2 from.
Okay. This one will for sure inherit. This is the last one that will inherit, by the way, in terms of the fathers and grandfathers, mothers. You know, the last thing is al-Jad, the mother of the grandfather. The mother of the great grandfather will not inherit. The mother of the great 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 grandmother, as long as you're going up through women, they will all inherit.
They will have.
Nothing will stop them from inheriting. Okay. This one will not inherit. She has a male between 2 females. She will not inherit. This one is crossed, will not inherit. Everybody else will inherit. The 3 other women will inherit. The one who has male between 2 females is not going to inherit. This is a male. She is, keep in mind, who is this? The mother of the maternal grandfather. No, the mother of the maternal grandfather will not inherit, because a male between 2 females will interrupt the chain, will disrupt the chain. A male between 2 females will disrupt the chain. Okay, so, yes, it is a rule, yes. Okay, so a grandmother inherits even if her son is alive. Why do they say this in the madhahib? They make a big deal. They say this in the matn because that is called the mufradat al-madhhab. That's a peculiar position in the madhhab. So we want to further stress it so that, you know, all the noise that you're getting does not affect your understanding of the madhhab, because every other one that you will meet will tell you what? Will tell you that the grandmother does not inherit if her son is alive. Everybody from other madhhab will tell you, no, she will not inherit. So we want to say, in our madhhab, she does inherit. A grandmother inherits even if her son is alive, but only 3 types of grandmothers inherit: the mother's mother, the father's mother, and the paternal grandfather's mother, as well as their mothers, no matter how many generations up. A grandmother does not inherit if she is connected to the deceased through a grandfather between 2 mothers. Connected to the deceased through a grandfather, this guy here, between 2 mothers. This is one mother, and this is one mother. Okay? All right. So between two mothers or through a father higher than the grandfather or through a father higher than the grandfather. I told you, the last one is the grandfather, the mother of the grandfather. The mother of the great-grandfather does not inherit, but the mother of the great-grandmother inherits as long as it's all women. Yeah. So if he is survived by his mother's two grandmothers and his father's two grandmothers, the mother of the maternal grandfather will not inherit, while the three other grandmothers will. As I told you, the mother of the maternal grandfather will not inherit. Okay, now, subsection. For the daughter is 1/2, and for two or more daughters, a total of 2/3. Okay, well, the daughter is very easy. We got the daughter, 1 daughter, 1/2, 2 daughters or more, 2/3. That's it, easy, no problem. And she gets she gets, you know, a designated share. But there are cases where the daughter does not get designated shares. When does the daughter does not get a designated share? في وجود معصب لها. So if there is the brother who will make her a residuary heir, that is تعصيب بالغير. So a brother will make her a residuary heir. The brother will tell her, no, you're not going to get your 1/2, because if you get your 1/2, what am I going to get? So you're not going to get your 1/2, but let everybody gets their thing, you know, and then the rest will be for us. Yeah, the rest will be for us. Now, in the presence of a son, no, the daughters in this case will not have any designated share. She will just be like, get the rest of the ذكر مثل حظ الأنثيين. For the male 2 shares and for the female 1 share. So, but at any rate, why is it that the son does not get, you know, oftentimes we say designated shares looks like more important than residuary heirs, right? Most of the time they are more important. They are getting first, and we're giving them big chunks. Giving 1/2 to the daughter, we're giving 2/3 to 2 daughters, and so on. Giving them big chunks, and we're putting them first. So someone would say, how come then the son, you know, does not get a share? Because he will block everyone enough to keep some for himself. Block everyone enough in what sense? Who are the 6 people that will always inherit? Let us make a drawing. The 6 people that will always inherit. Okay. Well, let us say that this is the typical sort of modern family here. Anyway, typical modern family. All those 6 people are never going to be blocked. They will always inherit. They will always inherit. Now, this guy, this is the son. Son, daughter. The index case could be this or this. The husband as an index case, the wife as an index case. This is the decedent, one of them. Okay, and this is the father, and this is the mother. These 6 people will always inherit. Now, if we have a son here, the husband will be reduced from 1/2 to 1/4. The wife, if it is a wife, will be reduced from 1/4 to 1/8. The father, in the presence of the son, will not be a residuary heir. He will be limited to 1/6. The mother will be reduced to 1/6. And this is Hajj Nuqsan. This is partial blockage. So in this case, let us say 1/4 and 1/6 and 1/6. So 1/4 and 1/3. Can you imagine more than this? No. Because even if there are grandparents, we have a father and a mother. Everybody on top of that is blocked. Anybody on the sides is blocked by the father. So everybody here, so or maybe better say blocked by the son. That's it. Those are the only ones. So 1/4 and 1/3. What is, make it out of 12. So this will be 3 out of 12. This will be 4 out of 12. So worst case scenario, if everybody is alive, we will have 7 out of 12 taken by other people, spouses and parents. What will be left for the children will be in worst case scenario, not worst case scenario, but in this scenario, 5 out of 12. Almost half will still be there for the children. Okay, so the daughters will inherit 1/2 or 2/3 if there is no معصب في نفس الدرجة, which is the brother. Okay, next is the بنات الابن, the son's daughters, take their place in their absence. But when both daughters are present, the son's daughters will be precluded unless they have a son's son of their generation or lower, however low, in which case he will make them co-residuary heirs. He will make them co-residuary heirs. What does that mean? The Banat al-Ibn, the son's daughters. Okay, let us say, here is the index case. I have a son here, daughter here. Let's say this is the index case. Daughter, son. The son has a daughter. The son has a daughter. The son died before his father. The son died before his father. Okay, what does she get? This is the wife of the index case, the decedent. 1/4, well, 1/8 because there are children, right? So she gets 1/8. Okay. What does she get?
Who's this?
The daughter of the deceased, the daughter of the decedent, the index case.
I think
Well, slam dunk, half. She doesn't have a brother. Her brother had died before. Okay, half. Okay. Now, what does she get?
The rest.
No.
Why? Oh, I'm sorry.
There is no woman that inherits by ta'asib whatsoever except the emancipator and the mother whose child was denied or who does not have a father. Okay, so she will get 1/6 تكملة الثلثين. She will get, because they said daughters have 2/3. I have one daughter in this generation. If she was alone, she would have gotten 1/2. If she had another daughter, they would have both gotten 2/3. Since she does not have another daughter in her level, but there is a daughter in a lower level, don't reduce her to 1/3, but at least to give this one the rest of the 2/3, 1/6. Give this one the rest of the 2/3. Now, if you have 2 here, they will both get 1/6. They will divide it. 3, they will get 1/6. They will divide it. Now,
but if they have son,
if you have with them a son, what do you do? Okay, he will make them all residuary heirs, and they will inherit the rest, and it will be 2 shares for the male, 1 share for the female. 2 shares for the male. الولد المبارك, now he's not always Mubarak, في ولد الشؤم أيضا. But anyway, it depends on the scenario. It depends on the scenario. Sometimes he says الولد المبارك, it's the blessed, it is the blessed son. You have al-Akh al-Mubarak also. So sometimes these different scenarios, but we want to get the whole framework first, and if we have time, we will do a little bit, we'll do some tricky ones at the end if we have time, but let's get the framework first. Yeah. Huh?
If two sisters instead of one daughter, two daughters instead of one. Yes.
If there is another daughter here, okay. So, this is the index case, and the index case left 2 daughters and 1 son, and the son died. The 2 daughters would have inherited 2/3. Okay? 2/3. Now, if you have daughters here, they don't have a designated share. Daughters of sons have a designated share only if there is 1 daughter that gets 1/2 and they get the 1/6. Or if there is no one in this level at all, no one in this level, we will treat her like a daughter. She gets 1/2 and 2 of them or more will get 2/3. But in the presence of anyone here, in the presence of a son, she doesn't get anything. In the presence of a daughter, 1 daughter, the 1 daughter is sulbiyya, which is the immediate daughter, will get 1/2. And the rest, which are meant to be for daughters, the rest of the 2/3 will be picked up by the daughters of the son.
If they are two, بنات الابن المتوفى مش هياخدوا شيء.
They are the ones that are taken. We're talking about the daughters of the deceased son.
2 daughters now.
2 daughters. Okay.
Two daughters.
You have 2 daughters of the decedent.
Yes.
The 2 daughters of the decedents will get 2/3. The daughters of the sons will not get anything unless they have a brother who can make them residuary heirs. Residuary heirs. The rest, if there is rest.
There is rest. But هل في شيء بنتكلم في حاجة اسمها الوصية الواجبة هنا ولا الوصية الواجبة مش داخلة هنا؟
الوصية الواجبة للحفيد يعني أو للحفيدة.
اللي هم اللي أبوهم مات قبل جدهم.
Actually, there will be arrest. There will be arrest. There should be arrest. If they are, okay, وصية الواجبة. وصية الواجبة is a Shi'i. I was just going back to this scenario. If you don't have anyone in this generation and these will inherit, there will always be arrest for them. If you don't have anyone in here and these will inherit, no one here, and these will inherit, there will always be arrest for them.
They will take the risk for sure.
Yes, there will, of course, because
مع الوجود حتى مش بس 2 daughters مع وجود الأعمام.
Okay, if you have a son or a son's son or a son's son's son, we're not thinking about uncles, we're not thinking about anyone else. He's blocking everybody.
I know that, but I'm talking about he died and left sons and daughters.
Okay.
One of his sons died and left children before he died before his father.
Okay, that's this case here. Okay.
Okay.
So
what about الوصية الواجبة هنا?
What was وصية واجبة? Oh.
If there is another son alive
For the grandkids, orphans.
for the grandkids.
وصية ثلث.
دكتور
الوصية الواجبة مولانا.
I know الوصية الواجبة, but in this case, why do you need الوصية الواجبة if they will inherit?
دول مش هياخدوا. لا أنا بتكلم على لو هم لو الولد مش موجود أو حتى لو الولد موجود وفيه ليه أعمام مع العمات.
Oh, okay. You're talking about a different scenario where not just this. You're talking about another son that is alive. Yeah, another son that is alive. According to the 4 madhahib, this other son that is alive will block all this generation. Al-wasiyya al-wajibah it's an Egyptian thing, that is taken from the Shi'i madhab, from al-Imamiyya, from the 12ites. where, according to the 12 ayats, they say that 12 ayats would say that this man should have been kind enough to include his grandchildren in his will. Since he was not kind enough, we will include them for him. Well, it's part of the Egyptian law. So if it is the law of the land, you just the law of the land. If you're in Egypt, it's the law of the land. You will go by it. It is not. It's not so. It's.
بالنسبه لموقفنا احنا هنا لو تعرضنا لمساله مثل هذه هل ناتي بالوصيه الوجبه ولا نقول لا ده ليس لهم؟
Okay, yeah, well, that's a very valid question. Should we use the wasaya al-wajiba here? I mean, if you're not Egyptian, you may have not heard of the wasaya al-wajiba. By the way, if you're not Egyptian or Shi'i, you may have not heard of the wasaya al-wajiba. But anyway, you're American here. Like, this is America here. Yeah. Okay. Al-wasaya al-wajiba, I personally believe al-wasaya al-wajiba is very kind. It is, you know, it's always the sensitivities, sectarian sensitivities, of course, because whenever something is, you know, is adopted by the Shia, it is ignored by the Sunnah for centuries, and then you pick it up from the Shia, it creates sensitivities and creates as if they were right and we were wrong, and people will start to foam at the mouth, and it becomes a problem. I'm just not going to get there. I'm just, you know, let's just move on. Wasaya al-wajiba, I told you about the background. Let me not make up my mind on the spot here.
One of the sisters died before the deceased index case, and they have grandchildren. So instead of making the box, make that circle.
What?
So you see that box right there?
Yes.
If we made that a circle.
Uh-huh.
Is there a wasaya al-wajiba for those kids?
No, those kids are the sons of the daughter. They don't inherit. No, this is not. No. Okay, but as I said, these are Dhawoo al-arham that you should include in your wasiyah. Allah gave you the 1/3 so that you would be tactful and you would be kind and you would know, like, these are your daughter's daughters. So give them something. That is why you have 1/3 for maneuvering. You have plenty of room. Okay. Next is, if it is one daughter and there are sons, daughters, then the one daughter gets 1/2 and the daughters of the sons, one or more, get 1/6 to complete the 2/3. And that is true, except if there is a male offspring of their generation who will make them, we get done with this. Okay, now, the sisters. The full sisters are like the daughters concerning their designated shares. What is the difference between the full sisters and the daughters? And let's finish this. The paternal half-sisters with the full sisters are like the sons' daughters with the daughters. However, no one except their brother can make them co-residuary heirs. Okay. The sisters عصبة بالغير or عصبة مع الغير. Co-residuary heirs will include both. عصبة بالغير and عصبة مع الغير. Okay, so now the sisters. When do the sisters get a designated share? The last verse in Surah An-Nisa. يستفتونك قل الله يفتيكم في الكلام امرؤ هلك ليس له ولد وله أخت فلها نصف ما ترك ويورثها إن لم يكن لها ولد. وإن كانوا إخوة الرجال فلذكر مثل حظ الأنثيين يبين لكم لهم أن تضل والله بكل شيء عليم. So, okay, this is a man that is called kalala. The kalala did not leave behind farâ'id, did not leave behind any inheriting offspring or male ancestors. The male ancestors, male ancestors. So if he did not leave behind any, inheriting offspring or male ancestors, the sister gets half. Two sisters get 2/3, just like the daughters. Two sisters get 2/3, just like the daughters. Except that if there are daughters, the sisters are not getting anything. Why? Because the sisters only get when no inheriting offspring. Okay? So then he says the full sisters are like the daughters concerning their designated shares, and the paternal half-sisters with the full sisters are like the sons' daughters with the daughters. However, no one except their brother can make them co-residuary heirs. What does he mean by that? He means by that, if this is the index case, and you have a sister here, this is his sister, this is his wife. This is his sister and this is his wife. He died. What do you give him? He died. What do you give his? Oh, he died. You shouldn't give him anything. What do you give his wife?
Does he have children or no?
No, that's the picture here. The picture is in front of you. 1/4. What do you give the sister? Who said the remaining? Okay. No. She has a designated share. The verse says لها النصف. She is entitled to nisf, 1/2. So 1/2. Now, if he doesn't have anyone else, what's going to happen after that?
The state or
redistribution. But in redistribution, the spouses don't get anything. We said if there's only a spouse, AMJA said, took Uthman's position, if there's only one spouse, and instead of the money going to the state, they will redistribute to the spouse. Here, this is not the scenario that we're talking about, that I'm just talking about. Here, okay, but we're saying that this is it. There is none. That's it. This is it. She will get the half what? Fardan, and the rest raddan. Like redistribution. Not ta'siban, raddan. One of them is the emancipator, the other one is mula'ana. التي لعنها زوجها. Okay. Yes. Now, yes. Which one is the vision? باقي ردا. We said
بيقول هل باقي ردا هذا إجماع عليه للأخت؟
لا هذا what is it that is بالإجماع؟ إن يرد الباقي على الأخت دون الزوجة يعني that the زوجة is excluded. طبعا الرد بالإجماع. الرد على الورثة بالإجماع. إذا كان ورثة ترد عليهم. لكن مسألة to not redistribute to the spouses is the position of the four madhahib, but not the position of Uthman and so on. Yes. يرد عليها لأنه ما فيش عندنا عصبات. في حالة عدم وجود العصبات في حالة in the absence of residuary heirs. We don't have residuary heirs. There is nobody, no one. So in this case, you will do the designated shares, and then the residuary heirs, and then al-Rad, and then the emancipator, and then the state. Wait a second. We are doing the designated shares, then we are doing the residuary heirs, and then we are doing the Rad, which is redistribution, and then we are doing Dhawoo al-Arham if you are Hanbali or Hanafi. Then we're doing the emancipator, then we're doing the state. Yes. But, yes. So, why is the sister getting? The why is a class in apologetics that we can do afterwards. Well, let's try to do the law, and then we can do apologetics on some other day. But this is what they said. This is the. Yes, because they will give it because they will favor kinship over marriage in Rad, in redistribution. They favor kinship over marriage. Because الميراث أسباب الميراث النسب والنكاح والولاء. The three causes of mirath are kinship, marriage, and allegiance through emancipation. They come in this order. And when there is redistribution, they favor kinship over marriage. Yes, let's try to finish, Ya Mashaykh. Yes. Huh? Because we're going to be short.
I'm going to take it, but yes.
We're going to take what? What is it?
Because she said the sister is going to take it. I can take it.
You can take it. Oh. No, the sister will take what, 3/4. This is the sister. This is the wife.
Okay, so 3/4 to.
Yes. Okay. So next is if you have now this sister is getting 1/2. Okay. What if this man, after this woman died, went and married another woman? And they together had one daughter. How is this daughter related to the index case, the decedent? Half paternal sister. Okay. How are you going to resolve this now? What does the wife get? What does the wife get? Still 1/4, no children. Okay. What does the full sister get? Half. Okay. What does the half paternal sister get? 1/6. Exactly. Like we said, the daughters are entitled to 2/3. And if you have a daughter and a son's daughter, if you have 2 daughters, they will share the 2/3. Divided between them. But if you have a daughter and a son's daughter, you will give the daughter her 1/2, and the 6th will be given to the son's daughter. Here we are saying sisters are entitled to 2/3. If I have 2 full sisters, they will take what? 2/3. If I have 2 half paternal sisters, what will they take? 2/3. Because I said I have 2 half paternal sisters, but there are no full sisters. And مع غياب الفول sisters, غياب البrothers, غياب al-farâ'id al-mawâreeth, which is inheriting children in absence of the male male ancestors, you know. So in the absence of the full sisters, these half-paternal sisters will get 2/3. Okay. Now I have one full sister and one half-paternal sister. The one full sister will take, yes, you are our sister and everything, but I am a full sister. I am related to the decedent through his father and the mother. I take my 1/2, and I will give you the rest of the 2/3 that belong to sisters. That's it. That's what we're saying. Now, he says here, وَلَا يُعَصِّبُهُنَّ إِلَّا أَخُوهُنَّ. However, no one except their brother can make them co-residuary heirs. What is he trying to say here? What is he trying to say here? This is the index case here. Let us say that I have a brother here as well. So there is a brother and sister, a wife and half-paternal sister. Half-paternal sister, brother and sister.
The wife is going to still have the fourth.
The wife is going to have the fourth.
Yes.
This will make them, these two will become co-residuary heirs. They will take the rest, and he will take 2 shares and gives her, he will take 2 shares and give her 1. Okay? Yeah, okay. But why is he saying no one except their brother can make them co-residuary heirs? Because in the previous example, when we were talking about this man who died and his son died before him, and he has daughters, and he has his son left behind a daughter. What is she going to get? If we had one daughter here, she would have gotten 1/6, right? But we have 2 daughters. They got the 2/3. Does she get a designated share? No, because the 2 daughters got the shares of the daughters. What does she get? She doesn't have designated share. She just waits behind. Can she make ta'asib by herself? No, women make ta'asib except the emancipator and the woman whose child was denied, or by the father, or who had a fatherless child, I guess. So anyway, so here in this case, she will wait until, if there is a brother that can come with her, he will make her asaba. Make her asaba means what? They will both inherit. They will both inherit as co-residuary heirs. They will get the rest. Let us say there is no wife here, and these are 2/3. Even if there is wife, they will still get something. But let's say there are 2/3, and this here, this is her brother. They will get the remaining 1/3. Okay, he will take 2 shares, and she will take 2 shares. Okay, let us say that this one also died. However, before he died, he got married, and he had a boy and a girl. A boy and a girl. What happens in this case? She doesn't have a brother to make her a co-residuary heir. Let us say there is an uncle somewhere lurking here, like some uncle here, waiting.
Define uncle. Which uncle?
Huh?
Which uncle?
A paternal uncle. Or there is no uncle. If there is no uncle, will we give this man the rest? Okay. He will. He's a lower generation than her. He will make her a asaba, and they will both inherit as co-residuary heirs. He will get 2 shares and give her what? Half.
But how about his sister? She get any?
What sister?
His sister, that grandson, that little kid.
Okay, wait a second here. We want to go back one step here. What's that? No. Her nephew will make her a co-residuary heir.
Okay, his sister. How about his sister now?
His sister. Yes. Yes. She will be included as a asaba. The issue here is this lady will ask her nephew to give her ta'asib only to make her a co-residuary heir only when? Only when? If it is in her interest. Because sometimes it is not in her interest. Sometimes if you have one daughter only and she gets 1/6, let's say she has one daughter and she's getting 1/6. Huh? The one daughter, no, she is getting 1/6 after the one daughter got with her 1/2, she's getting 1/6. Okay, and let us say that the husband, let's say that this is the woman who died, the husband will get 1/4, right? Because there is one child. So this is getting 1/2, this is getting 1/4. Let us say that there was a mother who's getting 1/6. A mother of the index case is getting 1/6. 1/6, 1/4, 1/2.
1 by 24.
Okay, 1/6, 1/4, 1/2. She will compete with them and get 1/6. The rest of the 2/3, she will get 1/6. The rest of the 2/3. If she has a brother, they will not get anything. And this would be, al-walad al-shu'm. Or the sort of the.
She will get 1 by 24. That's what they told.
Okay, no, but you notice this. She has a designated share if she does not have someone to make her a co-residuary heir. She is entitled to a designated share. When is she entitled to a designated share of 1/6? If there is only one daughter. She will be entitled to 1/6 as a designated share. If the designated shares consume the entire inheritance, she will still get, because she is entitled to a designated share. People who are entitled to a designated share, when the inheritance is consumed, is not enough for the designated share. What happens? We squeeze them all in and everybody gets their share proportionately reduced. Yeah, proportionately reduced, but everybody will get their share. Everybody will come in. We're not going to keep anyone out. Who are the people who are kept out? The residuary heirs. That's why they're called the residuary heirs. They get the rest. If the estate is consumed by the designated shares, the residuary heirs will stay out. People who have designated shares, like Bint al-Ibn, the daughter of the son, in the presence of one daughter only, she will get 1/6 as a designated share, fard. So she will get. Now, if she has a brother, in this case, what is going to happen in this case if she has a brother?
He's the residuary heir now.
Huh? He will make them both residuary heirs, and both of them will not inherit. Why? Because 1/4, 1/6, 1/2 is more than 1.0. There is nothing left. Yes, because he will make her a residuary heir, and in this case, there is nothing left. That is an ibn al-Shu'm. You know, yeah. So this is not, so, but what if this is not present? The one that is present is here, is that one below. She will tell him, I only use you when I need you. If I don't need you, I don't use you. What does that mean? If you will help me inherit, I will use you to make me a residuary heir. If I will inherit without you, but if you make me residuary heir, I don't inherit, I will not use you. You will be the residuary heir if there is anything left for you.
When she uses them still twice, he takes twice her.
Yes. Yes.
Better than nothing.
Yes, better than nothing. Yes. But then I just wanted to say here that he's saying, except their brother, however, no one except their brother can make them co-residuary heirs, because in this example, this is the decedent, his sister, her brother made her a co-residuary heir. What if this brother was not present, died before the index case died, and was survived by a boy and a girl? Can this boy make his aunt, who is the sister of the decedent, residuary heirs? No. No. Beyond the siblings, the boy does not make the girl residuary heir. So let us say, why did we have on this side sisters, and we had on this side the full brother's sons, and we did not have on this side the full brother's daughters? If you have the nephews and nieces, that nephew, the full brother's sons, will not inherit with his sister 2-to-1. He will inherit everything. He will not make her a co-residuary heir. And anything farther than the siblings, فَمَا بَقِيَ فَلِأَوْلَى رَجُلٍ ذَكَرٍ. Whatever is left is going to be for the closest male relative. So beyond the siblings, what do I mean by beyond the siblings? Because the children are before the siblings. The children, they make each other asabat. And the children of the children also. So like a son's daughter and a son's son. It is like a son and a daughter. The full brother and the full sister. The full brother will be with his sister asaba, residuary heirs. Now, the full brother's son and the full brother's daughter, it will stop here. The full brother's son will not make his sister residuary heirs, inheriting the rest 2-to-1. He will inherit the rest by himself. Okay, so that is the point that he's trying to make here. However, no one except their brother can make them co-residuary heirs. Okay. والأخوات مع البنات عصبة لهن ما فضل وليست معهن فريضة مسماة. Okay, sisters are co-residuary heirs in the presence of daughters. They get the remainder of the estate, but they would not have a designated share, and that is due to Ibn Mas'ud's statement concerning a daughter, a son's daughter, and a sister. I will judge according to the judgment of the Messenger of Allah, sallallahu alaihi wasallam. For the daughter is 1/2, for the son's daughter is 1/6, and the rest is for the sister. So, someone died and left behind, someone died and left behind, this is the person who died. He was married to this lady. They had a daughter and they had a son who died before his father, and this son had a daughter, and this guy also had no, they are not here. He had a sister. So who's with us? The sister, the daughter, the son's daughter. They presented this to Abu Musa al-Ash'ari, and then they presented it to Abdullah ibn Mas'ud. Abdullah ibn Mas'ud said that he will judge as like the Messenger of Allah judged. Sheikh Raouf left and he had the clock. All right. I have to put this here. Okay, so what does the daughter get? 1/2. Okay. The sister inherits in the absence of daughters 1/2. But here I have a daughter. What does the son's daughter get? 1/6. Right? Son's daughter with a daughter. She gets 1/6. You guys got tired, right? Looks like you're going to sleep on me, all of you. Okay. 1/6. And then, what does the sister get in this case? The rest. They say that this is asaba ma al-ghayr. This is asaba ma al-ghayr. She's a residuary heir with the daughters. The daughters, not by the daughters, because the daughters, they don't make ta'asib, because women don't make ta'asib. It is asaba, except in the case that I told you. Asaba ma al-ghayr. Ma al-ghayr. Sisters, like the mashayikh, this is not the wording of the hadith, but the mashayikh usually say, they extract from the hadith of Abdullah ibn Mas'ud, اجعلوا الأخوات مع البنات عصبات. اجعلوا الأخوات مع البنات عصبات. Make the sisters asabat with the daughters. Make the sisters asabat with the daughters. Whenever you see a daughter and a sister, they will block from ta'asib. They will block from ta'asib anyone farther than her full brother. Farther than her full brother means what? Of course, if there is a descendant of the deceased, of course, if there is a descendant of the deceased, where do I put this? Anyway, I'm getting drowsy myself. Of course, if there is a male descendant of the deceased, the male descendants of the deceased takes everything. Takes everything. The male ancestor of the deceased is going to be the asaba asaba before the siblings. The siblings. Even if it is a grandfather, we went through the scenarios of the grandfather. But they will not inherit by ta'asib. They will not either their grandfather blocks them according to the Hanafis, or we will go through those scenarios where the grandfather will have the edge, the advantage over them, and he gets to decide whether he will be one of them or he will get the better of, 1/6 of the entire thing or 1/3 of the rest after the designated shares. But if there is if there is an uncle, this scenario, son's daughter, sister, and this is okay. And there is here a paternal uncle, full paternal uncle. What does he get? He is the closest male relative, right? Isn't he the closest male relative? So he gets the rest, right? No, he doesn't. Why? Because if you have daughters, the sisters, whether they are full or half paternal sisters, if you have full, she blocks the half paternal. But if the half, and she blocks the half here. But in case where she gets 1/2, the half paternal will get 1/6 and so on. But if you have daughters, the sisters will act like brothers, not sisters. The sisters will act like, so the full sister will act like a full brother. Does the uncle inherit when you have a full brother? No. So the full sister will act like a full brother. She will block the uncle. She will block the uncle. And that is what the mashayikh say, that is how the mashayikh extracted from the hadith of Abdullah ibn Mas'ud, اجعلوا الأخوات مع البنات عصبات, make the sisters residuary heirs in the presence of daughters. Make the sisters residuary heirs in the presence of daughters. Okay. The maternal half siblings. The maternal half siblings, they are pretty interesting because they break many rules. They inherit in the presence of their mother, and their mother is the connection between them and the decedent. They still inherit in the presence of their mother. So what do they inherit? 1/6. 1/6 designated share. 1/6 designated share. And if they are 2 or more, what do they inherit? 1/3. Yes. We're studying law. We're not studying tafsir and apologetics and we're studying law. This is let's get this, we're not going to get done. The maternal, half maternal sisters and brothers, each one of them, regardless of their gender. And why is it regardless of their gender? So they inherit in the presence of their mother. Who's the connection? That violates the principle. Because we have an explicit statement, we have to bow. So why is it that they inherit each one of them like the other? We have an explicit statement, we bow. 1/6 for the brother, 1/6 for the sister. If you want to rationalize, you could say each one of them got the same because they are connected to the deceased through a woman in the first place. So you don't give the brother, in this case, twice the sister. Now, yep.
Can we say that in their absence, the mother would have gotten a third? However, in their presence, right, her third became a sixth. Right? Became half. And that is the part that they basically share equally.
No. In their presence, the mother came down from one, not in their presence, in the presence of multiplicity of them. But if you have one maternal sibling and a mother, the one maternal sibling will get 1/6 and the mother will get 1/3. If you have multiple maternal siblings, the mother will get 1/6 and they will get 1/3. So together they got more than the 1/3. Without them, the mother got 1/3. With them, they got 1/3 plus 1/6. Yeah. So what's 1/3 plus 1/6? That's half, isn't it? Okay. So we come to blockage. Blockage is an important one. Okay. Who are the asabat here and who are the ones with designated shares? Let us name them. Is the father asaba or not?
He's a designated share.
An asaba also. Okay, so this can be asaba. Grandfather can be asaba, can be asaba. Son can be asaba, can be asaba. Grandson can be asaba, can be asaba. Full brother can be asaba, yes. Half paternal brother, yes. Half maternal brother, no. Cannot be asaba. Not a residuary heir. Full brother's sons, yes. Half paternal brother's sons, yes. What is this? Father's full brother, yes. Father's half paternal brother, yes. Sons of full brothers of the father, yes. Sons of half paternal brothers of the father, yes. Husband, no. Cannot be asaba, not a residuary heir. He gets his designated share and that's it. Emancipator, yes. Out of the 15 male heirs who inherit, 13 of them can be asabat. 13 of them are asabat, residuary heirs. They get the rest. The exception is the half maternal brothers and the husband. Now, out of the 10 females, who are the asabat? Number 10, the emancipator. And in very special scenarios, the mother of the fatherless child is asaba according to a position in the madhab, or her residuary heirs will be asaba according to the other position. The mother of the fatherless child. Child without father. Okay. So now, those 13 males that are asabat, if they are together, if they are present, who blocks whom? Who takes the rest? Who is the closest to the deceased? We said before, there is jiha, there is qurb, there is quwwa. So here is the index case, here is the deceased, this is his wife, his father, his mother, his grandfather, his grandmother, and here his uncle, his uncle's son, and okay, so he has also a brother and a brother's son and a brother's and another brother, another brother and son and son, and he has a boy and a girl, and his boy has a boy and a girl, and he has another boy who has a boy and a boy and a girl, and okay. Everybody is alive here, and this guy died. Okay. Who's going to be the residuary heir? Are we going to have a residuary heir in this case? Yes. Of course. Yes. Because in the presence of a son, the designated shares cannot be more than 7 out of 12. We're going to end up having a residuary heir. Let us say, in the presence of the son, you know, no one is, that's it, where it's just blocking everything. You know, the son is blocking everything around them. Everything, really? Okay, except the ones that can never be blocked, Hajj b'hirman, except the ones that can never be entirely, completely blocked. They can be partially blocked. So the son will block the father, reduce him to what? 1/6. The son will block the mother to 1/6, reduce her to 1/6. The wife will bring her from 1/4 to 1/8. And then he will take the rest with his sisters, 2 to 1. Now, the son, we don't have the son. We don't have the sons. They died before the deceased. Okay. Okay. Then, should we go to the father? Son. Why is that? Because we look in the same direction first before we look for proximity. So the direction of the sons is stronger than the direction of the ancestors. Okay, let us say there are no sons. Where do we go? So al-jihad, jiha, direction. So al-jihad, the children. After the children, the ancestors. If you are Hanafi, the ancestors include the grandfathers, and they are not a jiha by their own. They are part of the ancestors. If you are not Hanafi, then the jududa and al-ukhuwa is another layer. So after the fathers, children, no matter how many generations down, first, that's the first jiha, first direction. Then the father by himself in a category. Then the jududa wal-ukhuwa, grandfathers and siblings are in a category by themselves, and we went all through their scenarios. Then, after that, should we go to the uncle, or where do we go from here? No, the children of the siblings, no matter how many generations down. No matter how many generations down. So, here, this is the decedent, his brother. Before I go up to his uncle, I don't have anyone here. I will go to his siblings. Died before him. I go down. I go to their offspring. Okay, so I have this one and this one, this one and this one. These four, who inherits? These two will block these two, right? Will block them. That is al-qurb, proximity. And even if they are not coming through them, meaning what? Let us say this one died, okay? And, or you could leave this here. But anyway, this guy here will be blocked by his uncle, who's not his father, because he is closer to the decedent. That is proximity. Okay? Now, so I am done with abna al-ikhwa. That is then I go up here to al-a'mam. I am already done with the father and the grandfather. These are done before the brothers. Done before the brothers according to the Hanafi without ifs or buts. The grandfather is done still before the brothers, stronger than the brothers, but they will compete with him, as we said, according to the Jumhur. But after this, and the siblings and the children of the siblings, and we're talking about males here because this is ta'seeb, males, children of males. Males, children of males. No male that is connected to the deceased through a female will be asaba. It's males coming from males related from the paternal kin of the deceased. Okay, so went to the uncles, and after the uncles, I go to the children of the uncles.
What if the female was herself a hasab, residuary?
How could the female be asab, a residuary heir?
Two cases.
Huh?
Emancipator, for example.
Emancipator is not going to come with here. We're not talking about her until there is no relatives. Yeah. So, but at any rate, and you keep on going up this way. Do you see? So you don't have someone here. You go to this grandfather and their descendant, this grandfather and their descendant, and so on. Keep going this way. What if in one layer here, you have this am who is a full brother of the father. But this man got married to this woman who's not the mother of this man, and then they had another one. This is half paternal am. Who inherits, the full or the half paternal? They are at the same level. They are brothers. But one is the full brother of the decedent, and one is the half paternal brother of the decedent. Who inherits? The full brother inherits. Why? Because the third consideration is al-quwwa, strength. And if you have two people in the same direction, at the same level, from the same generation, one of them is full brother, one of them is half brother, the full brother is stronger than the half brother. Okay? All right. So let us then quickly read what he says here in the chapter of al-Haj. And the chapter of al-Haj is one of the most important chapters. He says the full brother will be blocked by three: the son, the son's son, and the father. The son, the son's sons, and the father will all block the brother. The paternal half brother will be blocked by those three above and the full brother, because that is weaker than him. The maternal half brother will be blocked by four: the son or daughter, the son's child, the father, and the grandfather. This is the kalala that we talked about. No inheriting offspring, and no male ancestors. And when we talk about the maternal half brother, where no male ancestors, period. The grandfather, by agreement, blocks the half maternal brothers. So the grandfather, by agreement, blocks them. Okay, every grandfather is blocked by the father, and every grandfather is blocked by a grandfather who is closer to the deceased than he is. Anyway, just to remember these, we're looking at direction first, we're going to the children, and their children, and their children, no matter how many generations down. Then we're going to the ancestors, up, up, up. If you're Hanafi, you keep on going up. and you don't consider anything else. If you are not Hanafi, then you will go up to the father, and then when it comes to the grandfather, he will share with the siblings. He will keep room for the siblings, even though he's still stronger than them. And then after the ancestors, you will go to the siblings and go down all the way. And then you will go to the uncles and go down all the way. And then you will go to the higher uncles, the sort of the distant uncles. And then you go down all the way and keep on going up and down this way, as we said. Okay. And, we already, yes, chapter on Dasabat, yes.
The first determination for the direction, where first I should go.
What's that?
When I'm looking for the direction, what is the side I will have to look first? The father side going up or going down?
You will have to go down first. You will have to, the children first. The descendants first. And then the ancestors. Yeah. Yes. بقالي ساعتين وثلث. I didn't take a break. What time is it now? If you guys are not tired, I will carry on, just in the interest of time.
So because we have most of the people have flights.
Okay, and then we will have the Q&A. Allah يبارك فيك. Allah, no, of course. Jazakallah khair. Jazakallah khair. Allah يبارك فيك. Okay, so al-Dasabat, the chapter on residuary heirs. So they are every male relative who is connected to the deceased directly or through another male relative, except the husband, the female emancipator, and her residuary heirs. Except the husband, what does he mean by this? He is giving you a principle that every male who is connected to the deceased through a male will be a Asaba. But the husband is male, and he's connected to the deceased directly, but he's not a Asaba. The emancipator on the opposite side is a female and a Asaba. The husband is male, connected directly to the deceased, not Asaba. The emancipator is a female. If the emancipator was a female, she is going to be Asaba, even though she is a female. These are the two exceptions from the rule. Okay, and then I'm not going to read this because I went through it already. So this is basically the order of the Dasabat, and we did go through it already. At the end here, if he says, and if they are at the same distance, at the end here he says, this means the children of a more distant male ancestor will not inherit in the presence of the children of a closer male ancestor, and the most deserving of the children of the male ancestor are those closest to that male ancestor. And if they are at the same distance, then precedence will be given to the one connected through both of his parents, the full brother versus the half paternal brother. There are four who will make their sisters co-residuary heirs. So they will have all their inheritance divided between them. For the male, twice as much as the female. They are the son, the son's son, the full brother, and the paternal half-brother. Once you leave the siblings, you go to the children of the siblings, the nephew and the niece. The nephew, that is paternal, that's connected through males to the deceased, will get it all and not share with his sister. Everybody above him will share with his sisters. He will not share with his sisters. Okay. Then any other males will take the remainder, such as the brother's sons, the paternal uncles, and the sons of the paternal uncles. When the residuary heir is alone, he or she inherits the entire estate. If there is an heir with a designated share along with the residuary heir, that designated share will be given to him or her first, with the remainder of the residuary for the residuary heir. This is because the Messenger of Allah ﷺ said, "Give the designated shares to those who are entitled to them, and what remains goes to the nearest male heir." Okay, so this is al-Himariyya. Al-Himariyya, for us, it is, you know, it depends on where you're coming from. But anyway, al-Himariyya is, quickly, I'll just go over the Himariyya, or al-Hajariyya, or al-Yammiyya. It's all different names for the same scenario. Husband, this is a wife, this is a husband, this is the case. And in Himariyya, he says, a husband, a mother, and maternal half siblings, and full siblings. A husband, a mother, and maternal half siblings, and full siblings. So, okay, this lady is the index case. She died. This is her husband. Of course, her father is not in the picture. Her father died. This is her mother. These are her siblings, her full siblings from her mother and father. But her mother went on to marry another man, and they had a couple here of kids, a boy and a girl. Okay. So who's going to help us here? What does he get? Husband, huh? He gets half. Her mother, are there children? No. Is there a multiplicity of siblings? Yes. So she gets 1/6. Okay. Now I have maternal siblings and full siblings. Maternal siblings and full siblings. The maternal siblings have designated shares or not? Yes. The full siblings inherit how? As residuary heirs. The rest. The maternal siblings in this case inherited what? When you have a number of maternal siblings, what do they inherit? 1/3. Each one of them is 1/6, but together, 2 or more, 1/3. So the husband got 1/2, the maternal siblings got 1/3, the mother got 1/6. What is that? 1.0, 100% of the estate. The full siblings get what? Hanbalis get nothing. Well, so what can we do for you? Nothing is left. Okay. The Shafi'is and the Malikis. I'm blanking out on the Hanafis at this point, but are you like the Hanbalis? I'm not quite sure. Are you Hanafi or what are you? So anyway, but Hanbalis are what the Hanbalis say here is they don't get anything. The Shafi'is will say, no, we will give them something. Umar radiallahu anhu, it was presented to him one time, and he said, they don't get anything. Nothing is left for you. That's it. These are the designated shares and the shares in the Quran. Nothing is left for you. And then the second time, Zayd went to him, and he said, you know, these half-maternal siblings are getting 1/3, and the full siblings are not getting anything. Consider their father to be a donkey, or consider their father to be a stone that was thrown in the ocean. Hajar alqaynahu fil yam or something. That's why it's called the Yammiyya or Hajariyya or Himariyya. Consider their father to be, you know, non-existent. You know, why are they being punished for being full siblings? You know, they are connected to the deceased, They are connected to the deceased. So this is Ali, and this is Fatma, and this is Hussein. These are connected to the deceased through Ali and Fatma. These are connected to the deceased through Fatma only. Okay, consider Ali non-existent, as if he's not there, and make them inherit with the maternal, with the maternal siblings. And in this case, so this will not apply to the half paternal. The half paternal will not get anything. Of course, this applies to the full siblings. And this will not apply to them if they don't have boys, if they have only girls. Why? Because she'll get a designated share. Okay, so it will apply to, then when we make them inherit, all inherit the 1/3. The full siblings would inherit 2-to-1 male to female? No. Because they are coming here into a pool in which the male inherits like the female. So everybody will get 1 share. Now this is the himariyya, and it, whether you do this or that, it's different in different madhahib, and there are other madhahib that are zawat al-alqab. Let's not do this. But look at the Sharia scare. If the child is intersex, the determination of their sex is based on the urinary orifice. If the urine comes out from the shaft, it is a male, and if it comes out from between the labia, it is a female. If it comes out from the middle, it is an ambiguous intersex person who will be entitled to half of the inheritance of a male and half of the inheritance of a female. Likewise are the cases concerning their blood money or compensation for injuries and others. They may never marry. Okay, so this is the true hermaphrodite. It's intersex. The medical name that's becoming somewhat politically incorrect is true hermaphrodite. How many true hermaphrodites we have? It's like 1 in 25 million births. 1 in 25 million births is the true hermaphrodite, which means what? Truly ambiguous. You can't, it's just truly ambiguous. You can't say that this is male or female. 1 in 25 million births. No, the mushkil, the problematic one, because if we figure it out, he will go, if we figure out based on external genitalia. They had no access to chromosomal 6, to gonadal 6, they only had access to genital 6. We have chromosomal 6, we have gonadal 6, we have genital 6, and certainly nowadays, we also consider the behavioral 6 in ambiguous cases. We consider the behavior in ambiguous cases, only in ambiguous cases. But nowadays there is the behavioral and the chosen and so on. But anyway. Oh yeah. Yeah, Allah musta'an. But anyway, so nowadays we can figure out without looking, we can do a better assessment to figure out what the sex of the child is. Now, if it's completely ambiguous, then it is the khuntha mushkil, completely ambiguous gender here. What do we do? Okay, you make 2 scenarios. So you have the whole family, and you have this person. Imagine that this person was a boy, and make an entire scenario based on this person being a boy. Huh? And make another scenario, complete scenario, based on this person being a female. Then take the average for each one of the inheritors. Give each one of the inheritors the average of the 2 scenarios. Easy?
But some of them will not.
Easy. This scenario plus this scenario, divide by 2, will give you the average for each one of them, the average of the 2 scenarios. Now, Bab Dhawi al-Arham, and I want to tell you just a couple of things in Bab Dhawi al-Arham. Bab Dhawi, yes. You guys are. No, these guys that come from California and have obsession about these issues. No, let us move on. No. So, no. So, Dhawi al-Arham, because I need to finish. Dhawi al-Arham. Okay, how are Dhawi al-Arham going to inherit? How are Dhawi al-Arham going to inherit? Who is going to give them anything? Hanafis and Hanbalis. Malikis and Shafi'is, they're not there. There is nothing called Dhawi al-Arham, okay? And actually it's much easier for them. And the Hanbalis are, in any problematic thing, they are still sitting with us here. Like, the Malikis and the Hanafis could have checked out earlier with the grandfather. The Malikis and Shafi'is can check out here earlier. But the Hanbalis are always there. No, but no. This is a different issue. كتب عليكم إذا حضر أحدكم الموت أن ترك خيرا وصية الوالدين والأقربين بالمعروف. This is whatever Zuhri used, or was it Zuhri who said that al-wasiyya is wajibah? Because it was the naskh applied to the people who got parts of the inheritance, but it does not apply to everything else. But this is وَأُولُو الْأَرْحَامِ بَعْضُهُمْ أَوْلَى بَعْضٍ فِي كِتَابِ اللَّهِ. We Hanafis and Hanbalis are using this ayah. وَأُولُو الْأَرْحَامِ بَعْضُهُمْ أَوْلَى بَعْضٍ فِي كِتَابِ اللَّهِ. They're saying that they are awla from the generality of the believers. We give it to them before we give it to the generality of the believers. Okay, so yeah. So وَهُمْ كُلُّ قَرَابَةٍ لَيْسَ بِعَصَبٍ وَلَا ذِي فَرْضٍ. They are the rest of the relatives who are not residuary heirs and are not entitled to a designated share. Your maternal aunt, your beautiful maternal aunt who's like your mother. The Prophet ﷺ said she is a mother. So she gets, she gets something here. And if she does not, you want to include her in your will if she is needy. Okay, they don't inherit in the presence of any residuary heir or any heir entitled to designated shares except one of the spouses. Then they would inherit the remainder without blockage, hajb, or correction for shortage, hawl. So they will only inherit if there is nobody else, if there is no one, because the other inheritors, whether they are inheritors by designated shares or inheritors by ta'asib, which is residuary inheritors. The residuary inheritors, they get the rest. So no one is getting anything because they just get the rest. But the inheritors with designated shares, what do we do with them? Rad, redistribution. We give them back whatever is left that no one would be, if in the absence of residuary heirs. In the absence of residuary heirs, we go back and look at the inheritors with designated shares and give them the rest raddan, redistribution. Except to the two spouses, we don't give them back the rest. Uthman gave them back the rest. AMJA said we'll give them back the rest, and instead of the money going to the government, we'll go to the spouse, is better. Anyway, they did not give them back the rest, but they gave Dhawi al-Arham, the rest. But they would not allow Dhawi al-Arham in this case to compete with the husband. The husband gets his half. That's it. If Dhawi al-Arham, after you promote each one of them, how do Dhawi al-Arham inherit? Because we are not going to go into the details, because it's very rare that you would find someone who does not have anybody whatsoever, and you will go to Dhawi al-Arham. But how do Dhawi al-Arham, in a nutshell, inherit? You will promote each one of them until you get to the connection between them and the deceased that would have inherited had they been alive. So the maternal aunt, the mother, okay? The son's daughter, the son. Take her up, until you get to a point.
The daughter, the son's daughter, the daughter or the son?
The son's daughter.
So the daughter.
The daughter's daughter, the daughter.
Yeah.
The daughter's daughter will be like the daughter.
And the son's daughter would be the son?
Like her father.
But she's already waritha, she's not son's daughter.
Son's daughter does not inherit by ta'sib. Except if she has a son, if she has a brother, then he will make her to atasib.
But is she Dhawoo al-Arham?
Yes. Yes. So here he will say, they inherit by upward substitution, meaning that each one of them will be put in place of the relative through whom he or she is connected to the deceased. Here are some examples: the children of the daughters, of the son's daughters, and of the sisters will take the place of their mothers. The daughters of the brothers and of the paternal uncles and the sons of the maternal half-brothers will take the place of their fathers. This is Banat al-Ikhwa. This the son. Oh, you were saying the son's daughters? I'm sorry, I'm talking about the brother's daughters. Sorry, the son's daughters are not with us here. Was I talking about the son's daughters? Okay, why did you guys stop me? Anyway, you were saying the son's daughter. The son's daughters are not with us. I'm talking about the brother's daughters will get the share of the brother. Okay. The paternal aunts and the father's maternal half-brothers will take the place of the father. The maternal uncles, maternal aunts, and maternal grandfather will take the place of the mother, and so on. If there are two or more from the same direction, jiha, then the most deserving is the one closest to the heir, who would have inherited had he or she been alive. These are all just different scenarios. If they are equally close, then divide the money among those through whom they are connected to the deceased, and grant their shares to those related to the deceased through them, given equal shares to the males and females from the same direction. Therefore, if he was survived by a daughter's son, a daughter's son, a daughter of another daughter, and a son and daughter of a third daughter, you will divide the estate among the three daughters and then give their shares to their respective children. For the son of the first daughter is 1/3, and for the daughter of the second daughter is 1/3, and for both the son and daughter of the third daughter is 1/3, to be divided equally between them. Okay, had 3 daughters. This is the index case, has 3 daughters. Each daughter had, this daughter had a daughter, this daughter had a daughter, this daughter had a son and a daughter. The 3 daughters died before their father died. Now, all you have here is children of daughters. Are these inheritors? No, they're Dhawoo al-Arham. They're not. Okay, so upgrade them, so we'll 1/3, 1/3, 1/3. It will be divided between them. This 1/3 will go to this, this 1/3 will go to this, this 1/3 will go to this, equally divided. Yes. All right. We will skip this one. We've gone over this. Usul al-Masail, the chapter on, this is basically arithmetic issues, arithmetic redistribution. We did talk about this redistribution. Arithmetic. Keep this in mind. There is no awl or rad redistribution in any case where a residuary heir inherits. Of course. Because if there is awl, there is nothing left for him to inherit. You know, and if he is there, there is no radd because he takes the rest. The radd of what? He took the rest. Okay, chapter on eliminating fractions. You know, arithmetic, believe me, all of this, arithmetic issues, we have computation techniques that are great. Chapter on miscellaneous issues. Okay, his wife is pregnant and they died. His wife is pregnant and they died. What do? You presume that what is in his wife's womb is 2 sons or 2 daughters, whichever is greater. Could the 2 daughters have more than the 2 sons? Of course. The 2 daughters can have 2/3 in the absence of a brother. The 2 sons will have the rest. The rest can sometimes be 5 out of 12, right? So the 2 daughters can inherit more. Okay, and then you will give the people their shares until, you know, if she had only 1, not 2, then whatever remains will be redistributed. Malik said, no, we will wait until she gives birth. But we give them everything, but we keep for what if she gave birth to 3 and not 2? We will go back and take from the heirs, you know, the haqq of the fetuses.
But 3 daughters is going to be the same.
3 daughters are going to be the same, yes. Chapter on miscellaneous issues. Still on, we are here. So, yes?
We now determine through ultrasound whether the person is having twins or
California again. But it is not definitive.
No, but if you're using calculators, you might as well use ultrasound.
It's not definitive. Ultrasound is not definitive. How many times did it make a mistake?
Yeah, but Shaykhna, it's relevant. It's most likely it's relevant over 95 or 98% or something.
No, but it's still not definitive.
Of course, but nothing in fiqh or in.
No, but this is, you know. No, this is actually not nadir la ibra bin nadir. Rare things are not considered, but this is not rare. You know, ask the people who had ultrasound. You know, not oftentimes, but it is not rare that the ultrasound gets it wrong.
It is not rare.
Okay, all right. If you will go inside and basically do amniocentesis and get like some tissue and do a chromosomal analysis and figure out the gender definitively, maybe. But ultrasound per se, particularly in the presence of twins, do you know how ultrasound figures the gender? They look for something between your legs.
No, I'm not talking about the gender. I'm talking about the number of at least it's very minimal.
Oh, but the gender is also a problem.
I know, but at least to eliminate part of the problem, which is 2 instead of 2, the mistakes between having 2 or 1, it's very rare to happen.
Okay.
Maybe the gender.
Oh, I see that. Okay. All right. You know, the ultrasound will be accurate in terms of the number of fetuses. Yes, it is accurate. But the gender is the issue. The gender, particularly when you have twins, the gender, very difficult to look for. Yes, okay. All right, you know, the number of fetuses can be solved. Okay, I agree. Sorry to California and Canada also. This just like worse. Michigan. All right, but anyway. Oh, and kind of okay. Let's just finish those. Finish. Let's finish. Chapter on miscellaneous issues. If one of the heirs is missing and his or her whereabouts are unknown, you give each one of them, each of the other heirs their certain share. The rest will be reserved until his condition is known, unless he goes missing in perilous circumstances, in which case you wait 4 years and then his share will be divided. AMJA has some ijtihadat in these issues because review them. We're not waiting for 4 years or 90 years. Nowadays, the world has become different in communication. But anyway, it's a little different nowadays. If you divorce your wife in your terminal illness, and you've divorced your wife in terminal illness, and then you die, if you die in her iddah, he will tell you she will inherit. Actually, in the Hanbali madhab, she will inherit even after 25 years, as long as she does not get married. You know, like she will inherit not in her iddah. Her iddah ended, but she has not gotten married. She will inherit because we're suspecting that you divorced her in your terminal illness to deprive her of inheritance.
I think we have 3 opinions in this case.
Yes. So the last issue here is if the heirs acknowledge the presence of a co-heir who agrees with them or is young and of unknown lineage, then his or her attribution to the deceased or the decedent and inheritance from the deceased is established. If only some of the heirs admit this, the attribution to the deceased is not established. Still, he or she will get the difference between 1, the received share of inheritance of those heirs who admitted, and 2, the presumptive share had he or she been eligible for inheritance. He died, and he left 2 boys, and he was actually married to another woman, but no one knew, and he had from another woman this boy, for instance, from another woman. This son acknowledged that this is our brother. This son did not acknowledge that this is our brother. If both of them acknowledge that this is our brother, what happens? Each one gets 1/3. If one acknowledged that this is our brother and the other did not acknowledge that this is our brother, this one who did not acknowledge will get 1/2. This one will get half, but he will take 1/3 and 1/6 will go to this one. So since you are saying that this is your brother, then you are entitled to 1/3. We will give you the 1/3. This man did not acknowledge the brotherhood of this brother, so we will just give him the 1/2.
The 1/3 is his right if
had this actually been a brother. Yes, had this actually been. So this is remarkable because we're actually done. Subhanakallah wa hamdik, shalla la nastaghfiruka wa atubu ilayk.